Good morning, ladies and gentlemen, and welcome to the Engaging Asia Arbitration Summit. We present to you a distinguished panel of speakers and chairs for the various sessions across 1.5 days of this summit. We feel extremely privileged to extend a heartfelt welcome to the Honorable Justice Jagdish S. Kehar, the Chief Justice of India. Our keynote speaker needs little introduction in the world of international arbitration, and she has made her way to India specially for this summit. We take great pride in presenting Sheikha Haya Rashid Al Khalifa of Bahrain. We are honored to host Ms. Ruchi Ghansham, who has assumed charge as the new Secretary West earlier this week. Among her wide-ranging responsibilities include all legal and treaty matters, much of which deals with arbitration. We further welcome one of India's most articulate personalities, Mr. Salman Khurshid, who has held among several distinguished positions the position of the Cabinet Minister of Law and Justice, and who has earlier taught at the Trinity College, Oxford. He has also been the country's External Affairs Minister. Perfect. Okay.
Okay, so just do you want to just say that you like the lab and we'll have a short copy to proceed after that.
All right. We also have amongst us the very accomplished Mr. Abhinav Bhushan, Director, South Asia International Court of Arbitration. Last but not the least is Mr. Moses Manoharan, a veteran journalist with Reuters and who heads Global Dialogue Review, a foreign policy journal. He's the organizer of the conference, assisted by the ICC International Court of Arbitration, Paris. We thank all of you present here, reputed lawyers, young people new to law, diplomats, foreign guests, and the media for attending this conference and contributing to the advancement of arbitration in India. I request the Honorable Chief Justice and So I now invite the distinguished guests to please inaugurate the session by lighting the lamp. Just a little change in plans. So we'll have a short coffee break before we resume with the addresses. Our Chief Justice would be delighted to talk to the all the lawyers present here. So kindly make your way to the coffee area.
लास्ट बार उठा लेना ठीक है क्योंकि देर में उसको टाइम नहीं मिलेगा सेशन के बाद टाइम नहीं मिलेगा ऐसे कैटेगरी वाला बेसिकली उसको एक ही साथ चलेगा
No, you're wearing heels, so.
Welcome back. So we will begin by presenting our honorable guests with a little token of respect and affection. Honorable Justice Jagdish S. Kehar. Welcome, sir. Her Highness Sheikha Haya Rashid Al Khalifa of Bahrain. Welcome, ma'am. Ms. Ruchi Ghansham, Secretary West, Ministry of External Affairs. Mr. Salman Khurshid. Mr. Abhinav Bhushan, Director, ICC International Court of Arbitration. And Mr. Moses Manoharan, Chairman, Global Dialogue Review. I now request the Honorable Chief Justice to address the gathering.
Normally, an inaugural address for me would be at the end of the whole deliberations, but it's interesting to start. Her Highness Sheikha Hayat Rashid Al Khalifa, former President of the United Nations General Assembly and Bahrain's representative to the International Court of Arbitration, Paris, and former Vice Chairperson, International Bar Association. Mr. Salman Khurshid, Senior Advocate and former Minister for Law and Justice. Ms. Ruchi Ghansham, Secretary, Ministry of External Affairs. Mr. Vinu Rajamani, Additional Secretary, Ministry of External Affairs. Mr. Moses Manoharan, Chairman, Global Dialogue Review. Other dignitaries present, senior advocates, ladies and gentlemen. I am delighted to be part of this significant dialogue, very aptly titled, Engaging Asian Arbitration Summit. I congratulate the organizers for choosing to organize this conference in India. International commercial arbitration is an extraordinary saga of private human courage to carry on the business of life regardless of political boundaries and distances, starting from the merchants of Venice and Amsterdam. This risk-taking courage has endeavored to seek profit from the international exchange of goods and services, undeterred by politics of nations, even while seeking the support of national governments whenever necessary. In the globalized world today, while distance has been annihilated, the other two constraints of national boundaries and national politics continue. These two constraints, however, would not stop the evolution of the law merchant, which led to the creation of the new international trade law based on private commercial contracts and public international law. The post-World War II Renaissance created a consensus amongst world powers for peace and security. This realization emerged from the appalling human cost of going to war for territorial and market domination. International commercial arbitration, basically pushed by the private corporate entrepreneur, is a logical growth of the desire to trade in a world without national boundaries. A reflection of this is the Iran-US Claims Tribunal, before which private companies were permitted to claim compensation for commercial losses suffered during the Iranian Revolution. This was followed by the Iraqi War Claims Commission. Political governments were therefore brought face to face through arbitration in the politics of countries involving commercial consequences. This may be seen as a high watermark of international commercial arbitration being used for settling commercial grievances in political controversies between national governments. International commercial arbitration has increasingly become a preferred choice of businessmen for dispute resolution for the simple reason that it offers expertise, efficiency, and effectiveness at a much lower cost than litigation. Businessmen who realize the value of per unit of time and money dislike being caught in the forensic abilities of lawyers or lawyer-turned-judges, especially where neither have good commercial understanding of mercantile customs and practices in which their adjudicatory dispute is to be settled. What the businessman desires is a free but fair but expeditious process, a binding and enforceable determination of the dispute, and an appeal only in the rarest of rare cases, in only such matters which shock the conscience of commerce. What shocks the conscience of commerce may not be treated as a fair solution by a national government. This is important because ultimately the recognition of arbitration proceedings and the enforcement of arbitral verdicts has to be done within the boundaries of a nation. And therefore, under the concerned national laws coupled with international law to the extent it is recognized by the concerned nation. Emerging economies like those of India and of other Asian countries have an arbitration legislation which provide a special place for international arbitrations with structures for ad hoc and institutional arbitration. It is in this context that India and Asia seek a place in the arbitration market for dispute resolution. The future of international commercial arbitration for engagement in Asia must commence from India for the following reasons. Before I venture to express the reasons, may I venture to add a personal note. I believe that no individual Asian country is capable or has the wherewithal to shift to itself the culture of established international arbitrations in the UK, in the USA, and in Europe. We just don't have it. This, as of now, according to me, is an absolute impossibility. We must therefore make a collective choice. If we want to bring arbitration to Asia, we must make a collective choice to move to the best possible location in Asia. And then to expand arbitration centers into smaller nations with smaller trading activity. My suggestion is India, and my reasons are the following. Firstly, India is deeply entrenched in a culture of peace that transcends religion. This is especially so for its businessmen who are known for their being accustomed to secular values as they trade in an environment of diversity. This background brings in flexibility and adaptability naturally. Secondly, India's potential for international commercial arbitration is set to increase on an exponential scale. This is so because more and more foreign investment is coming into India. This inflow will necessarily generate an increase in international commercial arbitration. The total foreign direct investments which India received in the financial year 2015-16 were to the tune of United States dollars 5.9 billion. Thirdly, with its vast natural resources, India's demand for technology and services in infrastructure, manufacturing, and transport to exploit available resources in its interest of development is on a constant increase. India's 7% plus annual growth and the Union government's determined national program of Make in India are most likely to make India a favored equity market and a preferred venue for foreign portfolio investment among the emerging markets. Fourthly, Indian companies today view the world as a product and geographic market, and therefore, Indian firms have been investing in foreign countries through mergers and acquisitions. In 2015, India invested in the UK increased by 65%. Fifthly, in my view, the Indian legal structure has adapted and assimilated some of the world's best practices of governance, which commits India to promotion of world-class legal and judicial structures. India is also possessed of a talented pool of lawyers and paralegals operating the arbitration law at least since the Arbitration Act of 1940, along with the Arbitration Protocol and Convention Act 1937 and the Foreign Awards Recognition and Enforcement Act 1961. As India's inward and outward investments mature, ripen and expand, disputes are bound to arise with the outside world, including with Asia. These disputes are best settled in India, given the stability of India's legal structure and machinery derived from the common law and extending to the Arbitration Act, which has been drawn on the lines of the unilateral model law of arbitration. Furthermore, besides ad hoc arbitration, India also offers the alternative of institutional arbitration. the International Center for Alternative Disputes Resolution, an autonomous organization under the aegis of the Union Ministry of Law and Justice, has its headquarters in New Delhi and regional centers at Hyderabad and Bangalore. On October 8, 2016, the Mumbai Center for International Arbitration has been established in a joint initiative between the Government of Maharashtra and domestic and international businesses and legal communities. Mumbai Center arbitration rules are in the global arbitration class. They provide for an expedited procedure for arbitration proceedings which work towards finalization of arbitral proceedings within 6 months. An emergency arbitrator services are available which assures the appointment of an arbitrator within 1 business day and which works towards the grant of interim relief or emergency relief within 14 days. There is also in place a consolidated mechanism to merge 2 or more arbitration proceedings when required for faster settlement of claims. And finally, the Government of India has furthered the international commercial arbitration process in India by amending the Arbitration and Conciliation Act 1996 in 2015. The law has 34 grounds for cross-checking the impartiality of an arbitrator. It provides specific timelines for completion of arbitration proceedings. The amendment makes it mandatory for the arbitral tribunal to declare its award within a period of 12 months from the date the arbitral tribunal enters upon the reference. There is now a provision for a fast-track procedure. The amended law provides that arbitral proceedings must commence within 90 days after a party receives interim relief from a court before the constitution of the arbitral tribunal. To top all this, the oversight provided by the Supreme Court of India, I ventured to bring in some judgments of the Supreme Court because I was of the view that my colleague Justice Chandrachud would be doing that, but since he's suddenly had to leave Delhi, so I thought I'll just put a little bit in. To top all this, the oversight provided by the Supreme Court of India has resulted in facilitating international commercial arbitrations. On the vexed question of public policy and arbitration awards, the Supreme Court in Associated Builders in 2014 held. It must clearly be understood that when a court is applying the public policy test to an arbitration award, it does not act as a court of appeal, and consequently errors of fact cannot be corrected. A possible view by the arbitrator on the facts has necessarily to pass muster, as the arbitrator is the ultimate master of the quantity and quality of evidence to be relied upon when he delivers the arbitral award. In World Sports Group Mauritius Limited, in 2014, the Supreme Court held, the arbitration agreement does not become inoperative or incapable of being performed where there are allegations of fraud. In Chloro Controls India Private Limited, in 2013, the Supreme Court held that the expression person claiming through or under, as provided under Section 45 of the Arbitration Act, would mean and include within its ambit multiple and multi-party agreements. In Bharat Aluminium Company, in 2012, the Supreme Court did not hesitate to overturn its earlier 2 judgments. In this case, the Supreme Court held that Part 1 of the Arbitration and Conciliation Act 1996 was not applicable to arbitrations seated outside India. Therefore, presently, a foreign award is not amenable to challenge under Section 34 of the Arbitration Act before a court in India. May I add here another personal input? I was talking outside just now, and I'd like to reiterate that at the highest level of planning in the Indian government, efforts are ongoing, that neither the government nor its agencies will have any interference with the arbitral process. Government interference will be describable as zero role. The zero interference in international commercial arbitrations will give room for understanding of foreign traders in India that the process is neutral. These initiatives will provide a great sense of confidence and trust, and all those involved in international commercial arbitrations. The Indian Supreme Court, when called upon to appoint an arbitrator in cases of international commercial transactions, has adopted a consistent practice to provide arbitrators from a neutral country. So in my view, these two initiatives, one by the government of having a zero role, and the other by the courts when they appoint arbitrators in an international arbitration from a neutral country, will promote further the confidence of the trading community in international arbitrations in India. May I state in conclusion, in my view, India is becoming a hub of international commercial arbitration. As technology eases the doing of business, it also makes the content of business contracts more complicated. Commercial disputes between various countries will necessarily become interdisciplinary, requiring experts other than those in law. Probably the nature of international commercial arbitration is on the cusp of radical change. The sessions of this conference, I am sure, will reflect on the directions in which change is likely to happen. The participants are not only lawyers, but businessmen and representatives of governments in business through their public sector organizations. And therefore, I'm sure the conference will yield a meaningful outcome. I'd like to thank the organizers for giving me this opportunity to speak to you, and I thank you all.
Thank you so much for your enlightening address, sir, and for the much-needed perspective from the bench. I'd now invite Ms. Ruchi Ghansham to address us on the arbitrational challenges that nations face. Please, ma'am.
Thank you. Honorable Chief Justice of India, Sheikha Haya Rashid Al Khalifa of Bahrain, former President of the UN General Assembly and an eminent lawyer herself, former Minister of Law and Justice and External Affairs, Mr. Salman Khurshid, my former boss as well, Mr. Moses Manoharan, Chairman Global Dialogue Review, Mr. Abhinav Bhushan, Regional Director, ICC South Asia. I just returned less than a week ago from South Africa, where I was working as the High Commissioner of India, and have now joined the Ministry of External Affairs as Secretary West. I have not yet had the time to become familiar with the legal issues that one of the divisions under my charge is dealing with. And I therefore consider myself a student rather than an expert on the subject. To be speaking here, I feel somewhat greatly humbled actually to be standing here before all the legal luminaries of our country. It is also very difficult to speak after you, Honorable Chief Justice of India, and to speak before eminent speakers on the dais like Sheikha and Mr. Salman Khurshid. And therefore, I would just restrict myself to making a very few points, which I hope will be pertinent to the process, and which will not really come in the way of the very enlightening words that are coming after this. So, the first thing that I would like to say is that pursuant to the liberal policies and efforts by the Government of India, India has opened up to foreign investments. The growth in domestic and international trade and commerce has spurred competition, provided new opportunities, and increased certain attendant risks that include increase in number of commercial disputes. India is desirous of becoming a major international center of arbitration, and this is reflected in the PCA choosing India as one of the countries to set up their offices, and the UNCITRAL choosing India as the venue to host its celebrations marking its 50 years. The Arbitration and Conciliation Amendment Act of 2015, the 2015 amendment, aims to inculcate a more professional culture for arbitration in India, and also seeks to make arbitration proceedings more expeditious and cost-effective. The new act has several provisions to address the criticism that arbitration regime in India is a long drawn-out and expensive process, defeating the very purpose of arbitration. India has also signed a host country agreement with the Hague-based Permanent Court of Arbitration way back in 2008, which would enable India and the PCA to establish a legal framework under which PCA-administered proceedings can be conducted in the territory of India. However, major challenges which India needs to address is not only to promote arbitration, but also to promote India as a seat and venue of arbitration. In any arbitration, the selection of seat of arbitration is of critical importance, as it plays a role in deciding the law governing the arbitration procedure. The government is taking steps, as has been highlighted also by the Honorable Chief Justice. So the government is taking steps to develop strong and robust arbitration institutions to overcome existing challenges. A pool of Indian legal practitioners who specialize in the practice of arbitration has to grow, with arbitration viewed as a specialty rather than an appendage to Indian court litigation work. India thus needs to be seen as an effective and neutral venue with prompt and efficient proceedings to supplement the process of arbitration. As can be seen, a number of initiatives have been taken by the Indian government aimed at reforming the entire system of arbitration in India. Our Prime Minister, Honorable Shri Narendra Modi, has declared in a speech on October 26, 2016, that creation of an enabling alternate dispute resolution ecosystem is a national priority for India. We need to promote India globally as an arbitration hub. Reforms to the Arbitration Act have resulted in strict time frames for the resolution of disputes, thus expediting the process and bringing it closer to global standards. Provision for arbitral institutions to create their own rules consistent with the Act to ensure that arbitrations are swift and effective, and to express inclusion of communication through electronic means for formulating the arbitration agreement. Our legislation is broadly based on the UNCITRAL model law. It is hoped that with these reforms and initiatives, these will help to develop India as a global hub for international arbitration. I therefore congratulate the organizers of this conference and thank all of the participants and most importantly the speakers and the eminent guests who are sitting here today for having given us this opportunity to discuss this very important subject. Thank you so much.
Thank you so much, ma'am. I now invite Her Highness Sheikha Haya Rashid Al Khalifa to deliver her keynote address.
Thank you very much. Good morning, everybody. Welcome to this early morning session. And at the outset, I would like to welcome Honorable Justice Jagdish Singh Khattar, Chief Justice of India, Ms. Rashi Ganashim, Secretary, Ministry of External Affairs of India, Mr. Salman Khurshid, former Minister for Law Justice of India, Mr. Moses Mandarhan, Chairman of Global Dialogue Review, and I welcome you all. My intervention will be, the subject will be international arbitration and different cultures. Nowadays, arbitration is known for its ability and need to self-regulate. The process of arbitration exists and has been adopted by state as an international legal system alongside their national legal system. We have witnessed an increase in international efforts by the international community to standardize diverse legal system in the area of international commercial arbitration. The New York Convention on Recognition of Enforcement of Foreign Arbitral Award was adopted in 1958 by the United Nations. Since then, 156 jurisdictions have adopted the convention. Further, in 1985, almost 30 years after the adoption of the New York Convention, another significant attempt was made to harmonize international commercial arbitration through the UNCITRAL modello. 72 countries, including India, have since adopted the legislation based on the modello, a total of 102 legislation. In fact, modello jurisdiction now comprise approximately 1/4 of the world territory. However, the national legal culture largely affect international arbitration upon the interpretation by local judges of the international texts at time of challenge or enforcement. The fast development in technology and communication creates the necessity to understand other culture and accept their differences and to live with those differences. This naturally applies to the legal community. As trying to understand the facts of the disputes as well as the good interpretation and understanding of text of contract or of the law and applying the same to the facts ultimately lead to better fairness and justice. As we are all aware that legal systems are various and different in nature, what I will deal with today involves looking in depth at the interpretations and principles given the common law system and the civil law system as they govern and apply to most of the international transactions. It is evident that the proper understanding of each system reflects the quality of work and subsequently its effectiveness. There are certain issues that must be taken into consideration upon drafting contracts, rendering legal opinion, raising cases, or drafting reasons for judgment or an arbitral award. Ignoring such issues could lead to that the act to the could adversely affect the act to the extent of nullifying it. I will give certain examples as time permit. Firstly, the form. The law may provide that certain act or procedure must be effectuated in certain form. If the form is not adhered to, the act or the procedure will be considered as null and void. I will give you an example, like in Bahrain, Article 84 of the law of procedure provides that witness shall take an oath that he will tell the truth, all the truth, and nothing but the truth. Otherwise, his testimony shall be null and void. Based on that requirement, however, in Dubai they have the same text. In Dubai, on 20th February 2002, Dubai Chamber for Dispute Resolution issued a decision after hearing of 15 witnesses in favor of an American company for around $24 million. The award based on the witness statements. The other party, it was an Emirati company, challenged the decision for the nullity before the competent court in Dubai on the ground that the witness did not pronounce the oath and the exact wording providing by the law. That means the minutes of the hearing did not include that the witnesses say the oath as it is required by the law. The court nullified the award on the ground of the invalidity of the oath. The judgment was then confirmed by the Court of Cassation in the United Arab Emirates. That was a judgment for a company called Bechtel, for the company called Bechtel. I think all of you know about it. And they tried to enforce it in spite of nullifying it in United Arab Emirates. They tried to enforce it in the United States and in France, and I don't think that they succeed. I don't. But it is just a small mistake that the judge did not require from the witnesses to say the same wording of the oath. There is many other issues. I will just skip the long one. I will just give you examples of drafting and interpreting the contract. It is notable that contracts drafted in common law jurisdiction are detailed enough to cover all presumption of potential risk upon signing of the contract and during the contract period. However, the civil law jurisdiction, the same, does not include in general details which is not related to the law. The reason is that in the common law system, the interpretation of court is based on the form of the wording of the contract, whereas in the civil law interpretation, the judge has discretionary power to find the factual reason, of the parties and not the appeared reason only. In Bahrain, the interpretation of the contract consideration should be governed to the common intention, of the parties to the contract. Understanding of such an intention is under the capacity of the substantive judge. When the court identifies the common intention of the parties, then the court can justify it with the proper legal justification without being limited by the justification of the parties. That means the judge has a very wide power, discretion power. So the common law applied an objective standard in interpretation and applying the term and applying the terms of contract, while the civil law applies the personal standard while looking for the intention of the parties from the wording of their contracts. There is also certain terms in the common law, such as the term of without prejudice. Without prejudice, when a discussion or document is issued on a without prejudice basis, it means that the information should be considered confidential and the parties are not allowed to submit it before the court. And even if it's submitted, the judge should not take it or look to it and base his judgment on it. It is not considered as admission. It is not considered as an admission of liability. However, in the civil law jurisdiction, it is very risky document as the judge can rely on it in his judgment. In most of cases, it is considered as admission of liability before the civil law court. Also, the estoppel, you have reach in the common law It is rule of evidence or rule of law that prevent a person from denying the truth of a statement he has made or from denying a fact that he alleged to exist. You all know. In the civil law, we don't have a term of estoppel, but we have application of such term. We apply in a in a different name or in a different principle. We call it in the Middle East jurisdiction, like an agent which is not very clear. The judge use it. I give you an example of a case. In fact, it's a Ministry of Foreign Affairs. There was an ambassador who issued checks of the Ministry of Foreign Affairs for a certain cars, 10 cars, big cars. But the ministry didn't know about this contract. So they, the person who sold the cars, they came, asked the ministry, give me my money. They said, we don't know about this. He said, no, I have your checks of the embassy. So he raised the case before the court, and the ministry denied. However, the court gave this man his entitlement on the basis that this is here. I can maybe I don't know whether you consider it estoppel or not. The ministry cannot say that this is not myself. It's their checks, their place of the. He came to the embassy and signed it and received the check, and he sees somebody who has the authority to sign it. So the court say that all this atmosphere create that this man has he trusts. Because of all this atmosphere, he trusts the situation, and he sell the car, and he take the checks. He thought that the person who signed it authorized, and the court give him his entitlement, not according to the estoppel, but according to another principle which is similar to estoppel, but it is specific. That means it's not a principle. That means you can apply it in all the cases as the estoppel. There is many different issues and many differences between the civil law system, and the common law system. Each arbitrator or lawyer deal with the different culture must understand such differences in order not to make mistakes or to hurt or to his client. In fact, I have just a personal experience with some of, not a client, just somebody from common law jurisdiction, like a judge, ask Bahraini, ask us as Bahraini to find a solution for a case where, according to our contract, the Bahraini law was applied. To find any solution to give the claimant some compensation because he worked in a deal and he benefit the other party huge amount of millions of dollars. And according to Bahrain law, his right to claim is time bar. Moreover, he has all the transaction was offer, counter offer, offer and counter offer. There was no contract, there was no offer and acceptance. He cannot claim either as a contractor or any other reason. Can you help me? Do you have any other? In fact, in Sharia, because according to our constitution, we have the law come first as a source of law, the text of law first. And Sharia, Islamic Sharia, if there is any absent in the law, you can use the principle of Sharia. In Sharia, there is a principle that it's just two words called, if you cannot, if you take, you have to give similar for justice. If you take something, you have to give same level of give and like offer and acceptance in something, same value. You cannot give small value and take big. You have to. This is the justice, and you can use it. We can use it. One of our big arbitrator in Egypt, he used it in a very big case. The arbitrator, maybe somebody of you know him, Mr. Ahmed Al-Qushayri. He used it in a big case where he did not find anything in the law can help him to compensate one of the parties who has no legal ground according to the law, but he can use this principle of justice in Sharia. So it's better to understand when you draft your contract, when you draft your judgment or legal arbitral award, to know the legal system which is up to your to the case. So it is important to understand the nature of the differences between the common law and civil law system in order to avoid infringement, breach or violation of the law or public order. There are issues which may face parties in the disputes who invest the time and money in order to reach a fair judgment, to preserve their rights and ensure it subject to enforcement. In the civil law system, there is a binding legal provision, and party cannot agree otherwise, given that it is related to the public order. In general, the substantive provisions are similar as they are based on the principle of justice, fairness, and good faith. However, each system has its own provision which related to the form which needs to be known. The form is very, very important. As you are well aware, the New York Convention, as I have said before, in regard to the enforcement of foreign arbitral award, provides reason for challenging and setting aside arbitral award based on violation of public order and other substantive or procedural violations. Therefore, it's important to be aware of the binding provision of the applicable law in the place of arbitration and place of enforcement. This is crucial to avoiding any challenge or enforcement refusal from the courts. In the present day, and as the rules of arbitration become more and more unified, there is a need for us to knowledge and understand better the different legal systems which exist. On an international level, we need to invest more effort toward developing a global understanding and interpretation of international texts on arbitration rules and convention. Thank you very much, and thank you again for the organizer. Thank you, George, for everything and for your effort. Thank you very much. Thank you.
Thank you, ma'am, for highlighting how domestic legal systems impact international arbitration. I'd now like to invite Mr. Salman Khurshid to address the audience, please.
Good morning to everyone. Honorable Chief Justice. And I wanted to just make a comment, Mr. Chief Justice. Often in our country, we address the Chief Justice as Mr. Justice Kehar, Chief Justice of India. But I think I've tried very hard to persuade people that when you address Chief Justice, just address the Chief Justice as Chief Justice. And perhaps this is something that we can ensure in times to come. Your Highness, Sheikh Hai Rashid Al Khalifa, Secretary West, Ms. Ruchi Ghansham, Abhinav Bhushan, my friend and Regional Director for ICC, distinguished guests, particularly Moses Manoharan, who persuaded me to join this effort to bring some of our best minds in arbitration together, and some of you who worked extremely hard to bring together this event. I just want to preface my remarks by first thanking profusely the Chief Justice to have found and made an effort to find the time to be here this morning, and so generously extended this stay by the extra time that he was able to speak to you in the lobby. Understandably, much has to change in terms of attitudinal behavior, whether it's an arbitration, conciliation, or attending of conferences. So to ensure that 9 o'clock is 9 o'clock, but that's now how it is. Fortunately, we don't have to worry about that as far as courts are concerned. I want to say in response to the Honorable Chief Justice's remarks and indeed Her Highness's remarks that we are moving exponentially forward as far as arbitration and conciliation is concerned. But there is an essential point that we need to consider, and when those of us who are familiar with arbitrations that happen elsewhere in Singapore, London, Paris, and elsewhere, is the equipment and the hardware and software that's provided for arbitrations, which unfortunately is lacking. And I'm encouraged to say this, lacking here in our country, but I'm encouraged to say this because the Chief Justice has gone on record to say that in the next 200 days, you might be able to convert the Supreme Court into a paperless court, which is really something that is long overdue in a country like India, where we have a monopoly on technology, and particularly software technology, that we have lagged behind countries like Brazil, where the highest courts have turned paperless long time ago. We've had some remarkable successes in the Delhi High Court, where several courts have gone paperless, but they're only to the extent of the judges, as you perhaps know, who are paperless, but the lawyers are still resisting, and they still carry their files into those paperless courts. But for us to be to come up to the mark, as it were, with international standards, we will have to get greater amount of technology which is available in the world, but we can in fact improve upon that technology, and to have the pleasure of being able to argue with the help of that technology, and reducing, as it were, the very tedium of long drawn-out litigation, which is what the arbitrations are supposed to be a substitute for, is something that we really have to flag as a high priority of switching to technology. The second issue, of course, is that, and I bring this to the Chief Justice's notice, but I'm sure that Chief Justice is quite aware of this, is the drift of arbitrations towards looking more and more like court proceedings. That this is so in tribunals, and this is also in arbitrations, where people who have been accustomed to court proceedings for a long time and therefore are eminently qualified to continue in that manner. But when they come into arbitrations, to try and import the features of a court into an arbitration is something that I believe negates the very purpose of arbitration. And therefore, the enormous improvements that have been made in the recent amendments that the Honorable Chief Justice actually mentioned in his speech, including the issues of bias and issues of conflict of interest, and the period and the time that the arbitrations have to be completed in. The appointment of arbitrators, etc., has gone a long way, but I think it's very, very important that the arbitrator's attitude has to be different from the attitude that a judge has. In fact, a judge being more like an arbitrator, if it's physically possible, it would be certainly welcome. But there are constraints within which a judge has to operate, particularly in our country, where not only the constraints of what the requirement of law is, but also the heavy load of work that the poor system has to respond to. So these are, I think, important questions. And as we become candidates to draw more arbitration to Asia, and particularly to India, we speak of Asia, but obviously when we speak of Asia, much of our preference would be for India, and the destinations and the platforms that the Honorable Chief Justice spoke of are those that we would want to offer to the world, and they are outstanding places in India where I would imagine arbitrations would be very, very successful in time to come. But we are certainly working in that direction. Mediation centers that courts have set up, I think, have done remarkable work. And the mediation centers, if we could provide an equal alacrity and efficiency as far as the arbitration centers are concerned, I think we would be, we could congratulate ourselves. I want to mention here an important point that maybe will catch the Honorable Chief Justice's attention. And that issue is marrying together of our understanding and commitment of international transactions with the requirements of the law in the country. I have done a critical analysis of a very important judgment of the Supreme Court in the presidential reference in the 2G matter. In the presidential reference, the Honorable Court had decided to answer 5 questions, but inevitably, the constraint of time, because there are some judges retiring all the time, inevitably the constraint of time caused the judges to answer 4 questions. And the 5th question remained unanswered. And I believe one day that is a question that the Supreme Court should answer. And that question was, and we had very consciously framed that question and given it to the Honorable President for the opinion of the Supreme Court. And that question was, in deciding a matter on constitutional provisions in the country, which has international implications, in deciding what relief to grant or in molding relief, would the court would be conscious of the fact that the molding of relief may lead to international implications, particularly where there are, and there's a session for that, of bilateral treaties, commercial bilateral treaties, and the impact of a decision within Indian courts. Now, there has been in the White Industries case, the problem was the delays that were being caused by jurisdictional conflict between Calcutta High Court and Delhi or wherever it was, and that led to an international arbitration that is aware of, Abhinav, and that led to a huge arbitral award against us. The same thing may well happen in other cases where a decision is taken by courts, but to what extent should the courts should factor in international commitments is something that I think has not strictly been decided in such such a nature of facts. What has been decided, of course, is where international commitments or our signing of international treaties have been taken as additional material to decide which way the courts should be going. Now, I think in international arbitration matters, this is something that at some point of time the courts will have to decide and take a careful and conscious view, particularly because today there are at least 20 or something international arbitrations that are poison simply because of the agreements that we had signed, the treaties that we had signed, which we are now reviewing. I think most of those treaties are being reviewed. But in any case, the law needs to catch up with our international commitments. And I thought that I would just flag that point. And in flagging the point about the problem of judges retiring all the time, I do want to make a conscious statement, and the Chief Justice does not have to respond, but I do want to make a conscious statement that the Chief Justices stay for too short a period. That we need, and I wrote somewhere that the American Chief Justice came to the Supreme Court as Chief Justice, the present American Chief Justice, and will probably be there for the next 30, 35 years. And in the duration that he's been Chief Justice, in the few years that he's been Chief Justice, we've seen at least 6 Chief Justices come and go. But I don't know if we can find a solution to this now or in future, but I think that the captain has to be around for longer. And
the short answer is I'd love to retire.
But this is just a point not necessarily directly related to arbitration, except that retired judges are then available for arbitration. So what is a loss here in courts is certainly a gain to arbitral tribunals. But we are very grateful to you, Honorable Chief Justice, for having given us your time, and very grateful to Her Highness for also being here. I hope that this will be the beginning of a very special relationship between Bahrain and India in matters of arbitration. I certainly look forward to that. Thank you very much.
Thank you, sir, for setting the tone for the rest of the conference. Last but not the least, I would like to invite Mr. Moses Manoharan to deliver the thank you address.
On behalf of the organizing committee of the Engaging Asia Arbitration Summit, I express my warm appreciation to all those who have contributed to this event in one way or another. Among them, I would like to thank above all the Honorable Justice J.S. Kehar, the Chief Justice of India, for making time in a busy schedule for this summit. His speech was thought-provoking. His mingling with lawyers and others amazing, and the rapport was there for everyone to see. I express my gratitude to Madam Ruchi Ghanshyam for being here just days after assuming charge as Secretary West in the Ministry of External Affairs. But knowing her for some time, she would have done nothing less. I'm also grateful for Mr. Salman Khurshid, India's former Minister for Law and Justice, for his fulsome support of the event and for being amusing as always and evoking an equally amusing response from the Chief Justice, Honorable Chief Justice. Our appreciation of Sheikha Haya Al Khalifa of Bahrain knows no bounds. Her deep knowledge of the nuances of Eastern and Western approaches to international arbitration is fascinating. I thank our partner, the ICC, International Court of Arbitration in Paris, here represented by Mr. Abhinav Bhushan, the Director of South Asia, for the quiet but effective support. The success of the summit over the next day and a half will in a great measure rest on a distinguished group of experts who will deliberate on different aspects of arbitration. We are thankful for the support extended to us by the audience and especially the media. Our organizing committee has been ably led by Ms. Nisha Ramdas and Mr. Samir Jain, Madam Anshu Khanna and a dedicated team of event managers, and Mr. Kapil Gupta's social media group, OmLogic, as well as our numerous benefactors. Chief among them is the team from Leela Hotel, inspired by their chairman and managing director, Mr. Vivek Nair. Thank you all once again.
Thank you, sir. I request all of you to proceed for a 15-minute coffee break, and then we shall meet here again for the first session, that is Asia's emergence as a global epicenter for opportunities in arbitration. Thank you.
Nice to meet you. How long are you going to be here?
Ladies and gentlemen, I request you to kindly be seated for the first session to commence. The theme of the first session is Asia's Emergence as a Global Epicenter for Opportunities in Arbitration. The session is chaired by Mr. Salman Khurshid. The speakers are Mr. Ajay Behel, co-founder and managing partner, AZB and Partners; Mr. Sohail Nathani, managing partner, Economic Laws and Practice, Mumbai. I'm so sorry. I'm so sorry. Mr. Naresh Thakur, Economic Laws Practice. Mr. Fareshte Setna, founder and managing partner, DMD Advocates, Mumbai. Miss, I am so sorry. Ms. Chen Bao, Asia Pacific Council, International Litigation and Arbitration, Skadden Arps, Slate, Meager and From LLP and Affiliates, Hong Kong. Mr. Shai Wade, partner, Stephenson Harwood LLP, London. I'd request the chairman to kindly commence the session.
Thank you. We don't have mics here. So, shall we just, can you hear us? We use OIC. Good morning again, everyone. If you can hear me, if you can't hear me, just yell. We proceed to this very important session. And I was, my colleagues here on the panel made it very clear to me that this is not about India, this is about Asia, which is the entire region. The Asian century going into this high growth region, which is attracting attention internationally. United States of America coming out with the Asian pivot. The future, of course, depends on what happens with various trade treaties, etc., particularly on the Pacific. But Asia is really both the concern, the target, and for us celebration in terms of opportunities. But really, what kind of opportunities we have? What are the true prospects? And what are the possible areas where there is still need for further enhancement, improvement, etc. So, as our colleagues speak, these issues will become apparent or get flagged, and we will then have a chance perhaps to discuss and debate some of them, and finally then open up to the House for you to ask questions and then fortify your sense of what you can take away from this session. So what we would do is that we will begin at the edge and then move inwards, so that at the end of the discussion I can say a few more words and then conclude with your permission. So we start from the left, as it were, and on the left we have Mr. Shai Wade. He said I can call him Wade or Wade, depending on how you like to see it in Asia. So the floor is yours.
Thank you very much. Honorable Chief Justice Kaher, Your Highness Sheikh Al Khalifa, Excellencies, Honorable Justices, Ministers, ladies and gentlemen, I'd like to open my remarks with a short but heartfelt note of thanks to the organizers and tireless and hard-working organizers from Global Dialogue Review for organizing this very interesting and timely conference and for inviting me to participate. So, very well done. For those of you who know my firm, or at least know it well, Stevenson Harwood, they will know that we have a very, very long and deeply established roots in Asia. Indeed, Asia was where our founder, William Harwood, started out more than 140 years ago. He resided in Shanghai, where he established, before returning to London, what was then a little known, but has slightly become better known, bank by the name of the Shanghai and Hong Kong Banking Corporation. Some people refer to it as HSBC these days. And now, over a century and a quarter later, HSBC remains a client of the firm, and Asia remains a big focus for our business and for our interests, with more than 33% of our lawyers established in Asia. So we follow with great interest how the world of international arbitration has developed, both here in India, but also further afield across Asia. It's a development which I personally, now I feel as if I'm shouting too loudly. Tell me if your eardrums pop, put your hand up and I'll whisper. But it's a progress and development which I personally have also seen through the 20 plus years of my own career. And I thought, if I may, and I hope I don't bore you with this, describe the emergence of Asia as an epicenter or a center of international arbitration through some reflections on my own practice and the cases I have done over the years since I began practicing. And I hope my comments will illustrate how, in that period of time, Asia has become increasingly a place in which international arbitration can be and is practiced successfully. Indeed, my very first big arbitration, not a small shipping case, which was my very first one, but the very first big, complex international arbitration that I did involved an oil and gas pipeline offshore Singapore and Malaysia. And back then, in 1998, I don't know if I'm afraid to say, but as was the practice, and certainly was the practice in that particular arbitration, there were 3 international companies who had rights to oil and gas interests offshore in that particular area, and each of those companies brought in big foreign law firms, and we all descended on Jakarta, and we all had a very good time and worked very hard, but no local lawyers had anything to do with this international arbitration. It was truly international in that sense, but it wasn't very Asian, even though the ultimate assets were based there. A few years later, but not very long ahead, in around 2001, I, in my practice, saw how things began to change. And I also had the honor for the first time of submitting and representing a client before one of the most famous and respected Indian international arbitrators, probably of all times, Mr. Fali Nariman. And for me, that was the first encounter with one of the great Indian lawyers who showed me the depth and amazing shrewdness of the Indian legal culture. And he in himself, I think, both through his presidency of ICA and involvement in other international arbitration organizations, has probably done more than any one individual lawyer to advance the cause of international arbitration in Asia. That was an inspiring moment for me. Around the same time, but not connected to me personally, although I'd like to take credit for it, in 2002, the Singaporean government awoke to the potential for Asia generally as a center for international arbitration. And they introduced a number of measures that were designed to develop Singapore as a center for international arbitration. They modernized their own International Arbitration Act. They committed themselves to developing the infrastructure for international arbitration, and announced the establishment of what has become Maxwell Chambers, a set of modern and user-friendly hearing rooms and support mechanisms. Crucially, I think, and this is what propelled Singapore ahead in the international arbitration race, they announced an arbitration tax-free zone, which started in 2003 and will end in 2020. Any income made by arbitrators in Singapore is entirely tax-free. And so you can imagine how international arbitrators became very interested in the jurisdiction. A year later, I again appeared before an Indian arbitrator, this time Mr. Chidambaram, who has then since, I believe, left the law and has focused on politics. And again, in this time, times had moved on a little bit, and by now, we were foreign parties arguing over an oil field offshore India. But this time, we did work with Indian counsel, as has been my practice since then. And it was a very interesting and successful arbitration, and we shared leading roles with an Indian counsel and us, and it was a very good example of how cooperation can happen and should. In 2004, again, I had a case involving not Indian but Asian clients, this time based in the Philippines, and I was, I guess, lucky to appear in the first arbitration seated in Manila. I don't know if anybody's ever seated an arbitration in Manila. It was an experience. In the course of the proceedings, one of our witnesses was gunned down, and it was therefore a very good case to settle early, which is what we did. 23 to 26, I had a very large Indian arbitration between two Indian corporations in the telecom sector. I think it featured in the press at the time. Again, we were assisted and worked very, very closely with Indian counsel throughout the arbitration. Very interesting corporations. I was given my first set of Mullah and Mullah on contract law. Two very big tomes. I think they might be out of date. I think they, but mine are still on my shelf. Between 2007 and 2012, we saw a whole host, I think inspired or resulting from the financial crisis, a whole host of Asian arbitrations in our practice, mainly Indonesian related with coal and Singaporean related with shipping cases. But the development in my practice or in our firm's practice at that point was a big shift in the seats of the arbitrations for those cases. So as previously London or Paris or The Hague were the seats where we conducted Asian arbitrations in, with Manila being the only exception, now the majority of them at this period of time, within the scope of 10 years, had moved to Singapore or Hong Kong. And that is where we see more and more of our work going. In 2007, I don't know if it's foreseeing this surge, but in 2007, SIAC, the Singaporean Arbitration Organization, modernized its arbitration rules, and they did so again in 2010. Along the same time, a competition with Hong Kong started to emerge, and in 2008, the HKIC introduced their first administered arbitration rules. Before that, they only hosted arbitrations under the UNCITRAL rules. And in 2013, they revised their rules again, and that coincided with the introduction of a new arbitration ordinance in Hong Kong. That competition between those two centers has actually done a great deal to advance Asia as a center for international arbitration, and they led the world in supporting new developments in international arbitration, such as the emergency arbitrators' role, both within the rules and with judicial and legislative support for that development. Around 2010 and 11, there was also a surge of bilateral investment treaty claims being advanced against Asian countries. I advised on one which related to a Southeast Asian country, but equally there were a number of cases that commenced around that time against India and other countries in the region. And we saw a great development of international law arbitrations arising from the region, although I believe that mostly they weren't seated here. In the time since then, we as a firm have seen another great leap in our involvement in Asian arbitration, much of which actually relates to working for and with Indian clients, but not necessarily in Asia. In 2010, you will all recall, that was the year where India entered the top 10 economies in the world, and China took over as the second biggest economy in the world. And these developments have meant not only that, have, I suppose, heralded not only the increase in economic activity of Asian parties in Asia, but many of our Asian clients and many of the arbitrations we do for them involve mining interests and business contracts and oil and gas interests outside of Asia. So it is no longer, I think, right to say that arbitration, Asian arbitration relates purely to Asia, because within our firm, 4 of the biggest arbitrations are Asian, but 2 of them are for Indian clients concerning mining interests in Africa. So they're not seated here, but I wonder why not. So it's a question to think about. As you, and I'm sure we'll hear much more about this, but around that time, interesting judicial developments also happened here in India. And we've heard already today, and we'll hear more, I'm sure, about how negative Supreme Court decisions from the early 2000s have been reversed and updated, and now we probably have in India as arbitration a friendly atmosphere as we have had in many, many years, and possibly equal to any other jurisdiction in Asia. In 2015, the Queen Mary Arbitration Survey revealed that Hong Kong and Singapore are the 3rd and 4th favored arbitration seats for international parties engaged in arbitration, replacing from 10 years before then, replacing Geneva and New York, who had gone down in the ranking as favorite arbitration seats. In 2015, but came into force in 2016, of course, the Indian Arbitration and Conciliation Act was amended, and in 2016 we have seen the opening of the Mumbai Center for International Arbitration and the promulgation of its rules. And there are 2 things I think we can say about those at the present time, before any cases have run through them. First of all, they are very intelligent and modern application of accepted arbitral procedures, which are meant to reflect the cost and time concerns of parties in India. And I think that will herald a great move forward in terms of arbitration in India. The other big development in that regard is their arbitration facilities that they have moved into, which I have not personally visited, but I have seen pictures of. And I have spoken to people who have actually had hearings there, and they are cutting-edge facilities in terms of internet speed, conference rooms, seating, breakout rooms for the parties, and very pleasurable to work in. So that is also, I think, a development which will help India and the region increase its presence in the international arbitration field. So, 2 or 3 more statistics before I raise perhaps a couple of thoughts for discussion later. First, with all of these developments and just looking through my own background, to me, it's not surprising at all that in the past 2 years for which we have statistics, so 2014 to 2016, 800 new cases overall have been registered in SIAC, the Singaporean arbitration organization, and 523 cases in 2014 and 15 in the Hong Kong International Arbitration Center. So that's a very considerable amount of work which is now coming to Asia, and suggests to me that to the extent that there is a developing theme of Asia becoming the epicenter of international arbitration, or an epicenter of international arbitration. I'm not sure I like, by the way, this thought that we're in the middle of an earthquake, but still, if there has been an earthquake, it has already occurred. Asia is already a global center for international arbitration. And we should not be surprised by that development at all. The questions that we remain to address, and I'm not sure whether you'd like me to address them now or later, maybe I've spoken enough already, are there any more barriers which prevent Asia from going even further into becoming a center for international arbitration? If there are, what are those barriers? And what can we do to remove them? And I have thoughts, but I don't know when you want me to express.
Maybe we can come back in the second round and then talk about the barriers, because you've really talked about the positive experiences that you've had, and that indicates that that's be available to everyone. So in the second round, we come back to the barriers. Thank you very much.
Thank you very much.
Right, so I think, as I said, we will squeeze in from the outside. Mr. Ajay Bahel, your turn now. Floor is yours.
Bring it left and right.
Squeezing in, yeah, from left to right. So
Thank you.
we're in the right direction.
Thank you. Mr. Chairman and friends, ladies and gentlemen, I think when I was looking at the theme and I saw the word global, I was actually wondering, and I think Mr. Khurshid, if I may call him Salman, because he's a good friend who's also been an external affairs minister, would really question whether this word global is soon going to go out of fashion with the amount of nationalism that we are seeing. And therefore, are we going to revert to the pecking order of national, regional, and then global? And I think that's the context in which I thought I would approach this, because I'm a great optimist, I always have been, but I think optimism has to be also a little tempered. And that doesn't mean that we don't recognize the importance of Asia as essentially a place which has, at the end of the day, some of the largest economies of the world: India, China, Japan, the Asian tigers, Australia, New Zealand. So as trade develops, as Mr. Khurshid said, it's only natural that the importance of this region is going to have to be reflected in more ways than one. And one of them would obviously be to make it a place for people to be able to settle their disputes. The question really is, while everybody must aspire to do better, but I think even if we look at it regionally, I think it's important to ask the question that will Asia, at least regionally, be an important center for arbitration? And I think the answer has to be a resounding yes. I'm not going into specific countries, but I will talk a little bit about SIAC and Hong Kong, because they've obviously been very positive influences, and the outcomes have been very positive. But I mean, realistically speaking, do we expect two companies in the Americas to choose Asia to arbitrate in? Probably not. Not in the short run, maybe in the longer run. Do we expect continental Europe, where there are language issues, where there are people who might find more familiarity going to ICC or arbitrating in Paris? Again, probably time will tell. But I do note the comment that was made that Geneva and New York have lost some of their preeminence. And I think I will give one statistic which actually supports that proposition. But I think clearly the question is, or the proposition, if the proposition is that is Asia an opportunity to be grabbed for commercial dispute settlement and ADRs, the answer has to be, as I said, a resounding yes, and there's an opportunity to be grabbed. And I think clearly Singapore and Hong Kong have taken that lead and have made great strides there. Now, at the same time, just in terms of some statistics which you referred to, in fact, it's interesting to see that Hong Kong seems to, even though it was the older one, Hong Kong seems to, in a sense, be left a little bit behind Singapore. In 2016, Singapore saw a 22% increase from 2015, and the value of disputes there was almost $11 billion. Hong Kong, in contrast, while it had 400, 500, actually it was less than what was in 2015, and the total value of disputes was only $2.5 billion. In contrast, of course, ICC is still seeing robust growth, and they had 900 plus arbitrations with almost $84 billion worth of value of disputes. But interestingly, LCAI has certainly seen stagnation. In fact, in 2016, the number of arbitrations have actually come down from 2015. And I think that therefore, that's where the question is, that if Asia sees itself as a region and a regional player with aspirations of being a global player, just the mere non-externalizing or exporting arbitrations which have a counterpart in this region will, I think, itself be a major way of developing this as a center. Because if you look at it traditionally, when we were in the early days of our practice, when people wanted a neutral venue, the experience we had was that London used to be the first choice. Common law, English law is something that is well understood. Large Indian diaspora, access to firms, and there was very little by way of alternates. But in the last 5 or 7 years, we've seen a very remarkable change where, especially if people are at least one counterparty is from this region, Singapore has become, as an example, a very, very recommended, very easy place to work with. And obviously there have to be reasons for it. It can't have done something on its own without having made it couldn't have become so important on its own without having made the actual effort to reach where they are. So I just want to, without going into specifics of what need to be done, I'm just looking at what are the ingredients if anybody wants to really grab this opportunity. I think there are 3 or 4 very clear ingredients. Some of them are softer issues, some of them are obviously important ones. The first one is obviously an arbitral or arbitration-friendly domestic law. In a law which is soft touch insofar as proceedings are concerned, which provides for the least interference with the proceedings, which is speedy, which is predictable. And I think any jurisdiction which offers that has obviously achieved one of the important benchmarks that is needed to be in the reckoning. Secondly, it has to have good institutional frameworks. It must have rules which are well developed, well oiled, well thought through, as Singapore has attempted to do, and they've kept revising them from time to time. The rules must provide as much clarity with respect to the proceedings. It must provide whatever best it can. Singapore provides, for example, for immunity and confidentiality. So the comfort given to the arbitral community and to the clients is also that we are dealing with a place which has, again, transparency insofar as its rules are concerned. And obviously it must be cost effective. And if it's cost effective, that is again a major issue, because when we used to go to England, obviously it's an expensive place. Lawyers are expensive, travel is expensive, hotels are expensive. All of that in the long run adds up, because you have an entire, that's the package of cost that you are referring to whenever you look at anything in the context of litigation. The third is the infrastructure. Infrastructure has obviously got to be, one is the hard infrastructure of facilities, places to arbitrate, internet, access, etc. But very importantly, an accessible local bar, which understands the need for the arbitration, the needs of somebody who is not resident and naturally familiar with that place. While you may have familiarity with a place like Singapore or Hong Kong from our visits, but it's important to have access to a local bar, which from a litigation standpoint is in a position to provide you the requisite cost-effective support for purposes of conducting the arbitration there. And I think that's again a very important ingredient. And then certainly you need to have other softer facilities. I think it's only fair. Arbitration is done by lawyers and by clients. All of us like to be in nice hotels. If you have a nice place to work with, you have a nice place to spend some time with, some restaurants. I think it's important. I don't mean to sound, make this sound frivolous, but I think it is important that all these various ingredients must come into place. If you have a location which is, has the best law and the best courts, but does not provide you with a decent environment, I would be very surprised if people flew all there for purpose of an arbitration. If you had a place which has the best hotels, great sea, I mean, Maldives is wonderful, but I don't know how many people would want to go and arbitrate in Maldives, because I don't think you'd find time from the distractions of the sea and diving to actually arbitrate. So all of these things have to sort of fall into place in order for something to become really a center. I won't call it the epicenter, but the center. And as I said, even if it can't be a global center, I think if the aspiration is even regional, I think that's dramatic enough to make a difference as things move on. Then there are other issues, the ability to move in and out, the ability to get visas easily, the well-connected geography is important, access to flights, the ability to be conveniently located. Maybe over a period of time technology will change a bit of that. But I think we can't ignore the fact that, again, to be realistic, when you're looking at yourself, or any country is looking at itself as a center, it can't just say, I've got great laws, I've got great lawyers, but by the way, flights are very difficult to get, visas are very difficult to get, our airports is a problem, local infrastructure is a problem, but we have a great law. Please come and arbitrate here. I don't think it's going to happen. So all of it has to be put together and as a package. So I think in summary, is Asia going to become a global epicenter? As I said, aspirationally, it's great to have aspirations, and I would hope to see that it could. But I think in the short run, even if it becomes a regional center and we stop exporting arbitrations where a counterparty is in one of these jurisdictions, I think that is enough to continue to make this grow as a region. And each of the countries in that region have a great opportunity to get onto this very, very exciting opportunity and make themselves a part of that regional package and offer good alternate dispute resolution facilities. Thank you.
Good. I think it's important, if you might describe them as the hard and the soft infrastructure that goes into an attractive arbitration destination. Those are interesting points that flagged by Mr. Ajay Bahal. We now trying to correct the gender balance a bit. So. Otherwise, it would have appeared to be somewhat arbitrary, this attempt to find the right atmosphere for arbitration in Asia. So may I invite now Ms. Farishte Sethna, who's the founder and managing partner of DMD Advocates Mumbai. The floor is yours.
Her Excellency Sheikha Haya Rashid Aya Al Khalifa, Panel President Mr. Khurshid, esteemed co-panelists Mr. Wade, Mr. Tucker, Mr. Bell, distinguished members of Judiciary, distinguished arbitrators, esteemed colleagues, ladies and gentlemen. It is my privilege to address this august gathering, all of us present here today with a keen interest in evolving the road ahead for India and Asia within the realm of international arbitration. Whether our interest emanates from functions discharged as members of judiciary, tasked with adjudicating upon matters concerning international arbitration, or as members of international arbitration tribunals, or as members of domestic arbitration tribunals proposing to migrate into international arbitration tribunals, or as practitioners at the arbitration bar, or as general counsel to corporations engaged in arbitration. The common thread that binds us all here today is the spirit of our desire to ensure due discharge of bounden duties in the quest for justice, and eventually ensuring that India finds its proper place in the world of arbitration. With the growth of international arbitration in Asia having been carefully nurtured over the last, in my experience at least, over 2 decades, Asia's rapid growth as an arbitration hub, aided by robust levels of professionalism displayed by diverse institutions, including, of course, the SIAC, the ICC as well, and therefore both regional and non-regional, in providing requisite infrastructural support, has led to exponential requirements for international arbitration in this part of the globe from that which had previously prevailed. The Asian story has, without a doubt, led to an experience that has, in my opinion, been ranked as largely satisfactory, and to most that I have had the privilege of interacting with this morning, overall categorized as successful. Of course, I admit there is a long way to go. But the question I ask myself, having heard our Chief Justice of India, having spoken to where it is that India is likely to rank, and I believe that he started with saying that it appeared impossible, but he was extremely optimistic about ensuring that India finds its proper place in the world of arbitration, and he did express very clearly that at some point in time we must certainly get there, and he said that in his opinion India was quite clearly the obvious choice in the region as far as leading the road as far as Asia is concerned again for arbitration. I would think that I completely agree. I think those words resonate extremely close to everything that I have certainly stood for insofar as concerns India's role on the international map of arbitration. The fact that we have increasingly had diverse international arbitrations take place in India, and of course I'm talking specifically in the realm of the commercial space. The fact is that we've had multiple nationalities coming into India for seats in India, and of course multiple nationalities traveling to Singapore and Hong Kong in the last decade and over, in fact longer, which very clearly shows the clear migration, if you will, of the arbitration circuit, if you will again, in a direction which certainly is warranted given the economic growth of the region generally. Diverse challenges in the process, no doubt, have been encountered, leading to a requirement to mitigate those risks that would inevitably come our way, whichever the form of dispute resolution process for that matter. When it comes to matters arbitration, I'm sure we would be unanimous here in identifying amongst the key challenges that the foremost lies in the constitution of the Arbitration Tribunal itself. And to my mind, if that challenge were to be suitably and swiftly addressed by India, which I must say has its own diverse pool of arbitrators and excellent minds, particularly our retired members of judiciary, what they bring to an arbitral tribunal, I would think, is unparalleled. Once that threshold requirement is satisfactorily addressed, the road forward in an international arbitration must necessarily become sufficiently streamlined. Ladies and gentlemen, whether it is an ad hoc arbitration or an institutional arbitration, as we well know, the choice of the constituent members of an arbitration tribunal is either left to parties entirely or to members of institution who will effectively be tasked by virtue of the institution rules to nominate our arbitrator, or for that matter, to leave it to the parties entirely, particularly obviously in the ad hoc space. Whatever that choice, ultimately, what we are concerned with is matters of independence, impartiality, neutrality of our arbitrators. And I'm proud to say that India has most certainly, through its 2015 amendments, taken the lead as far as defining what it is that would be required to ensure that conflicts are minimized and obliteration virtually, annihilation, if I may use that term, of justifiable doubts around the appointment of an arbitrator. While I may not necessarily subscribe to every last letter outlined within those schedules that we now find in the Indian Arbitration and Conciliation Act 1996 as amended 2015, as necessarily tantamounting to potential conflict zones, one thing is clear, and that is that India means business. India is, therefore, plainly, to my mind, a front runner in establishing itself as a jurisdiction which will prove an efficacious remedy as far as arbitration is concerned going forward. And to my mind, India, through the judiciary as well, has taken significant steps, including through the Balco judgment in particular, to ensure that the world at large is aware that India is serious about ensuring that there will be a very restricted challenge available to international arbitration awards. That, I submit, is a very serious requirement that needs to be built upon in India in order that India is taken seriously as a place for international arbitration. Because I must tell you that our experience as far as Singapore is concerned is Singapore outranks several jurisdictions globally, principally on account of its ability to insulate arbitrations from challenge, which therefore readily makes Singapore an obvious choice of seat for most, particularly those who would want to have the benefit of valid, binding, enforceable awards free of judicial interference to the extent feasible. No doubt, of course, you have the public policy exceptions and others, but otherwise it is clearly ultimately, having taken that long road of arbitration, and of course a shorter road now, the question that is key for an arbitration party is whether or not they would effectively be in a position to insulate that process from challenge. And that again, is why, to my mind, Balco puts India straight on the world map of arbitration. I would therefore think that if we are in a position to insulate parties to arbitration against those fundamental risks that surround independence and impartiality that India has done in the form of the recent amendments, in the form of insulating challenge that India has done through the Balco process, and of course, through ensuring that procedural integrities and timings around arbitration are suitably adhered to, which again India has done through, again, the 2015 amendments, where India has considerably reduced the time frame within which an arbitration tribunal shall deliver up its award. I would think that all of those elements, those key constituent elements, are clearly drivers to put India on the world map, and clearly, therefore, as my colleague Ajay mentioned, ensure that we don't end up exporting arbitration, which really ideally should take place here. My friend, Mr. Shaiwade, also alluded to the fact of why is it that where there are Indian parties involved, typically he has in the past encountered situations where parties would choose other than India as a seat. I would like to think, certainly, ladies and gentlemen, that that is a thing of the past. The 2015 reforms, in my opinion, have ushered in a new era in Indian arbitration, and I would certainly think that India is now ready to become that next hub of arbitration, hub of international arbitration. And clearly, we must, to the extent that all of us here, the Indian bar, could certainly contribute in that direction to certainly put us there on the map. And with every facet that would be relevant to ensuring that we have the same levels of professionalism that have previously obviously been laid out for us by the West and clearly must therefore be enshrined in whatever it is that we do going forward. I have one observation that I want to share with you as far as international arbitrators are concerned. Increasingly, our Indian courts, in matters of international commercial arbitration, and in particular our Supreme Court of India, has, as you know very well, for those of you who practice Indian law certainly know very well, international commercial arbitrations invariably, where parties are unable to find consensus and there's no institution involved, will typically go to the Supreme Court of India for appointment of an international arbitrator. I have found that there is an increasing trend, and I'm sure the judgments, as you will all have had opportunity to read, will establish that there are several arbitrators who are appointed from outside of the Indian jurisdiction. And I ask myself, why? I ask myself, what is it that would essentially cause our courts to reach out to an international arbitrator, particularly when the seat is India and/or the governing law of the arbitration is Indian? I ask myself, why is it that our Indian Supreme Court would want to nominate a neutral nationality arbitrator? And I have to say that the answer that I find is because quite clearly they have led the way when it comes to matters of international arbitration. But I ask myself again, why is it that we cannot learn from those international arbitrators as to what it is that is actually required from that international arbitrator and effectively be in a position to ensure that we ourselves create that distinguished pool that would be in a position to find ready appointment, ready acceptance by our own courts. And I talk here about the fact that we have diverse retired members of judiciary who have kindly agreed to act as arbitrators. I must say to you that there are those who have made the choice that they will not. But to the extent that we have those who are ready and willing to act as international arbitrators, I would submit that clearly our Supreme Court must certainly, going forward, very seriously consider building that pool of international arbitrators through the Indian pool that is available itself. Because in my submission, that knowledge of governing law, particularly when the arbitration is, for all intents and purposes, governed by Indian law as to the merits of the dispute, I would submit that clearly that is the best placed mind to deliberate upon and adjudicate upon your matters. And I would therefore think that if we can build that pool up swiftly, which no doubt will require the support of our Supreme Court, very clearly that would certainly propel international arbitration through the hub India in a significant way going forward. While criticisms abound generally around India, I am of the view that barring the odd arbitration, which may not complete within the narrow time frame, or have the few obstacles that one has typically seen encountered. Perhaps the time has come for us to ensure that expedited procedures and practices inculcated in arbitration will eventually usher in a new procedural regime for the best advantage of all and the greater good generally. I would therefore safely venture to conclude with putting on record that India's legislative framework to ensure that it is treated as a serious contender in the arbitration world globally has imposed a burden upon all of us here jointly to ensure that it is discharged fairly and fearlessly in a manner that will foster arbitration in India into an unassailable legal remedy. Thank you, ladies and gentlemen.
Well, thank you very much, and thank you for flagging these important points, such as why do we need neutral arbitrators in cases where the Supreme Court has taken upon itself to appoint such neutral arbitrators. And it's also flagging the important point that the amendments that have come have indeed introduced a whole new ball game, that we have moved several steps forward towards living up to the promise of being an ideal emerging epicenter for arbitration. As you can all clearly see, that our panelists are largely focused on India, although we are really dealing with a much larger region, and perhaps there will be another occasion when people from China, indeed from Hong Kong and Japan, might want to emphasize a broader perspective than what we would naturally be gravitating towards as Indians. But the field is open, so if anyone has suggestions about other possible destinations within Asia, we would in the question answer session take those as well. Final speaker on the panel then is replacement speaker, but I'm very pleased that he's here, Naresh Thakur from the Economic Law Practice, who's stepping in for his colleague Sohail Nathani, who is not well, we are told. We wish him a quick recovery, and we give you the floor.
Thank you so much.
Honorable Justices, Her Highness Sheikh Haya Rashid Al Khalifa, Chairman, my panelist, and friends. When you are the last speaker on a subject of this kind, you have the least to speak. I actually have a mind of, thanking all of you and going back to my seat. But no, I will have my time under the sun, and I will certainly speak. So, just to begin with, we did hear from Shai an international perspective of what, and how the international arena is looking at Asia as a global arbitration destination. I thought at that point in time I had a lot to speak after that. Then came Ajay, and Ajay spoke about global, regional, national, and I thought to myself he'll stop at global, but no, he didn't. And Farishta finally put the final nail when she spoke about national, because that's the last thing that I thought was on the table for me to speak on. And I would speak certainly about the national part of it. But nonetheless, let me try and put all of this together. From an international perspective, when you look at Asia, what is it that you are actually asking for? What is it really that makes arbitration that magnet where disputes and certainly where parties who are actually in contract with each other want to actually go into a dispute mode, but in a more informal way, I wouldn't call it a non-legal way, because certainly there is a lot of legalese involved in that as well, but it's a more informal way of doing, of settling a dispute rather than going the national court way, or maybe going the international way. So what is it that parties actually look for? Speed is a given, because in today's times, if you are actually doing business, and if you want to move from one transaction to the other, you want speed, and arbitration certainly provides you that. Cost, well, that is something always debatable. Is arbitration cost friendly, or is arbitration actually not that cost friendly? It's a matter of debate always, but if you run a arbitration efficiently, if you run a arbitration in the shortest possible time, and when you are efficient, you will find that the time does really considerably shorten, then yes, it can also become cost effective. Ease, certainty, enforceability, which is actually something that parties are also looking for. It's one thing to say that I will arbitrate, which is, as I said, outside the regime of the courts in that sense. But if you are going to find that finally having an award in your hand which is not enforceable, you will certainly not want to go the arbitration way, and which is where possibly Asia in the last couple of decades has come up in a big way, because you find jurisdictions like Singapore. We've heard our panelists speak about Hong Kong, speak about Singapore, and obviously we are all now focused upon India. People want to see India as a jurisdiction develop. What has happened in Singapore and Hong Kong as jurisdictions, which has really made them so arbitration friendly? They had a governing law which was easy to understand, and not just easy to understand, but also very robust. They had courts, again, extremely robust. They had systems in place which actually were arbitration friendly, and then they had all the paraphernalia in and around it to make it into a jurisdiction which will ultimately be very which would ultimately act as a magnet, as I said, for the purposes of doing for the purposes of international community looking at these jurisdictions as arbitration-friendly hubs. Yes, it is true that we are actually seeing a move from being global to regional, and finally maybe to national, and those of us who do actually the international investment arbitration bit, we do understand that nationalistic treatment at times does not work that well. People do come back and talk about the national treatment and not very fondly about that. But nonetheless, we are certainly seeing a move from being global to possibly being national. The pendulum is certainly swinging the other way now. In all of this, where does India really stand? Yes, we do focus on Asia, but special focus on India as well. We must look at Indian jurisdiction. We are all here. We do see a move now in India from the last 2 decades that we've seen. We've seen the courts interpret the law. We've seen the law per se change. You do have a law which was, we did rather have a law in 1996. Did it ease the business of arbitration in India? The real answer is no, it did not. There were interpretations of the court of the law by the courts, which actually led to a situation where maybe it had become a tedious process. The arbitration per se had become a tedious process. 2015, change in law. We are again looking at a few interpretational issues here and there, but if you have the law and if you have the lawyers, there will be multiple interpretations for certain. What we need to see is that how best is this implemented. You now have the new law. What we need to certainly see is that the interpretation of that and the execution ultimately is seamless. If that happens, then certainly we are on our way to becoming a global arbitration hub. Are we a global arbitration hub? Answer is no. Are we on our way? The answer is yes. Is it a short-term or a long-term view that one has to take. I would rather have a long-term view rather than a short-term view. What we really need to do right now is to have the processes in place, and that can only happen if we have more and more institutional arbitrations happening. Currently, large number of arbitrations, in fact, if I'm not mistaken, it's almost 95% of your arbitrations which are ad hoc. We need to move them from ad hoc into the institutional space. You heard Shai say that the 2015 Queen's Mary survey actually puts London, Paris, Singapore, and Hong Kong in that order in the most preferred seats of arbitration. What's really heartening is to see that you have Hong Kong and Singapore move quite close to what London and Paris are as arbitrational hub. Why has really that happened? One of the other reasons is the fact that there is a move from ad hocism to institutionalization, and I think that's the way that India should move. We do have great institutions being set up. Again, MCIA being set up in India is a good move. I have personally arbitrated at the center, though not under the rules, but yes, under the center, and they have some fantastic facilities, and I must say that the facilities are world class. They match the international standards. I'm trying very hard to push my clients to see to it that they bring in the MCIA rules where at least 2 Indian parties are concerned. And why not? If you look at the rules and if you study the rules are actually as per global standards. Obviously, how it will ultimately pan out in terms of execution is something that we need to wait and watch. But yes, they are good rules to arbitrate under. And yes, we must move into the regime of institutionalizing arbitration rather than doing it ad hoc. Once we have the processes in place, then I'm certain we will be one of the centers to look out for insofar as arbitration is concerned. As Farishta rightly mentioned, we do have a very robust panel of arbitrators or a pool of arbitrators. We need to grow that pool of arbitrators exponentially if we really want to become the hub that we are talking about. At the same time, we will also require arbitration practitioners. Today what really happens is that people who practice litigation practice arbitration as well. And if you really want to make arbitration as your profession, and I am conscious that I'm using the word profession when ultimately being a lawyer is your profession. But within that also you need to decide for yourself what you really want to do. Do you really want to have the litigation practice and be a part of that, or you want to do arbitration, which actually should run on a day-to-day basis? In my view, it should not be either a weekend arbitration or an evening arbitration. Once all of this happens, then certainly we'll see ourselves moving in the right direction. We have taken the first step. Hopefully we'll go all the distance. Thank you.
Thank you very much, and that clearly, I think, brings out the facilities, the standards that are already available, and the few things that need to be added and fine-tuned that will certainly bring us on par. We are running a little bit late, but we will have to have some questions. Before that, because there were some points that were left, Mr. Wade had some points left, and you thought that those are the gaps that remain. So if you would like to flag those points, then we'll have a full and a comprehensive picture. There must be a... Yeah, take this.
Very briefly, I hope everyone in the audience and on the panel will be inspired to comment back. I think the barriers that remain for arbitration in Asia, both here and elsewhere, are interesting. I think there is a generational gap that in some respects we all have to breach. I know there is a strong tradition amongst my clients from here and from other places in Asia to prefer retired judges as their arbitrators. And often the best choice they can think of is an English retired judge from the Supreme Court. And my submission is, and my advice to my clients is, that very, very rarely only are such people the best arbitrators you can have in terms of advancing the speed and economy and flexibility of your arbitral process. More often than not, people who have lived in and resided in the judicial system all of their lives find it difficult to transfer into the more open framework of the arbitral process and don't use it to the best effect. Another great barrier which I think can perhaps be overcome more quickly or more easily is the infrastructure barriers which have been mentioned. So not to go into them too far, but visas is something which is an important issue. Internet speed is a big thing, not a problem in India, but elsewhere in Asia it still is a problem. And neutrality is perhaps the biggest issue. And I say this not from a point of view of a perceived bias, but think please why Singapore, Hong Kong, and London are large centers for arbitration. And part of the reason, at least in my opinion, is that Hong Kong is part of China but isn't China. Singapore is an important place for transactions in its part of Asia, but doesn't actually have a stake in many of the transactions. London, part of England, likes to think of itself as great, but is more of an annex to Europe than really at the center of Europe, and of course much less so now following Brexit. So in my opinion, what makes a great arbitration center often is the fact that it is no longer a great player in commerce. And so count your blessings perhaps that in India the economy is growing, but if you are advising a party contracting with a large Indian corporation, you may not advise them to agree to arbitration in India, not because of any perceived bias, but because it's less neutral than, say, Singapore would be, or if you're American, London would be. You try and agree on a place which is geographically convenient to both, but not in either country. So I don't know whether India can happily pursue its quest for economic greatness, which is probably more important, and arbitral greatness at the same time. But those are my headline barriers for you.
Well, that's interesting. Interesting. These are occupational hazards of growth. If you grow, then there are issues that you need to answer. Now, if the other panelists have anything to say now, I will give you the floor again, or otherwise we will ask for questions from the floor. You have something? Yeah. Then, if there are any questions from the floor, we'll take a couple of questions. Please identify yourself for our sake, and then indicate who you would like to respond.
Good afternoon. My name is Vishnu Datta, and I'm from Mind Merchants. And this question is for either Ajay or Sai. You guys talked about the location advantage of certain countries or others, and the ease of getting visas and travel issues. So my question is, video conferencing has helped a lot in communicating between different locations, but now the new technology, that is 3D virtual meetings and conferences, which is very extensively being used in conferences, meetings, or even work. So do you think this will take away the advantage of the more preferred locations and bring the smaller player into the same playing field, and also bring the cost down? Thank you.
Okay.
I think that's a very relevant point, and I did mention when I talked about geography being important and why I felt that, at the end of the day, to expect two companies in the Americas to arbitrate in Singapore may be still a bit of a stretch. But certainly technology is going to be the game changer, and whether it's 3D, whether it is the ability to do more by using technology as a means of saving cost, most certainly that is going to be an advantage. But I think, again, as I said, the package which you have to offer, the necessary ingredients have to be a package. And a part of that package has to be the access to technology. But I think, you're talking about, at the end of the day, arbitration is a process conducted by human beings for other human beings on a contract written by other human beings. And there is always going to be the need somewhere or the other for people to meet, talk, interact at some place. I know there are witness statements being done by use of technology, and that would take away some of the pain of the visas, etc. But as I said, one particular change cannot, to my mind, make a dramatic influence by itself in whether that one location is going to be the future of arbitration. It has to be the package of the 4 or 5 things that I mentioned. But yes, technology is, we believe, going to play a great role and make life easier, make arbitrations cost effective, and make travel that much less, and take away the cost that you have of people traveling and fares and hotels, etc. But can't be a game changer, to my mind, by itself without the rest of the ingredients being satisfied by a particular country.
And if I may just add to that, I completely agree with what Ajay says. Yes, you will have technology taking over a lot of stuff, but so let's say a procedural meeting really need not take place, and especially in an international commercial arbitration, it makes no sense. In the domestic sphere, it makes no sense to have a procedural meeting, which will possibly last for 15 minutes or not more than that, or maybe at best an hour. And people travel in from different jurisdictions just for the purposes of that meeting. It does not make sense. But let's say something like a cross-examination, and I have personally conducted a cross-examination over video conferencing, and it really, to my mind, does not bring out the human element which otherwise a judge would be able to see, namely the demeanor of a witness. What a witness would, and you depend a lot in a cross-examination, not just on the questions that you ask, but also on the answers that you get. And on the answers that you get and the demeanor of the witness that you have, a lot would turn maybe on that. And that is certainly not the human element that Ajay spoke of. That certainly does not come through when you do it over video conferencing. So yes, technology is an important part of today's times, and therefore a part of arbitration as well. But will it completely do away with the human element? I don't think so. And it ought not to my mind.
Yeah, no, nothing to that. Moses, you're not really qualified, but to ask a question.
Yes, I'm not a lawyer.
I'll give you the last question.
I'm not a lawyer, but therefore I will be more articulate.
Not for that reason.
I heard some of the speakers, including Mr. Ajay Bail and Madam Setna and Honorable Chief Justice. They were all talking about India graduating to the highest levels, place in the sun for India as an arbitration seat. I wonder if before we try to go to the top, whether we can do, for instance, collaborations. I know there are informal collaborations, I'm told, going on between different centers, maybe a big center with a smaller center around, which is not publicized. On the other hand, there is the Dubai Financial, not the Dubai DIAC, but Dubai Financial District Arbitration Center, which is now, they do it in collaboration with the LCIA. So why shouldn't India look at a via media, try to collaborate with other more established, more successful arbitration seats, and then try for itself to be there, up there? Thank you.
So who do you want this reply from?
Yes.
Well, I think it's nobody would have a problem with it, except that every arbitration center would want to expand its own footprint. provided it's attractive to go to that destination. But since we have a highness here, I mean, I think that bilateral or trilateral collaboration or institutional collaboration is something that's entirely welcome. I'm not quite sure that I know of any such collaboration having happened already, except very informally maybe. But if you think that out of this conference, at least this idea can germinate and this can possibly grow, and one example might be India and Bahrain, because that's possible because of the presence of people. It'd be a good thing, and it'll be a feather in your cap if you have one. I mean the cap. One more there. So yeah, sure. Please.
I'm Faisal Syed. I'm an entrepreneur and probably a consumer of arbitration. Based upon that, probably Setna, I'll have my observation to you. Because there is so much of emphasis going on towards India at the moment, is the consumer, which is that you refer as clients, are they really mature to use arbitration to the fullest extent? And should, as leaders of law, do you guys have responsibility, and a platform like this, which GDR has conducted, also has an onus to educate the consumer and make them utilize arbitration to the fullest extent? There I would just add my personal observation of, especially doing a lot of cross-border transactions, encountered a lot of emotions that gets involved in family-run enterprises in India, which probably may make it difficult, unless educated by lawyers like you all, to take out emotions and deal with arbitration as a platform for the fastest and best resolution.
That's for you, I think.
Thank you for that. Am I audible? Well, I must start by assuring you that arbitration is really a parallel dispute resolution mechanism to that which you would otherwise be entitled to avail through the system of courts of law. And what arbitration is intended to do is to essentially simplify and swiftly deliver dispute resolution to parties to that dispute. In that sense, therefore, there is no significant difference, if I may put it so, between your filing a suit in, say, the Delhi High Court, or going over to what would be a panel of arbitrators or arbitrator, as the case may be, whether sole or three-panel usually is what we have in our system, to adjudicate upon your dispute. Arbitration primarily is a mechanism which is, by virtue of creature of parties, no doubt fully sanctified by the relevant statutory mechanism that effectively gives to it the legitimacy, the validity, and the enforceability as a matter of law. Because obviously at the end of the process you need to be sure that you will be in a position to have the fruits of your labor in the form of the award, if of course you have succeeded in that process. So I would think that to your question as to whether or not the average Indian consumer is mature to have the benefits of the arbitration system, quite clearly, if that average consumer has no option but to go to court, is arbitration an alternative avenue? Of course it is. It absolutely must be. And the question then is, when you really weigh it up, which is courts versus the arbitration process, typically the reason why arbitration is bound to find ready acceptance is the fact that it is a tribunal of your choice primarily, because A, you get to nominate the arbitrator, or at least your nominee, and so you have faith in that individual to effectively look at your facts and facilitate the delivery of justice. B, you have the advantages of having specific dates that are allocated to you as against your having to live in the hope of a date from the court system. So quite clearly, those ready advantages that are available to you. And C, you have eventually the validity of that award available for you for ready enforcement through our courts, which have increasingly developed an anathema towards permitting for interdicting an award. So I would think that given all of these different facets around an arbitration, and most importantly, the increasing disinclination of courts of law in India to interfere with arbitration processes at any stage, way, shape, or form, I would think that, as a matter of fact, arbitration is the future of dispute resolution. It has been for several, and it must inevitably, in any commercial contract, most certainly be the way forward as best afforded by the parties that contract. And I think, as I said earlier, that India affords that full-blown remedy in an extremely evolved manner, because arbitration has been here since, as somebody here this morning mentioned, since the 1940 Act. I think it was Chief who mentioned, since the 1940 Act, we've sort of been active in arbitration. It's here to stay, and it's clearly the way forward. So, yes, we do have a mature space. Arbitration is the way forward. Do please embrace it.
Thank you. I think we'll let that be the last word, only in deference to the next lot of panelists, and I think it would be unfair. We eat so much into their time. But if you have a question, we're continuing with arbitration, so that question perhaps can a little modification be placed to before the next panel. Thank you very much for your cooperation. I am sure that we've started well. Now we go on to the other sessions. Thank you, and I invite the next lot of panelists to come. Thank you.
Thank you, sir.
Ladies and gentlemen, we'll start with the next session shortly. 5 minutes. But a quick announcement before that. We are trending on Twitter, so you can tweet about the event with the hashtag EAAS 2017. We'll start with the next session in the next 5 minutes. Ladies and gentlemen, kindly be seated for the next session. I'd like to invite the chairman and the speakers to please take the dais. Also, you can watch the live streaming of this event at the Global Dialogue Reviews website. We're streaming live since morning. So we're starting with the next session. The theme is Challenges in Arbitration in Terms of Technology, Delivery and Cost. The chairman of the session is Dr. T.K. Vishwanathan, Director, International Center for Alternative Dispute Resolution, New Delhi. The panel of speakers are Dr. Nicholas Weigand, Managing Partner, CMS Hong Kong, Mr. Ashish Chandra, General Counsel, Snapdeal.com, Mr. Naresh Thakur, Partner, Economic Laws Practice, Mumbai, and Ms. Jaspreet Kaur, Associate Vice President, Client Management, Mine Merchants Global Private Limited. I request the chairman to kindly start the session.
Good morning to all of you, distinguished panelists, my beloved minister whom I have interacted with him in different capacities, both myself and him, he as a law minister, then as a corporate affairs minister, then as an external affairs minister, then me as a law secretary, and then as a secretary general. I recollect many fond incidents where we collaborated, and I'll mention them shortly. Her Highness Haya Rashid Al Khalifa from Bahrain, and distinguished audience. My credentials to speak on this topic of arbitration is somewhat very hilarious, because I started way back in 2000 looking into this Arbitration Act in the Law Commission of India. When the present finance minister came to us, he was a law minister then, I was a member secretary of the Law Commission, and then he made a request to Justice Jeevan Reddy, you have a look into Section 9 of the Arbitration Act, there is some problem, interim relief. So we had at that time two judges, Justice Jeevan Reddy is a chairman and Justice Jagannath Rao is a vice chairman. We started looking into that. Then Justice Jeevan Reddy felt it's too early to look into this act. It's only 1996, 4 years have passed, then can we have a relook at it? But then there is a Supreme Court judgment which is causing problem. Then when we started it, then the work went on, and as it is with Justice Jagannath Rao, you might have known him, he goes very deep into this whole subject, and as a draftsman, I was available. He went into a deep surgery. We came up with a 100-clause amendment to the entire Arbitration Act in the course of my time in my law commission. Then one thing it struck to me odd was that we might have blundered in trying to mix up domestic arbitration with international commercial arbitration. Good, UNICITRAL model law was good, but we should have not thrown overboard our experience of the 1940 Act. I think that somewhere we blundered and we are not able to come out of that. It was too late, and we tried to see whether we can have a separate act for international arbitration, but then it was difficult to come out of the mess in which we have landed. Then I came down as a legislative secretary. I moved this proposal very forcefully, and I brought the bill into Parliament in 2004. You may remember. And then this went before the committee, Nachi committee. Then we had the president of ICC, Brenner. All of them came and gave evidence, and they said it's too intrusive, and we have to relook at the whole bill. So we withdrew the bill. As a legislative secretary, I withdrew the bill. Then I moved over as a law secretary. Then I started the consultation process. We issued a paper on consultation. We had many conferences in ICDR everywhere, and nothing was moving. By 2009, I moved out of the law ministry, and then I still continued to be called for speaking on conferences on arbitration, then it looked as if I'm just posting something which is not happening. So I stopped attending conferences. Ultimately in 2015, something has come out. Now let me first share I've been in government for too long. I've been in different capacities. I've seen them from working from close quarters. The whole defect of our whole arbitration jurisprudence is we lack empirical data. I try to collect data because they say arbitration is a private thing, confidential, awards are not available. So how do you develop a body of jurisprudence? But then we have the public sector undertakings which are having a very vital stake in great arbitration, international arbitrations. I said, let me gather some information from the PSUs. So we sent in a missive as a law secretary to all the PSUs to share information. For the past 10 years, how many arbitrations you have conducted, who are the law officers, who are the lawyers, law firms who were employed, what was the outcome of the award, etc. Strangely, you will believe, all of them resisted parting with the information. They said, if we have autonomy, we will not yield this. The ministry said they are not yielding. Then we held a meeting in the cabinet secretary's room. And the cabinet secretary himself told me, these people are very resisting. Why you are asking for that? I said, need information. Public money is being spent. We are not sure how the Arbitration Act is working. Let me go through it, but I didn't succeed. Even now, the parliamentary committee looking into this also sought information. They were not trying to get that. I'm on the point of emphasizing that most of the evidence, most of the talk which goes about the failure of the Arbitration Act and why you are not taking off in the global, as a global arbitration have, is most of them are anecdotal evidence, not empirical data, which is lacking. Now, come back to this opportunities which are posed, the theme of the conference. The theme of the conference, Emerging Asia Arbitration Summit. India stands in a very vital crossroads at this point of time. 2008, we went to PCA, the Permanent Court of Arbitration in Hague, and India has a MOU with the PCA. Still, it's valid. It has not been activated. We went, when the Law Minister Bharadwaj, both of us went and we signed an MOU. They wanted certain concessions for having a PCA center in India for regional Asian facility, but then somehow it didn't take off. It's still dormant. It didn't take off. Right now, I've been lobbying for the past 2-3 years a different route to adopt to make India as a hub of international arbitration. We have the Special Economic Zones Act. It was the 2005 Act which I drafted. The Act provides for international financial centers, and international financial centers, you can have specialized legal regime to deal with those entities which are established there. You can have a special legal framework by amending through the notification. I said, when you can amend the Insurance Act and the Banking Regulation Act, can also have a slight amendment to this Arbitration Act and see how foreign seated arbitrations can come to our SEZ zones and arbitrate. You have one avenue of seeing how you can build up islands of excellence. I have been writing very extensively, and ultimately it has caught on in Gujarat International Financial Center. I find in Gujarat International Financial Centers, they are setting up arbitration centers. I'm not sure, I read in the papers, because I've been writing to Prime Minister's office also. Now Maharashtra has come up with a merchant chamber. I'm told it's coming out very well. You can invoke this SEZ zone because very often they expect certain concessions, tax concessions, customs duty concessions, and various things which are visa and other things, which can be very easily addressed through this SEZ Act. It's a Special Economic Zones Act. If you really want to know what are the sections which you need to attempt, I have also done that in my separate paper. I will share that with you. Now, the theme of this present session is about technology. Technology is always challenging. Incidentally, I'm also heading another committee of the government which is looking into this video conferencing and this Information Technology Act. In fact, I drafted the Information Technology Act 2000, and I continue to be associated with that. So we're looking into the various aspects of how law should address the new challenges of technology. Video conferencing is one thing, and how do you deal with video conferencing? My previous panelists, they expressed certain difficulties in how it doesn't bring out the human element. How do you address that? But technology is changing so fast, we can't afford to be left behind. There is a concept of now virtual courtrooms or virtual presence, tele-immersion, where there is a sense of everybody being present in the same place. Now, what does it portend for arbitration? Now, arbitration already we have with this electronic marketplace, we have to have online dispute resolution. The UN is also moving ahead with online dispute, online mediation, then online arbitration is only a question of time. So we need to see how we address that. This gives rise to another area, the choice of law and choice of forum. So we are having a situation where all the national law legal systems are becoming somewhat converging or they are becoming irrelevant. Then we have to be well versed in so many other things, and the seat of arbitration itself will soon lose its significance. These are some of the challenges which are great opportunities for a country like India, which has a very vital infrastructure, backups on the internet and other things. We have, as I said, problem of judicialization of the arbitration process here, because we don't have an arbitration bar and we don't have that culture of treating arbitration different from the other judicial process. The basis of arbitration jurisprudence is what we draw it from Hugo Grotius, Pacta sunt servanda, respect for promises given. If you give promises, you have to stand by that. I think that is a basic principle which we have to follow. And then there is now the excessive, as the previous speakers have said, we have to insulate our awards being challenged in the courts because enforcement is very important. Unless you have awards enforced, nobody will come to your court. There is a strong pressure being built up for India becoming a member of EXID, Washington Convention. And we are not sure whether this annulment process will be a substitute for judicial review. We are not very sure. But I think we have to set in place a robust regime where respect for awards are given and then awards are seen very quickly enforced in this country. This will go a long way. And technology, of course, is a great boon for us. And we have, instead of the elders, the youngsters have a vast promise for taking this forward. As the minister knows, when he was External Affairs Minister, I came up to him as a Secretary General a proposal for having courses. We have the Bureau of Parliamentary Studies and Training. We conduct courses on legislative drafting and parliamentary procedures for various foreign country nationals, parliamentarians. When we were in Chile, the speaker long back, the demand was made for the speaker of Chile that why don't you have courses in Spanish? Why are you always going after English people? We want to do that in Spanish. Then you gave us some money to run the translators, Spanish. We did that course. We had from Latin American countries and 20 Uruguay and Paraguay, and they were very much keen. Then we expanded a little bit and went into Arab countries. In Arabic we did for parliamentarians. Unfortunately, now I think it's not taken forward. What I'm suggesting this because arbitration also you can bring in from these countries to India, so language may not be a problem. And language by itself, sooner or later, will lose its significance because everything is codified and communication can be extracted in any language you want. We are reaching that stage. I leave it to the fellow panelists to reflect upon what are the challenges and opportunities this technology will facilitate us to become a whole global hub of arbitration. And I thank you for having given me this opportunity to share some of my thoughts. Thank you. Now I request Mr. Nicholas Viga.
Thank you very much, Mr. Chairman. Dear members of the judiciary, dear Mr. Khurshid, dear Her Highness Sheikha Haya Rashid, thank you to my co-panelists and the organizers for putting up such a great event. It's our pleasure to be here. I realize the time is not really, we're not really on time, let's put it that way. That's why I would like to talk today about one issue that is also part of our topic here. It's not technology, but I will focus on time and costs of the arbitration, which is a big challenge, which we are all facing these days. As you can see, it's already 1:10, and you should all be at lunch. Instead, you're listening to us here. This is a problem you'll face in many arbitrations as well. So we've heard a lot this morning about how can India, as an emerging arbitral seat, become more competitive on the international scene. It accounts not only for India, for all emerging markets in the international arbitration scene. How do you compete with established seats? And one of the issues, of course, one of the problems international arbitration is facing these days and in international context is the cost and the time and the cost of the arbitration. We are seeing a major concern with clients about the costs involved, and we're seeing clients turning away from arbitration, not agreeing to that anymore. And that's why I would like to address this topic in this context today, because for an emerging seat, it is so important to address this concern for the parties to make sure you're an attractive option compared, for instance, to London, to Paris, and to other established seats. It's also one of the reasons why we have seen Hong Kong and Singapore rise. They were attractive options, attractive alternatives to the very expensive traditional European seats. So, can you go to the next slide, please? We've also heard a little bit already. Oh, it's there. Thank you. That's not the slide. About a 2015 international arbitration survey conducted by the Queen Mary University. We've heard that Hong Kong and Singapore came in third and fourth as the most preferred seats. But one key aspect of that study was also the costs. And the clients that were interviewed for that study said that costs and delay are amongst the worst characteristics of international arbitration. That's a worrying message when you work in international arbitration. I'd like to raise two questions in this respect. First of all, is it true? What is there really a better alternative? And second, what can be improved to make sure clients don't think that anymore? Now, to the first question, you will see here that while the perception is that it is among the worst characteristics, it's not entirely true that it's worse than state court litigation. On the contrary, if you look at this time and cost graph here, you will see that arbitration is always better than state court litigation, in particular when you go to expedited arbitration. But in any case, court litigation in your home or in a foreign jurisdiction will always, in the end, in particular, if you consider the instances you can go through, be more expensive and take longer time. The question, of course, arises if that's the case. Why does arbitration have such a negative image? I think there's three reasons for that. The first reason is, of course, the parties' expectations. Parties are told by, the users are told by lawyers, and they read maybe in some not very informative journals that arbitration is cost-effective and quick time, a quick resolution, and you will save a lot of money and a lot of time. While that is true to some extent, is of course not entirely true, because if parties read that and then think, oh, this is going to be much less expensive than state court litigation, they come into the proceedings with that expectation, and it's simply not true. Of course, it can be more cost-effective, but it will still cost a lot of money. So I think it's a lot about managing the parties' expectations. What can you expect in terms of costs in an arbitration. The second point, of course, is parties are not stupid. They see what happens during an arbitration. They see that there is a lot of room to save some costs and time during an arbitration proceedings. And I will address one aspect very briefly later. There are many. Given the time limit today, I will only address one. And the third point, of course, is a misperception of who can remedy the problem. Again, Queen Mary's survey, this time the 2010 one, revealed that the parties are largely responsible for cost and delay. However, the users were also asked how can it be remedied, and the users said the institutions need to solve the problem, which is of course a contradiction. You will be familiar with the typical cost structure of an international arbitration. This is what it looks like. I'm afraid to say that the institutional and arbitrators' fees are really not what you should be looking at when you try to reduce the costs of an arbitration, but it is definitely the parties' costs. The ICC has come to the same conclusion, unsurprisingly, in their recent report on controlling time and costs in arbitration. This is a summary of their most pertinent results in this respect. I'd just like to point to the third bullet point here, where you can see that the ICC identified unfocused requests for disclosure of documents and unnecessary witness and expert evidence as the two main cost drivers which need to be reviewed if you want to look at reducing arbitration costs. This is very well illustrated in the next graph, and I'd like to take a minute to explain that to you. As you can see, an arbitration starts out mildly when it comes to costs, and parties will be happy. Even the request for arbitration, the answer, and the whole initiation proceedings is, on a cost basis, quite okay. But then you see the first peak here, and this first peak is the document production, which usually takes place in a standard international arbitration these days. And there are more aspects, for instance, expert evidence, which we could talk about. But for today, for the purpose of today's session, I'd like to focus on this one issue, and that is the document production process, which, and again, bringing it to the context of this conference, can be maybe remodeled in a new emerging arbitration venue in order to become more effective and more attractive to users. So why is the document production so expensive in an international arbitration? It is true we don't have US-style discovery, I must say, fortunately, in international arbitration. I hope there are no US lawyers offended now in this room. But even though it is not a US-style, very broad discovery process, still, if you look at this graph, it's still very, very expensive. And of course, the question is, why is that the case, and how can you improve it? If you want to improve something, you first need to look at the status quo, of course. So what is document production in an international arbitration typically like these days? As a starting point, and that's very, very important, you need to remember it's the parties that lay down the rules for their proceedings, and meaning also the rules for the document production. So the costs are in their hand. The parties, together with the arbitrators, can model the proceedings in the very beginning, of course guided by the institutions and by the legal environment at the seat of the arbitration. And that's where the opportunity maybe for Asia as a whole comes these days. Where does the problem we're facing come from? While it is in the parties' hands, typically in an international arbitration, you have parties from different legal backgrounds. So you have a clash of views. You may have a party from the US or from England, which are used to very broad, or at least broad discovery, document disclosure. And you may have a party from a civil law country, from like China, for instance, or Germany or France, or other continental European countries. So this is your typical international arbitration. Or think about all the other countries in Asia, in Southeast Asia, most of which are of a civil law background. You will get two parties that expect something completely different. And this conflict of course, needed to be resolved, and it has been resolved by the international legal community by compromises, and all of you will be familiar with the most prominent compromise, which is, of course, the IBA rules on the taking of evidence, which tries to set a standard, a common ground between civil law and common law traditions, in particular also when it comes to document production. So you could think, okay, a middle ground has been found, it's cost effective. The contrary, of course, is the case, as you've seen earlier. The IBA rules may be good, but they are also a convenient excuse. The biggest problem with them, of course, is they are very open to interpretation, and every party, especially if you come from different legal backgrounds, will interpret the rules differently. What is the result? The result is that, I think you all know, a best practice or standard practice for conducting an international arbitration, including the document production, has emerged. And this best practice, clearly, if you look at the complaints, the results of the survey, and the earlier graph, doesn't solve the problem. Rather, it's very convenient for the parties and the arbitrators at the beginning of the proceedings to simply refer to the IBA rules and to set out a standard, a boilerplate procedural order number 1 with a boilerplate provisional timetable providing for document production, not further specified, and ideally using a reference schedule. Now, I said earlier, this has several potentially negative consequences. First of all, the parties may have a very different interpretation of what the procedural order number 1, of what a reference schedule should look like, what should be in there, and how, in particular, how extensive should it be. You may have one party that submits just a single document request or nothing at all, while the other side submits 100 pages. That, of course, then leads to further problems, lengthy proceedings, good luck, and of course, I must say that is a rare case that one party submits only very little while the other side submits a lot. The most common case, of course, is that neither party wants to fall short of what the other party does, so you rather submit 100 pages just to make sure, in case the other one submits as many, you're not behind. So the result really is, from today's standard practice, you submit too much, too broad requests, and the costs remain high. I can testify to that. We had a deadline for a document production request which had to be filed yesterday, and the client told us explicitly, well, we don't know what the other side is going to do, make it as broad as possible. So that clearly doesn't solve the problem. So what can you do? I'll just try to very briefly sum this up for what I suggest a new emerging seat or emerging region for arbitration may consider in improving when it comes to document production. My submission is you should, when you submit document production requests, or rather at the very beginning of the proceedings, the parties and the tribunal should be very clear that the burden of proof is used as the controlling factor for any document production, meaning that a party is only allowed to request documents from the other side in support of a fact pleaded by this party and for which it bears the burden of proof. What does it mean? What are the consequences? First of all, you exclude all the material that relates to facts or discussions or legal arguments that may be undisputed. That's all out. Second, you reduce it, you also exclude materials relating to facts that need to be proven by the other side. And I'll give you an example. Why, for an example, do you need to request, for instance, correspondence from a certain person for a time period of 3 years just to show that an allegation made by the other side does not find support in these documents? It's a negative issue you're trying to prove. And if that's the case, if you're right about this assumption that the other side makes an allegation, but there's no proof in the record for that, you don't need to review a truckload of documents for that and tell the tribunal there's nothing in there. All you need to do is say in your submissions, well, the other side has alleged ABC, they haven't substantiated it, there is no proof for it, and if that's the case, you'll win on that point. You don't need to request this negative document request. If you reduce it to the points you need to prove, you will really exclude quite a lot. A second point is you also significantly reduce fishing expeditions by where parties try not to prove their case, but try to build their case through a document production. If you limit the requests to such which are in support of an allegation you make in your case and for which you bear the burden of proof, then these very broad requests where you hope to find something which then changes your entire case and you build your case upon are excluded. That doesn't mean that you're cutting the right of a party short to produce evidence. Not at all. The party can present its entire case and can still present all the documents and evidence it wants in support of its case, which simply means you're focusing the document production as a matter of proof. Sorry, I'm trying to get this quote in. No, next page is good. To a matter of a party proving its case, but not building its case. This is a quote made by Professor Tercier, of course the former president of the ICC, quite a while ago already, and I think it is a very wise statement. It means that you still get all the documents you need, which the other side may have and you don't have access to, if you have a case and try to prove it, but it doesn't mean that you get the opportunity to burden the tribunal and the other side with very broad fishing expeditions. Now, just a very few practical suggestions how to implement that. I think the current best practice simply needs to be reconsidered, whether it really is the best practice and whether it's really smart to use a boilerplate procedure order number 1 and standard reference schedule in each and every case, or whether, especially in this region now where there is a lot of mixture between civil law and common law backgrounds, it's probably more than in any other part of the world that you will find international arbitrations where parties from both backgrounds meet, and this is a chance to establish a new best practice. And my suggestion would be to reduce the document production by adding separate columns in the typical reference schedule used, one for which specific factual allegation is the document I'm requesting linked to? Is this factual allegation relevant to my party's case? And third column, do I really bear the burden of proof for this very allegation I'm trying to support with this document? And in the last slide, you will see just a short example of how I could imagine such a extended reference schedule would look like. It has more columns, I admit, but I would assume, especially that through this last column party bearing the burden of proof, it will get much, much shorter in terms of pages. I can tell you that the longest reference schedule I have ever seen was 496 pages, and the last objection on the very last page at that time I was on the tribunal side, at that time from one of the counsels was, he didn't even object anymore, the typical like privilege or anything. The only comment was, I'm losing the will to live. And I hope that if we implement maybe this amended schedule, we can try to make more lawyers survive. And as I said earlier, my starting point, maybe have Asian seats using it's just one suggestion in document production, there are others, become more attractive compared to traditional seats in terms of time and costs of an international arbitration. Thank you.
Thank you, Dr. Nicholas, for your valuable insights. I hope all the institutional arbitrators will take note of your issues which you raised here. I think they are very valuable. I request Mr. Ashish Chandra to now share his views.
Mr. Chairman, my co-panelists, dignitaries and friends. I will cover two topics and I'll try to restrict myself to 10 to 15 minutes maximum. My two topics are, number one, online dispute resolution, and Chairman Sir did speak a bit about it. I'll share my personal experiences in implementing online dispute resolution in consumer internet industry, because that's where my personal work experience has been. And second topic would be use of artificial intelligence in efficient justice delivery system through arbitration, and could possibly argue that with good use of artificial intelligence, how can we completely reduce our dependency on lawyers as well as on arbitrators. Don't kill me for that. I mean, we all know, and I can't really argue with anybody in terms of the growth of the consumer internet in India, whether it is for e-commerce or whether it is for the online payment industry, and and the kind of potential it has to grow more and more. But I think the real test of your consumer delight, whether it is for e-commerce or for online payment, is when your customer is facing a problem, right? The customer can face a problem with his counterpart who has sold the goods on the online platform, or or let's say with a person who has paid for a particular transaction by, let's say, using his or her mobile wallet. Or that dispute could also be with the payment service provider, right? So how do you handle the dispute? So then we have online dispute resolution, which comes more handy. And the online dispute resolution has already shown its importance in terms of cost and time efficiency when we see disputes in terms of domain names. We all know that in case you believe that your domain name is squatted by a cyber squatter, you can initiate online dispute resolution in WIPO. And I'm sure that most of you would be aware of that the time taken to resolve the dispute is not more than 45 to 60 days. And the cost which I have personally incurred, including the Indian Legal Counsel cost as well as cost of WIPO and the arbitrator, don't exceed $8,000 to $10,000, and you get the dispute resolved in about 45 to 60 days. So that's an institution which is there, which has resolved hundreds and thousands of disputes on domain name. In India also we have National Internet Exchange of India, which basically administered .in your names, and all your .in names which are now to be disputed are adequately handled through online dispute resolution through NIXI. Very recently in Delhi High Court, a case of google.com versus googly.in was also resolved, although it got escalated to the High Court. But at the first instance, it actually got resolved through the online dispute resolution forum at NIXI. And coming to my personal experience in terms of handling online dispute resolution in the consumer internet industry. So I used to work for eBay in India, and I'm talking about somewhere in 2005 onwards. And at that point of time, we were growing very, very fast in terms of pan-India presence for e-commerce. And since the e-commerce ecosystem was not very efficient, and we used to see a lot of consumer dispute between the buyer and the seller. So we have actually implemented online dispute resolution systems, which basically reduce the time and the cost of resolving the complaints either of the buyers or of the sellers. Then we did implemented the similar systems for their payment gateway called as PaisaPay. And then subsequently, when I came to work with Snapdeal, we also have implemented some sort of online dispute system to address the concerns of the buyer and the sellers. And same we did for freecharge.com, which is the online wallet system. Now, if you ask me, the legal ecosystem in India to really implement online dispute resolution system and to improve it is already set in place, right? We have our parent act, which is your Arbitration and Conciliation Act, right? It clearly provides that the Evidence Act rules and the Civil Procedure Code does not apply to the dispute resolution process which is conducted under the Arbitration Act. So, anyone who want to implement the online dispute resolution system, which will have its own unique way or peculiar way of submission of the evidences, whether in writing, through video conferencing, through Skype, or through something else, I think the law basically provides for that flexibility. And similarly, I mean, most of the online terms and conditions, I mean, they are not signed, but they are in writing, and you can have a good arbitration clause in that, because our arbitration law, I mean, does not say that the contract has to be in writing and signed for the arbitration clause to be invoked. It says that the arbitration USA agreement has to be in writing only. And I mean, we have the Information Technology Act, which basically provides for attribution of the electronic records to a sender or to a receiver. We have Evidence Act, which in case any of the record is to be challenged in the court of law, does have the provisions which basically talk about admissibility of the electronic records. So, these are the important laws, very, very basic law, which I think are already in place in India to create a very robust ecosystem for the implementation and growth of the online dispute resolution. Now, to be very specific to e-commerce and to online payment, I will first talk about online payment. So online payment, the grandfather law is the Payment and Settlement Systems Act. And if you talk about the online intermediary guidelines, which are issued by RBI, which sets the entire legal ecosystem for making of the online payment for online transaction. And we have prepaid payment instrument guidelines by RBI under the PSS Act, which basically gives the rules for the online wallet, or what we say mobile wallet. In both these rules, RBI does provide the flexibility to the payment system operator to have its own kind of consumer redressable rules in order to very quickly address the concerns of the consumer. So the industry-specific laws, which is Payment and Settlement Systems Act, the Intermediary Payment Guidelines, the Prepaid Payment Instrument Guidelines for the online payment industry, coupled with Arbitration Act, IT Act, and also Evidence Act, does give us a good legal infrastructure ecosystem to have more and more ODR systems. As far as e-commerce goes, we have seen that in Consumer Protection Bill, which I think is tabled before the Parliament, does introduce a concept of electronic intermediary. So, I think I'm not saying that arbitration should be force-fit into the Consumer Act, but I think that actually one can argue that for your online e-commerce, you should first have an online dispute system which can be exhausted before a buyer or a seller can go and approach any court or a quasi-judicial forum. But how this can be implemented? As you have seen that the cashless economy, the use of digital cash, right? Although it was voluntarily existing in India for last 10 to 15 years, but when it was legislated, when it was forced upon by the government through various machinery, whether through RBI and now through Income Tax Act and all, the growth of adoption of the online payment system grew very, very fast. So I think while we, on one hand are legislating or maybe force-fitting the adoption of cashless economy to the citizen of India, I think this could be the right time for the government and other institutions to really think through that. Should we now force-fit the dispute resolution from our traditional offline dispute resolution like Arbitration, Consumer Protection Act for these industry which are like e-commerce, online payment, to your online dispute resolution? And for that, I mean, some institution should be mandated, maybe MCIA or some new institution to come out with specific rules to conduct an efficient online dispute system. One institution which has very, very recently come up is online dispute resolution for e-commerce transaction by National Law School of India, in Bangalore, which is in partnership with the Ministry of Consumer Affairs. Something like that can also be set up on a pan-India basis to resolve all the dispute in the online dispute resolution. So my second thing in terms of adoption of technology in the arbitration is about artificial intelligence. I'm sure that this is a buzzword, and a lot of entrepreneurs who talk about artificial intelligence are receiving check of millions of dollars from the investors. But have we ever thought that how we can use as lawyers, academicians, artificial intelligence for a better and efficient justice system in terms of, fast and cost-effective and lot more accurate your delivery of justice to a common man. And I'm sure that we all know that very recently IBM has invented some sort of cognitive intelligence software called as ROS, and very recently I think in the US some big bank has also implemented some software which has reduced the contract review time from I think 1,500 your billing hours to just I think a few hours, something like that. And also very recently Infosys has also implemented some software to do some efficient legal contract review work. Now, I mean, how can we actually use artificial intelligence to be more efficient in terms of justice delivery? Is that, we have so many precedents, we have the software which has now the capability to do very, very complex contract review. We have the software which is ROS, which has a capability to do so much extensive legal research. Now, if you see how we do arbitration, most of the arbitration are on some commercial contract. You have a contract, you have a claim of the breach of a contract, you have some evidences, documentary evidences. So if we have sophisticated software who can interpret what that contract says versus the claims versus e-discovery, and then you have a software which has a great capability to do an excellent legal research, join these 4 dots, it can be done very, very quickly, and you can, if not give the judgment or the order, but you can always assist the arbitrator, correct, that look, with this contract, claims, evidences, and legal research, this I believe are the 2 or 3 permutation combination which the arbitrator or in fact a judge can, in fact look at it. So it will also help them to be more accurate, be more compliant with judicial precedents, and can also save a lot of time and cost for the clients. So I think the world is moving towards more and more adoption of artificial intelligence. I think India is still far behind in terms of implementing, but yes, I have seen that people are appreciating the emergence of artificial intelligence into the legal services. So, should we get scared about it? May not be Salman Khurshid sir, maybe guys like me, because when I will come on his age, then I have to be extremely fearing about the artificial intelligence. I think it's time for young lawyers like us to start understanding that how software and how technology is going to affect our life either positively or negatively. So, I will end by saying that if you can't beat them, then join them. So which means that if let's say we being lawyers cannot beat those people who write the codes about artificial intelligence and some sophisticated software, at least we should join them. We should start enhancing our skill set into technology. And I think not now, maybe 5 to 6 years down the line, lawyers can actually become the coders when a great company starts implementing artificial intelligence system for the legal services. And I can bet that the compensation and the salary and the fees of those lawyers who understand how to write the code, I'm sure would be far more than what any senior counsel will learn in India. So thank you very much on this note.
Thank you, Ashish, for sharing your foresight of what the shape of things are awaiting the legal profession. And artificial intelligence, if it takes away, it will be very harsh upon the legal profession. I think the Bar Council of India is not noticing what he has said today. But I'm sure as we move towards Internet of Things, this is going to happen, and our lives are dictated by algorithmic codification. I request now Ms. Jaspreet Kaur to share some of her views on technology.
Thank you, Mr. Chairman, dignitaries, and my co-panelist, and esteemed audience. So I was fearing that maybe Mr. Chairman is going from right to left, so I'm going to get the burden of standing between you, and my speech is going to be the burden of standing between you and the lunch. So thank you for giving me a previous slot. So right now, I am feeling overwhelmed, and it is a privilege for me to share the dais with such eminent speakers and the dignitaries here. I belong to a firm which is tech-enabled legal services firm, and where our mojo, or rather the motto, is to deliver the legal services by infusing and blending our services by the use of technology and software. And with that as a background, that makes me some relevant into the system of where we're talking about the next era of evolving arbitration and making the use of technology into the delivery. So, and I would like to start by thanking Mr. Chandra about talking about artificial intelligence, because I had a big speech about it. So we've already covered that topic. So I'm going to just shift the gears and just concentrate on how exactly we can blend the technology into the legal ecosystem, or rather the life cycle of arbitration. So I'll start by introducing you to the term ESI. No, it's not a secret agency. ESI is the electronically stored information, and that information is something we get in our local drives, in our laptop, computers, on the servers, on the SharePoints, Dropboxes, emails, and also the information that we save through our external storage devices like DVDs, CDs, pen drives, and all. So, and we should not forget that we live in a technology era where we use our smartphones to be an indispensable part of our living and working. So the role of technology, while I speak in arbitration and share on my knowledge, I think this is the very next logical, natural progression, a step which is inevitable for us to see in the years to come. And while I go further and speak on this topic, I will attempt to substantiate my analogy on this one. So I'll start with a quotation, and I think this is a quite popular quotation these days, with the people speaking on the blending of technology or use of artificial intelligence, machine learning. It says technology is a great equalizer. It makes the world flat. So it is said on purpose, and so when we talk about technology and we talk about making it as an equalizer, it basically is something which is to be construed as a facilitator. It is not something which is trying to eliminate the human intervention, because few things are indispensable to the system of reviewing a document and applying the human minds. That is going to stay. That is not something which is going to eliminate, and the motive of infusing technology is to actually get those productive and the expert hours on going through the documentation, which actually needs our attention, which should be presented to the reviewers and attorney like us in for the review, right? So. As Mr. Wiegand was also telling about the huge cost impact in the document production stage that we all go through in the arbitration life cycle. So if we take a moment to get out of the quotation saying that we've been doing this from quite some time. So we understand change is not something which is easily and open-heartedly accepted by all, but nevertheless, it is the time that we need to embrace technology into our arbitration life cycle as well. And this particular analogy I say because ESI, electronically stored information, is the DNA of all transactions. So in the time and space we live in, we understand that majority of the exchange of documentation, the content, is the information available on ESI. We have come a long way from data being measured into kilobytes or megabytes or gigabytes. That seems to be a very small unit of measurement these days. So we have graduated to talking of content in being terabytes. So when I talk about terabytes, now as early in the session we had heard that technology is to ease the operation, and that in fact is the 100% true statement. use of technology does not mean that we are going to be out of our jobs of reviewing it. We're going to stay important, but we will be important, we'll be staying important for an important reason. The reason of interpreting and culling out the information which is relevant to the case and finding the facts which can lead us to present or investigate further and get to the true facts. Now, if I go and take a quick example of a case pertaining to the breach of confidentiality. And let's assume it is a case with 3 terabytes. I'm just taking a very, example with a very short amount of content to be reviewed in this one. So 3 terabytes of data needs to be reviewed by an attorney, which is a case of confidentiality breach. Now, if I translate, and pardon me if my calculation goes wrong, roughly 3 terabyte means 1 GB has 6,000 to 7,000 of documents. 3 terabyte would mean approximately 2 crores of documents. Now, if we call ourselves as subject matter experts, and if we are thrown into a dump of documents, a corpus which runs into crores, we can imagine how much of cost, how much of effort, and how much of fatigue we are going to cost to the entire life cycle. So to be able to use the technology better here, when we have got into the stage where content is available throughout the different mediums of ESI, it is important for us to now infuse technology. Over this particular example here, now technology can be leveraged where an algorithm can be built of getting the relevant email exchange for that matter. Out of 3 terabyte information, you think 5 GB is related to the email exchange of different parties. We can use the technology to just cull out all the emails related to the related parties of the case. We can then cull out the information to say that our software can be fed and directed in such a way that only the relevant and the unique information comes out to the review box. We can bucket the relevant information for the further review of the respective stakeholders. For example, if something which is related to not maybe my subject matter that I deal with, then I need to pass on to another peer of mine who is maybe an IP expert. We can create and bucket the information for them to pick it up, segment the data, and to further review it down. I'm very sure after technology does the first round, because till now we see there is no human intervention. What we're trying to do is bring down the documents to such a stage that the relevance of the case is captured for the bucket which is meant for review of attorneys or reviewers, right? So this Herculean task, from the aspect and from the success that we have seen in our e-discovery and forensic space, is something which we perceive being the tech-enabled firm. We're excited to see this in the arbitration space as well. And now, if you talk about the analysis and the length of, the review process, if arbitration also takes is as close as the litigation, then we are fearing that the popularity of arbitration might fade away, which obviously is not something we wish for or we want. To analyze the situation with use of technology as part of delivery again, I have just listed a handful of benefits that we can draw from technology. We can introduce search strings. Now, search string is something that I might be sounding a little bit more a person from technology background, but I'm trying to relate it with the process of introducing technology, not just to the initiation of online registration of complaints through online dispute resolution mechanism. After the registrations have been made, there is a complete life cycle that goes into this particular scheme of things. So as I was talking about, that search strings can be there. Technology can expose us to the metadata. Metadata is basically the data of the data. Who created the document? Who was the author? Who edited it? What was the date ranges? Do we want to really look for an information which happened from this year to this year? So all of these magical things from a stage of coming the manual review can be overcome by technology. And that adds a great fervor to when we talk about the cost impacts also on the life cycle. And if we also talk about technologies, and I can have a complete session over how we can leverage the technologies into the legal, legal services that are already present in the system, or something where we have not, the sectors which have not touched technology, please catch me. We can have an interactive session in our informal thing there. But I'll restrict myself here with an example that I talked about. Now imagine with 3 terabytes of data, with the kind of computations and the strings and the concentrated searches that we asked, now the 3 terabytes of data is culled down and brought into the buckets for the review. And I am very sure that, and I'm banking on my knowledge on that, what we have done for the e-discovery and forensic space so far, the 3 terabyte data is reduced down to 1.5 terabytes. So that's a humongous reduction of the corpus that needs a human review or intervention, or might be purely relevant for the case in the subject. Another aspect of technology is to get our hands on the information which is not visible to our eyes, as I talked about the metadata thing, and also about arranging and managing the workflows and the workloads. Now, if we get an extra time, I hope nobody would mind to have a better personal and professional life balance. And in the experience of myself, the short career and my peers, we have seen that technology definitely aids in saving time for better things in life. And with this, if I talk about broadly about how the technology can be leveraged for arbitration life cycle, it aids to identify right bracket of information. It culls out not relevant information, reading out the duplicate documents, because we have seen many a times that there are versions floating. There are same set of data that is lying on your server, might be on my local drives, and once the data is pulled out for the review, the party who is responsible of taking out the documents is not going to look into each and every document. So all the documentations which are supposed to be not part of the review, with the help of technology, we can get them out. Third is to also aid the human review. Human review aspect is, for example, that you're reviewing a document, in a document of 400 pages long MSA that you signed with the other party, and there's a relevant context in maybe to know the governing law, maybe to know the arbitration proceeding clauses that you have set in, and also to know about what were your SLAs in terms of, and also to know what are your confidentiality terms and conditions that you talked about in a contract. So technology or the software can actually take you down to those specific areas for your concentrated review and analysis. So another point which came up during one of the sessions was talking about the paperless environment. And I've been asked by one of my very dear friends to talk about the impact of going paperless, because it is indeed a very touchy topic, if I can say, and it's a different one, but I will touch upon it because legal and billing, legal department, billing departments are said to be, quoted to be the higher consumers of papers. So if we aim to translate our physical form of copies into the transactions and the things which we can do over cloud, over the system, the storage which is there in the soft version, yes, there can be chances, and we will be contributing to a better, a bigger, the area of concern these days, which is cutting down of trees. And paperless also assures one thing, that the possibility of getting your papers into unwanted hands. When I say unwanted, maybe you're not supposed to, or you're not a party to review, or there is no reason why, or it was just a leakage and you're trying to just look through the things on the paper. If we kind of import everything on the soft version, that leakage into the security protocols can also be managed. And in the era we are in today, the next logical step that, according to my little knowledge and experience, suggests is the stage of artificial intelligence and machine learning. But I would right now, because we do constantly R&D on where the technology is being going, and our concentrated area of service is legal services. So we say, I definitely think for that we need to make sure, first of all, we embark on the journey to introduce technology to the arbitration life cycle. So With that, we are aware of initiatives also being taken to make Asia, I would say not India this time, sir, Asia is the next center of arbitration hub. I think we need to race with the time and get the time and cost effectiveness into the arbitration process. And it is pretty achievable in India because we are very sure about the resources, the skill sets that we have, and the homegrown technology to take care of the arbitration life cycle is not a distant dream, because the skill set, the resources from development point of view, the skill set, resources, and the cost effectiveness from human contracts review perspective is something that we are already ready for. So I would like to just conclude my statement by saying, to make Asia and India as a center for next international arbitration hub, it is time to say bon voyage and get on to the technological transformations. Thank you.
Thank you, Jasprit, for enlightening us on the importance of knowledge management. We have too much of information and too little wisdom to use that. Thank you. I request Mr. Naresh Thakkar to share his views.
Good afternoon, ladies and gentlemen, and yes, I'm back. When I was walking over to the dais for the second session, our good friend Abhinav Bhushan, who's found an opportune moment to walk out, actually came up to me and said, "It's your day today," and let me tell you, it's not my day really. I was filling up for my partner in the morning, and I came last. I am doing this session for my own self, and I come last. I'm not a great advertisement for my son. What am I going to go home and tell him? I came last, but you have to come first. I don't think a great advertisement at all. But a lot has been said about technology. A lot has been said about how to save time and cost. The fact that technology will help us save time and cost, let me just try and sum up everything and try and give a few practical tips. As a practitioner, what I believe is the way forward and how one can save time and cost in arbitration. In the first instance, I think you need to start with choosing the right team, whether it is your internal team or it's the external team. And to my mind, it becomes extremely important on both the fronts to have your right internal team in place, the one that understands what an arbitration will entail, why facts are important, why do you need to take all the facts, including every sheet of paper that you have, even if it's a handwritten sheet, to which to you looks innocuous. But to my mind, you should actually carry it over to your external counsel. Therefore, it becomes very important for your internal team to be completely aware of what an arbitration would really entail. Your external team. The choice of your external team again becomes extremely important. If your external team does not understand your business, does not understand what really you want to achieve, does not understand the arbitration process and equates it to the litigation team, to start off, you're on the wrong foot. You've started off absolutely on the wrong foot. So both the teams, the choice is very important, and both the teams actually have to be on the same page. Next, obviously comes the choice of the right arbitrator. Experience versus availability. I think that's a dilemma which all of us at all points in time in every arbitration face. If it's a large enough arbitration, are you going to look for experience as against the availability, even if there is a question on the availability? Or in a matter which is maybe not as heavy, either from the legal perspective or maybe from what it really entails in terms of numbers, are you actually going to look for more of availability and give up on experience? So it's, to my mind, a chicken and an egg story, but ultimately one needs to give an answer to that as well, and one needs to find a right balance to both. And therefore, when I said in the morning that we need in the current scenario, need to have a pool of arbitrators. Yes, we have an excellent pool of arbitrators, but is that enough? Is that pool good enough? To my mind, no. We need to add to that pool. We need to bring in the younger blood into it. We need to also get the GCs into it, and why not? They are the stakeholders as well in this entire process, and they must understand and they must partake of this process to its fullest. Should we also get experts from the field into this process? Answer is yes. But would I, if I was doing an arbitration, a commercial arbitration, would I look at a team only consisting of either experts or only industry people? I don't think so. I would actually look for a balanced team, and a balanced team of arbitrators, I mean, and in that I would actually look for a person with a legal background, and when I say a legal background, someone who's practicing in the field of arbitration or litigation, one way or the other. And when I say arbitration and litigation, it does sound a little surprising and a little weird, because when I began by saying that you've got to choose, in the morning I said you've got to choose between a team which does arbitration and a team which does litigation, but a litigation experience does help. Let me tell you that if you've worked in the courts, you do understand a lot of what actually will go into an arbitration. It's the mindset that you bring into arbitration which matters to my mind, and if your mindset can change from litigation into an arbitration, I think you are fit enough to do both the things. The next, obviously, what you need to think of when choosing an arbitrator is that, would you want a sole arbitrator? Do you want to go in for a panel of 3 arbitrators? And there's a lot to be said for and against both. But obviously, again, it's a toss-up and a choice. Which choice, at times, when you are entering into a contract and when an arbitration agreement is being written down, people don't leave that choice to themselves. You know, you would possibly write a contract, and when you are writing the contract in the arbitration agreement, you actually put in 3 arbitrators. Then you get into a litigation, into an arbitration, and at that point in time you do realize that it's an arbitration, either it's not too heavy on numbers and therefore does not require 3 arbitrators, or the issues are not as many, and therefore you would rather have it done by a sole arbitrator, and you would actually want not a clash of diaries, not too much of cost involved, and you would want to run it as efficiently as you can, and at that point in time you're really left with no choice. And if you have a recalcitrant respondent and who's ready to spend, for all you know, you may land up in a situation where even after you've suggested a sole arbitrator, they would come back and say, we are sorry, it's a panel of 3, and we would go with a panel of 3. I have actually experienced such sort of situations where I have landed. I know that the dispute does not actually require a 3 arbitrator panel. I have suggested a sole arbitrator, and the comeback has been that we are sorry, we'll stick with what we have out there in the contract. Again, something that we need to consider: should it be document only, or do you want to go in for a full-blown arbitration? There's again a lot to be said on that front. We in India maybe look at every arbitration from a perspective of a trial. Yes, it's a trial. I do not for a moment doubt the process. But at the same time, does every trial require as much of a oral submission as leading as many witness evidences? Is it not good enough in a trial to have the documents and let the tribunal decide on the documents with the least minimum oral arguments that which is required? To my mind, you should look for that. in fact, the Act now, the amended Act does require, it has a provision which is a fast-track provision, which will actually end the arbitration within a time span of 6 months. It's a great tool, and I think if that tool is used, certainly with technology, we can really move at a much faster clip than what we do at the current regime. To begin with, when you are into an arbitration, what you should actually start with is to investigate what are the facts, what are your rights, what are the interests. And with the current act in place, which will actually require an arbitration to run its course either within a span of 12 months or a given span of 18 months at best, post which the mandate of the arbitrator actually goes. To my mind, it's best that before you shoot out the notice of arbitration under Section 21, you actually investigate, prepare yourself, know the facts, know what are the rights, look for the right interest before that notice of arbitration is shot out, so that when the arbitration actually begins in its right earnest with the acceptance of the notice of arbitration, not really an acceptance as an acceptance, but you get an answer saying that yes, we go into arbitration, which is when the arbitration really kicks off. You are already prepared on what you want to say vis-a-vis your statement of claim, or if you are the respondent or the defendant, what your defense statement really would be. Work backwards. What is it that you really aim to achieve out of this arbitration? And that is something very important. People don't really think, and at most times I have had clients come and we've sat down, and the first question that I ask is, what is it that you seek to achieve? And many times we realize that when you're talking to a client, the client is really not looking for a 100% win. Yes, everyone wants a 100% win, but with the facts in place, are you in a situation to get a 100% win? Most of the times the answer that comes to you would be that no, you, in a commercial transaction with the back and forth which has happened between the parties, a 100% win is a lesser of the probabilities. Most of the times what the client is looking for is the percentage win. And that percentage win is what you need to really investigate on and to understand where the interest really lies. And if you've done that at the very first instance, I think you've shortened the process already. Having asked that question, that what is it that you seek to achieve, the next question that you need to answer is that how are you going to get there? Because if you've answered both these questions at the very first instance, as I said, the time frame for an arbitration really, you can shorten it down to the 12-month period that the current act requires. Though I personally do believe that when the Act says 12 months and 18 months and it says that the mandate of the arbitrator ought to go, I do believe it's a little harsh timeline that we are running with, and especially insofar as the arbitrators are concerned. Also think of it from the party perspective. You have a pool, a small pool of arbitrators, you have a smaller pool possibly of practitioners. And then you have a time frame which is 12 months to 18 months, and you'll have complex arbitrations, complex issues out there. Is it really a time frame which is workable? To my mind, not really. In a complex arbitration, even in the international sphere, experience tells us that 20 to 36 months is really the time frame that one looks at for an arbitration to get over. So the 12 to 18 months, maybe we've been over ambitious, but time only shall tell us, how we'll be able to achieve this and if we'll be successful in doing this. But if we do manage to keep up to the time, because, we had a problem where arbitrations would run the course and they would be as long as a court proceeding. Again, the pendulum having swung the other way, we now have a shortened time frame. Maybe it's a novel solution and it may bring in a lot of relief to the parties. So as I said, time will tell us whether we succeed in this endeavor or not. Finally, in all that we have to do, we must plan the arbitration well in advance, have our summary of arguments put in place. Again, in the short time span that one needs to now run an arbitration, parties would be served well if longer oral submissions are avoided and a far more succinct summary is provided to the tribunal. It also helps because when the tribunal sits down to write the award, they have the arguments in front of them. Obviously, that is something we need to learn to summarize and not make it into a full-blown written submission. Budgeting, as we all understand, is very important, whether it's household, business, or litigation. One needs to budget. You cannot, and today we understand it better than ever before. When you have a GC who comes up to you, and he gives the mandate to you, he understands what his company wants. He also understands that there is a budget to it. When you talk to the general counsels these days, all of them will tell you that they have a budget that they are working with. Yes, you have to work within the budget, and you have to learn to work within their budget. Yes, there will be a little up and down, but you need to therefore decide how you are going to run this entire arbitration. Yes, there will be, like I said, if you have a recalcitrant respondent, you always will run the risk of going a bit here or there. But if you've planned the whole thing out and if you've budgeted yourself well in, I don't think one will have a problem running the course of an entire arbitration. And with that, I would actually step down and not be between the audience and the lunch. Thank you so much.
Okay, I think there are no questions. We'll break for lunch.
From arbitration, so you got it from the arbitration. The arbitration started post 2000, October 2015. No. Yeah, so that's a question. Post, it's a little, I mean, today in the courts, I had decided whether arbitration, the German Arbitration Act is retrospective or not. So that says that as far as the regime is concerned, it is actually that happens, then you have the wherewithal. So that's an issue which is very unfortunate. It's an issue which is very but yes, one can certainly look at it and we can 100% easy. Yeah. Yes, which is not but not for your presentation. Sorry?
would you like to start this business in Russia?
Well, yes, we can actually do
I can help you. I mean, I noticed because in September I finished workshop here.
Okay. So, this set up, right? So, but yeah, if you want like expand to Russia, and I'm sure that there will be so many investors in Russia who want to invest in their e-commerce, in their technology. So maybe what we can do is we can connect offline.
Yes.
Maybe next week.
You are in Delhi.
So I am actually shifting to Mumbai next week, right? But I would still have the same phone number.
Telephone number, same.
Yeah.
And in email address?
Email will also change because I'm changing my
If
job.
you can write, yes.
Yeah.
Yes.
Yeah. So we can connect because I know so many people who want to expand in Russia, and I know so many people in Russia who want to invest in India. So maybe you and I can think of a business model which will help these two people to talk to each other. 1109 at the rate
gmail.com.
You can write in your
Yes,
handwriting.
my yes. Ashish 110 1109.
At the rate Gmail. At the rate.
E.
It's not E, it is
110 at the rate. It is at the rate.
At the rate.
Gmail.com. Yes. Yeah.
And I have your email ID. I hope
Yes,
that
yes.
okay.
Yeah. What this second?
Second.
This is means Minister of Finance because I'm the Minister of Finance.
Okay.
Administration.
Understood. Sure, sir.
Thank you. Thank you.
क्या है यार, जो बीच में छोड़ के चलेगा, कोई और बैठेगा। क्या छोड़ के? कोई और बैठेगा, वो कैसा बैठेगा? ठीक है, तो ऐसे मैं ले जाता हूँ। मैं तो अच्छा ही होगा, अच्छा है यार। यहाँ रख देना।
So we're waiting for Mr. Vivek Kapoor. All right. So the theme for the third session is Evolving Role of Corporate Counsels in Managing Dispute Resolution. The session is chaired by Dr. Nicholas Wiegand, Managing Partner, CMS Hong Kong. The speakers are Mr. Tushar Chawla, General Counsel, JL LaSalle, Mr. Vivek Kapoor from Stephenson Howard LLP, London, Mr. Pulin Kumar, Group Senior Legal and Compliance Director, Adidas India. So I request the chairman to kindly commence the session.
Thank you very much. Welcome back, everyone. This is your favorite session of the day, right after lunch. I see some people are probably still getting their coffee. I don't think you'll need it because we have excellent speakers lined up for you. In the interest of time, I won't say too much. You've heard from me already this morning. The topic, of course, of our session is evolving role of corporate counsel in managing dispute resolution. For all of us external counsels, a very important topic to hear what the in-house counsel actually think of us, how they think their role should be, or how their role is evolving in managing a dispute. From my own experience, I can say it has changed quite a bit in the past couple of years, from a hands-off approach to a very much hands-on approach. In particular, the larger the company gets, the more in-house counsel do get involved nowadays into managing the dispute from very early on to the very end. A very active role, but that's my perception as an external counsel. As I said, I don't want to take too much speaking time from our panelists, so I suggest we start right away, and I would like to ask Mr. Pulin Kumar to give us his views on the role of in-house counsel.
Thank you, Chairman. Welcome to the post-lunch session, and just to give you an idea of how I really correlate the General Counsel's role with we have for our foreign friends. I'll just go back to our epic, which is called Mahabharata. And there was a person, the iconic figure in that epic called Bhishma Pitama. Bhishma was the savior of the reign at that point in time. He had some commitments. So I correlate the General Counsel's role with the Bhishma Pitama somehow. And the role of the General Counsel is to just protect the company and the culture, and he is basically the conscience keeper of the entire organization. Whenever there's a risk, the General Counsels of the company is running at the forefront, and he is posed with the facing all kind of risk and mitigating those risks and giving the advice to the management for taking the business forward. Over a period of time, I will again correlate that it is not only the Bhishma Pitama's role which the General Counsel plays, but it also plays the role of a typical character in the Mahabharata, which was a person called Shikhandi. She was a transgender person. And Bhishma Pitama, it was said that he was fighting for one group of brothers, and the Pandavas was on the other side. And Shikhandi took side of the Pandavas, because Shikhandi has taken a rebirth in the form of transgender. And the history goes back, and she vowed to take revenge from Bhishma Pitama, because in one point in time when Shikhandi was in earlier birth, she was basically known as a princess. She was a princess of an empire, and her name was Amba. And when she was to get married with the king, Bhishma Pitama forcefully took her along with the other two princes, and force other two princes to marry the other, for whom he has taken forcefully. And Amba was finally, not married to anybody. She was not accepted for whom he was taken forcefully, and she was not even accepted who wanted to marry. So she vowed that her life was ruined, marital life basically, she couldn't marry, ruined by Bhishma Pitama, and she took a vow that she'll ruin Bhishma Pitama one day. And Bhishma Pitama has vowed that, that he will not use shastras, that is weapon, against any women. And Shikhandi was taking part from the, she was on the side of the Arjuna. When she confronted Bhishma Pitama in the battlefield, Bhishma Pitama just put down his weapon and he said that I can't shoot the women. And finally the Bhishma Pitama was killed by the other side. So that is how, the General Council, why I am telling this small story, the General Council's role is more or less of Shikhandi also. Whenever there is a problem, he is put before everybody. So you face the problem. So we are Bhishma Pitama as well, and we are, kind of Shikhandi also. So having said that, I'll quickly touch upon the, how the role of the General Councils in the corporate sectors have evolved over a period of time. And this, the evolution has happened in, it's not very old, but it's very, new. In last 2 decades, the role has seen the, paradigm shift, what it used to be earlier. We still remember that when we took admission in the law school, maybe 25 years ago or 28 years ago, it was told that you didn't have anything to do, you are doing law. So that was the, kind of perception in the society. But now the law is a career. Now people opt law, there are a lot of law schools are coming up, and there are a lot of good law schools are around. And the students are choosing it as a career. And as far as the topic is concerned, that how, the General Councils can really, what is the role of the General Councils in dispute resolution? What I would say that, what quality the General Council should have, he has to say that they typically the issue and resolve the issue. It is not the role of the General Council which is expected as of now. See that it would be what represent and the team is proper, then the responsibility and the legal spend basically is the limit for them. And with the laws and regulators regulations becoming complex, companies risk and challenges. If one can manage one may become a successful General Council. But in order to achieve that, they must first understand the do's and don'ts of business. And rightly said, when the regulators look at the General Council as the barometer of what is wrong and what is right. So they are the first point of contact for any regulators, and they want to understand from them only. So this is how, one has to be abreast with the entire, ins and out of the business and the commerciality of the business. It is not only restricted to the legal risk. As far as the dispute resolution is, and the role in dispute resolution is concerned, again, what I have said, that a successful GC has to have a 360-degree view. He needs to understand the deal and the context and the risk and everything and the facts. Those are very important. And no other person can be better than, the legal in-house counsel to explain the facts to the external counsel to take it forward. So it is partnering again. So therefore, it becomes a complementary to each other to represent in the litigation or the arbitration. Wherever the General Counsel has to contribute, they are contributing immensely and they are expected to contribute immensely. That is what I would like to say, and I would conclude and would like to hear from the other panelists. Thank you.
Thank you very much, Pauline. Does anybody from the audience have a question right away to Pauline at this stage? not at this stage. I have a question. Since you work for Adidas as a German company, of course, as a German, I have to ask you whether you see any differences in the work of a general counsel working for an international company based in Germany. I know you worked for a Korean company before, and your work yourself, you're based in India. Do you see any cultural differences or in the work of in-house counsel?
Yes. As I said, that as far as the India is concerned, the history is not very old, and certainly the liberalization and globalization has helped quite a lot to evolve the roles and responsibilities of general counsel, recognition of the general counsels. As far as the cultural the import is concerned, being in India, certainly the culture has a huge difference what we had in Indian conglomerates as compared to the foreign entities. So and rightly so. The Indian entities have now adopted to the same, and they are also taking up the challenges. And more or less, I find that the culture are the same as far as the compliance is concerned and the regulations are concerned. Doing the business in a compliant environment is concerned. The sense of doing business in a compliant manner is equally as far as whether it is Indian conglomerate or the foreign entity. The risk perception and really the desire or willingness to honor the compliant business is equally, I would say that it is there available in all the entities which we are there, business entities in India. But certainly, yes, as far as the culture is concerned, the foreign entities have definitely impacted the lot of workings in India, and the importance has also risen. And see, 90 was the major, that decade has been the great decade for India, because liberalization and globalization really started and picked up the momentum in that decade, and a lot of foreign investors came into country, and a lot of culture also came from the foreign investors, and there has been a tremendous growth into that.
Well, thank you very much. If there are no other questions from the floor at this stage, I think we'll go on with Tushar to give us your insights. Thank you.
Good afternoon, everybody. The fact is that what has been pointed out by Pulin is ever since 1992, the role of general counsel has gone a huge amount of change, from earlier being essentially civil law and or criminal lawyers to being corporate lawyers, and thereafter getting onto the other spheres of corporate work as such. It's more about now being the general counsel of the company, especially like a company like JLL, which does facility management and which has about 1,400-1,500 sites on a pan-India basis. There are ethics, there's risk mitigation. The role of general counsel has gone a substantial amount of change, I must say. So it can be anything virtually, and I think I'll go with practical examples. What as a general counsel I faced is that I have never been rogered by stray dogs. Right, and this was the first time. It's there in the public domain, and that's why I can state it. And especially in the Bombay edition, is that I'll give you what we managed this Natraj facility site, which was a studio earlier, and which had about 6 to 7 stray dogs based out of that place. That place ultimately got transformed into a commercial space. The studio went down, but the dogs continued to stay. The client did not like it, and asked us to remove the stray dogs. Ignorance of law is no excuse. Our people went ahead and removed 4 out of the 6 dogs. They it was alleged that they tortured them, but eventually they were removed. The fact was that the people for animals and the other animal activists came to the forefront. They not only backlashed us on the media. The fact is that they put in the FIR was lodged against 3 of our people we were asked to bring back those dogs. And to the extent that I was supposed to go to Bombay for one day, I ended up spending 6 days there. The best part was that luckily JL had never got accused in the FIR under section 428, which is about maiming of the animals. It is a cognizable offense, but had JLL directors being, names been put in the FIR, I would have had to kind of, seek their bails, and the matter would have had to go on. So this is, a simple thing such as removal of stray dogs, which I never kind of encountered in 23 years of my career. Never ever I've encountered as a general counsel. I've dealt with complex matters, but never with stray dogs. And these are the risks which a general counsel carries, because you have to protect the directors, and we are a global company. There's a global strategy in place, and there's the global policies in place, then there are global ethics policies in place, and especially from an ethics perspective, you have since we are world's most ethical, one of the most world's ethical companies, there is Sexual Harassment Act which you have to comply with, and especially being based out of the site, even this Sexual Harassment Act per se is silent on multiple features as to who's going to conduct an inquiry, and especially because, let us say, if a client employee is involved, the site is, based out of, let us say, Hyderabad, we are based out of here, who's supposed to conduct an inquiry, what is the venue? So there are a lot of, gray areas even in the Sexual Harassment Act, but we have to comply with the same, there is no doubt, and there is zero tolerance on that. The other part, from a practical perspective, which I would like to point out is that, let us say that, you're talking about a service-oriented company with about 10,000, 15,000 people, rendering services at various places, and there are multiple vendors. Some are, big vendors, can be, MNCs, who are the vendors. Some can be small vendors who are registered under the MSME Act. Now, look at this provision. I will kind of, read out this provision for you, which is section 15 of the MSME Act. Draconian provision, I must say, where any supplier supplies any goods or renders any service to any buyer, the buyer shall make payment therefore on or before the date agreed upon between him and the supplier in writing, where there is no agreement in this behalf before the appointed day, provided that in no case the period agreed between the buyer and the supplier and the buyer in writing shall exceed 45 days from the date of acceptance of the deemed acceptance. Right. So, in a business like ours, where you're dealing on let us say, a pay when paid clause, where your payment to the vendors, and since there are multiple vendors, it's dependent on you getting paid by the client, and let us say that the client payment is about, the period is 90 days or 120 days, and here it is 45 days. My question, and I've raised this question to multiple senior counsels, is that whether, this particular clause, it says notwithstanding anything contained in the agreement between us and the vendor, does it override the contract? Does it override the law? What is it? The answer is still gray, and it is a draconian provision. The fact is that a company which is dependent on providing services, right, and you can't be expected to go out of your working capital requirements. So does this override the provision? Does this override the act? Does it override the agreement? We have not had an answer to this. So these are and especially when you're having a huge vendor bank, these are the provisions. And suppose if a decree was to be passed against you, especially because of the fact that there are small vendors in place, in case you were to file an appeal in the appellate body, 75% of the decree amount will have to be deposited before you go in for an appeal. Honestly, this particular law, we don't have an answer as of now, but we are seeking to find some answers to this. So these are like the dog issue, the MSMED issue. These are some of the challenges which a general counsel faces, especially in a service-oriented company, which is based on services by the vendors and all the stuff. What do we do? The fact is that there has got to be a distinct dispute resolution policy in place. In today's world, you cannot do without a distinct resolution policy, dispute resolution policy, which has got to tie up with the global policy or the regional policy. Second is that your relationship with the business. That is very important. Today, the business might say that, okay, that vendor is small, I don't care at all. But today, that particular small issue can become big at any point in time, and you'll not even come to know of it before you land up with the financial burden. Monitoring, continuous monitoring of each and every issue which is likely to give rise to a dispute. please make sure of the fact that none of your issue, be it small at this stage, is considered small. It has to be, you have to pay attention to it to make sure that, you mitigate all the risks in case there are chances of it becoming big. Awareness programs, running awareness programs, continuous, with the business. The business is not aware about the law. They may not be, aware of the fact that how to deal with the vendors or how to deal with the clients. The fact is that you cannot allow the dispute to kind of become big, and that is why, in multiple papers I have read, it talks about, you talking to the business, having training sessions with the business, making presentations to them, making them aware, and especially in a company like ours, which has got 1,500 sites on a pan-India basis, it becomes all the more important because you have people based on the sites, who don't know what cruelty against animals could lead to. You don't know what, issue of small payment of, non-payment of a vendor could lead to. All these issues, no matter how the thing is today, anything can become big, and before it becomes big, you should have mechanisms to deal with it. So that's two examples which I cited. Today we are not cost centers any longer. It's very, very clear, and we have proved it. We are profit centers, in multiple ways. We do risk mitigation, we do cost reduction, we help in kind of, if we win a litigation, we recover the money. In case we file an insurance claim, we recover the money. So we have become profit centers, and at least from our perspective, from my perspective, we have as a department, as we've shown to the firm, that we are profit centers and not cost centers.
Thank you very much.
Thank you.
Any comments or questions from the floor? Maybe someone has a solution to your current legal problems.
Give me the solution to MSMED.
If that's not the case, I will give the floor to our third speaker.
Thank you, Nicholas. So while we have heard from Shikhandi to dogs, the corporate counsel's role has become very complicated. The in-house counsel is the central cog in the dispute resolution mechanism. I totally agree with what Pulin said. He is the Bhisham Pitama, because in a dispute resolution situation, he has to be counselor to the external counsel, because he knows the business, he knows the heartbeat of the trade, he knows the company's policies, he knows the company's objectives. A dispute, it runs much deeper than the paper trail and the contracts, and it is the in-house counsel, the general counsel, who knows what it is. He has to be the counselor to the management. There are times he is the voice of reason, other times he is the facilitator of a hard decision, which is starting a dispute. Most importantly, and that from an external counsel perspective, he is the custodian of the artillery of the dispute, the evidence and the witnesses. He marshals all these resources, and he has to do it keeping his eye on the grand prize, which is an effective and efficient resolution of the dispute. So I will not tell you more about the problems. I would make a couple of suggestions what general counsel could do, what things they could sort of focus on and make their life easier, and sometimes even the life of external counsel like us. First, get the Arbitration Act right. A business transaction has many moving parts. You cannot control, and in-house counsel cannot control all of them. However, you can control the Arbitration Act. So the first thing is avoid the pathological clause. That is the incorrectly drafted clause. Look, London, write Singapore. It's terrible, wastes a lot of time, wastes a lot of cost. Secondly, don't fall in the trap of a boilerplate clause. Arbitration is inherently a flexible process. Make use of the fact. A boilerplate clause is a massive lost opportunity. Every transaction should have a different dispute mechanism. Every transaction does not need a three-member tribunal. A sole arbitrator can be the answer. A 3-month, 6-month dispute for something very small can be the answer. So don't fall in the trap of the boilerplate. Secondly, get the right external counsel. Litigation is different from arbitration. bringing a litigation counsel on sometimes is not the best option. It sounds very self-serving, but that is a fact. Sometimes you need an external counsel who has the right industry experience, who has the right dispute skill set to efficiently run a dispute. Third, get your document retention policy in place. For the business, the next day is business as usual. Documents get lost, documents get misplaced. However, when you go to trial, a misplaced document could actually result in an adverse inference. That is something what you want to avoid. Yet, once a dispute has started, you need to have an ongoing communication oversight. You need to ensure, now this is a slightly delicate topic because the business doesn't like that all communication, especially with adverse parties, flows through you. However, that is very, very critical. And if you have disclosure requirements, you may even need to manage the public discourse. And sometimes, especially in treaty arbitrations, there is a lot of public discourse which is happening, which if a general counsel does not mitigate and control, it can have adverse effects for the company. Next one, website inspection and beautification. Something which is very often ignored, but very, very critical in this day and age. You need to ensure that wrong-headed statements are removed because your opposing counsel is anyways working hard. You don't need to give him opportunities to impeach. Coordinate with the co-venturers. This means the other stakeholders. It could be the banks, the funders, your contractors, your operators. Most importantly, don't completely outsource the dispute resolution strategy. For you know the business, you know the objectives, you know the priorities. Be part of formulating it. Work with your external counsel, be part of it. And it is very important that every arbitration decision is taken in a very traditional way of a cost-benefit analysis, which means that during the arbitration, a lot of applications, a lot of challenges, even if they can be filed, should not be filed just for the sake of it. They waste time, they have no practical relevance, and very often can also have adverse consequences. Be involved in the process. Now that starts with choosing the right arbitrator. It is very important that you discuss with your external counsel what your priorities are, what you are looking for in the arbitrator, so that you get a person who is realistic, practical, has a viewpoint which you want. Be part of establishing the timetable. Now that has two sides to it. One, you get a realistic perspective, which is very helpful when you have to go back and manage your client's expectations, that is the business. And secondly, you can plan how the dispute is going to pan out and how you are going to internally manage that. Case management techniques, very important, often ignored. Things like bifurcation of disputes. It can be very useful if rightly used. The involvement of a general counsel with the external counsel helps with it. Evidence and witnesses. It is one of the most fundamental aspects of a trial. And it is the general counsel who ultimately gets the right witnesses, gets the right evidence. Costs often get discussed, and I think one very helpful thing when it comes to managing costs is if the in-house counsel can leverage internal resources to manage external counsel and have a specific international arbitration team. Another very important thing, keep an open mind for settlement. Just because blood is boiling on both sides does not mean that the matter needs to go to trial. If there is an opportunity to settle, you should be open to it. Monitor future commercial developments that could affect parties' relationships or dispute strategies. And most importantly, manage client expectations. The business often has very unrealistic expectations about time, about costs, about winning. It is the general counsel's job to manage them efficiently, effectively, and periodically. And I think the last, which is very important, you need to know how to herd the cats, which means the business, the management, sometimes multiple counsel in multiple jurisdictions. You need to know how to do it. You need to be hands-on with it. Thanks.
You have questions? That's good. I was going to say...
So we
our
have to share a mic. So
our in-house counsel should probably ask you the questions now.
There are two sets of questions which I have. One is that so far as the arbitration is concerned, I'm slightly confused because the moment you have a sole arbitrator, the parties don't agree to it, and therefore you have to file a Section 11 application in the court. Again, that goes into that spin. Or you get into what I was talking to Samir in the afternoon, was get into institutionalized arbitration. That is one. That's one set of question. I don't know how to kind of deal with this. 3 arbitrators, very expensive. Sole arbitrator, not proving to be feasible. Institutionalized arbitration appears to be more effective. So 47% of the country today follows ad hoc arbitration. 47% because I think 47 or 50%. That's one question. The second question is, I'm slightly digressing, is that there have been a lot of changes to the labor laws. Maternity Benefits Act getting amended, the Payment of Bonus Act, specifically again a draconian change wherein it talked about retrospective application of payment of bonus, especially when we filed the income tax returns, dividends have been declared, retrospective application of payment of bonus act. Arvind Kejriwal government hiking the minimum wages by 37%, though it got stayed later on. How do we, that is the two sets of questions which I have, and honestly as a general counsel, I don't have, though I might keep the company or the global people informed that these are the labor laws, ESIC limit getting enhanced, which is good for the people. Provident fund, limits getting enhanced, bringing more people. So effectively every change has got the ability to bring about financial repercussions. And there might be a bill, there might be something else, but effectively we have to keep the global leadership informed of the fact that these are the changes which is again a very, very challenging stuff, because we don't know. Like for example, the retrospective application of payment of bonus act 14-15, nobody ever dreamt of it as to whether we'll have to pay for previous years. So these are two things. One is on the sole arbitrator, one is on the change of law, which is arbitrary to a large extent.
So if we go with the sole arbitrator, I totally agree with you, but that at this point in time, the Indian dispute landscape is very complicated. You have a sole arbitrator provision, it's bound to get into dispute. However, why it is essential to have a sole arbitrator and not a 3, for a small transaction, you don't want a 3-judge, a 3-member tribunal. It's just going to be a lot of waste of costs. Now, the system is changing. It is, institutional arbitration is coming in. There are, ICADR is there, MCIA has come up, which have sort of tried to streamline the appointment of arbitrators. But my suggestion is, just because it is slightly more cumbersome, you should not incur a massive cost of a 3-member tribunal just because it may be slightly easy to manage when the dispute does not require it.
Mediation you could look at.
Yes, mediation is an option. So, when I was talking about tiered clauses, when I was talking about arbitration clauses, you can also look at tiered clauses, which means that, you say there is negotiation, there is mediation. A lot of disputes can be settled and should be settled in negotiation or mediation, especially the smaller ones. Because a lot of times it's just about managing egos, managing personalities, and just being a little more, having a conversation. Most people who do mediation say that the real discussion happens at 4 o'clock when people are tired and they're just ready to, like we are having a session.
So I would just add to that, Vivek.
It is 4 o'clock.
There has been a lot of changes. I mean, the amendment in the Arbitration Act, and of course, there are some crucial area where clarity, judicial pronouncements are still awaited, like seat of arbitration and foreign awards in which enforcement. So these are still to be clarified by the highest court of the country, and we are still waiting for those clarifications to be given. But there has been a lot of changes. I mean, the Arbitration Act has seen, again, I mean, the amendment of 2015 was a landmark amendment in the Arbitration Act. And the Indian government is trying to make it at par with the other jurisdictions. And over a period of time, we will see the changes. And a lot of institutional arbitrations coming up now, centers coming up, So these are the, MCIA, the recent establishment, and we have almost high courts, like Delhi High Court has its own arbitration center. So as far as the choosing of arbitrator, as Vivek has rightly said, that it's very important that how do you choose your arbitrator to resolve your dispute. So that is very important, looking at the kind of dispute you can foresee out of a contract. How do you see what kind of arbitration you will like to put into the agreement? That's very important. That has to be visualized. Again, the role of the in-house counsel comes in as to how you visualize the future disputes. But it has some pitfalls also. I would say that sometime or the other, we do feel like that for some small vendors, we keep it that, the sole arbitrator as may be decided by the managing director of the company. So it becomes virtually an arbitration between a lion and the lamb. So that those also should be avoided at some point of time. So these are the changes which we have seen, and going forward, hopefully we will see more changes and more judicial clarity in the, kind of confusions or the clarity where we really require.
If I get back to, thanks, Pulan. If I get back to the second question, I think what is very, very important is that you need to manage your client, which is the business, them, and bring them up to speed on the realities. Because sometimes businesses take a very cavalier attitude towards things, and they're like, we are doing so well, and what are you doing? Every time we come to you, we just get a no, and there is always a problem that you find out, but you point out. But it is very, very important that they realize that there is a regulated environment. There is an environment which has a lot of external factors, and which are what they are.
And also, since we have a distinguished parliamentarian with us, Mr. Salman Khurshid, he is an eminent jurist also, we would request that please see some in-house counsels are also given an opportunity to stand with the lawyers. This has been a long pending demand. So if you can voice for us as an in-house counsel that, there is some amendment made in the Advocates Act, and we are also allowed to stand in the court to represent our own company, not other clients. So this is what has been, voiced amongst the community quite often, but there is no representation of the voice. We don't have the strong voice to communicate. So if somebody can be can give us the voice to represent us, we are not only doing good things, we are also, contributing quite a lot to attract the foreign investments. It is not only the policies, but we sell the policy to the world. We go to the world community and tell them that look how we are open for that. So give us some opportunities, sir. Give us some representation. Give us some voice, sir. That I would request. Thank you.
Certainly, but get ready for more strikes then.
Well, thank you very much. You have just witnessed a moderator's dream. The panel was passing the questions back and forth without any awkward silences. I will try to involve the floor now as well. Are there any questions from the audience? Yes, over there in the back, please.
Good evening, everyone. This is Nakul Sachdeva from Karanjawala and Company. In today's evolving world, would it be correct to say that for a corporate counsel, it's more necessary to know the business than to know the law? So the business that the corporate counsel is involved with, it's more necessary for him to know the business than to know the law in general.
Both. What was the last you said? Business and?
Or the law.
Business and the law.
And the law. So what's more important?
For a corporate counsel.
For a corporate counsel, it's more important now to know his business than to actually know the law. I would invite the panel.
No, it's both. It's both. Actually, what I have been emphasizing all along that, being in-house, you know the facts better, you know the deal better, you know the investment better, you know the context better. And then when you brief your lawyer, the external counsels, if you have the knowledge of the law as well, then that logic putting it in a logical way, and you have a threshold, you cannot go beyond a certain line. So when you do and present it in the platter to your lawyer for arguing in the court of law or before the arbitrator, you are in a best position to explain the things. So it's question of partnership between the external counsel and the in-house counsel. It's not that you master in law and you don't master in the facts and circumstances. Even what happens, facts have to be understood in a right perspective, then only you apply the law. So therefore the importance assumes when you know both. I don't say that you be a master of the law, but yes, you should have the knowledge of the law at least. You know what is lying where and how it is to be interpreted.
You can't act, in today's world, you can't act as an impediment to business. You have to be a partner to the business, and you have to know what they're looking for.
Yeah,
business will come to know with the business will come to you for a solution. Whether you it's up to you whether, how do you want to devise a strategy, to overcome that, if there's an impediment. But the fact is that at the end of the day, if they are the revenue earners, hardcore revenue earners, they will look towards you for a solution and not otherwise. So within the parameters of law.
So major expectation from the general counsel is to identify the risk. How do you identify the risk unless and until you are aware of the regulations, rules, laws, what is applicable to your business? So when you identify, this is the expectation from you to identify the risk and mitigate too. That is how you advise to the business to take the business forward. So that is what is expected. You have to be a solution oriented, you have to keep that approach. Then only you can advise the management properly, to do the business in a compliant manner. And the compliance is assuming very important role in the organization, because you cannot be setting aside the compliance part of it and then just do the business. Gone are the days. So that is not available now. So you have to make a balance between the two. So knowing law, as well as, you are the custodian of the business, you know better business than anybody else know. So these are the two things which has to go together.
Thank you. Well, you asked a tricky question. You clearly got a lawyer's answer to that. Any other questions from the floor? Not at this time. Did you want to comment on, because I saw you reaching for the microphone?
Yes, so since there's... I think from an external counsel's perspective and the way I see it, the general counsel or the in-house counsel needs to know the business and the law very well. And I'll tell you sort of a war story. I was, long back, I was doing a market fee dispute for an FMCG company in India. So the general counsel asked me to talk to one of the business guys because there was a transaction which had to take place and it had the similar facts as the one which was under dispute. So this assistant manager who was based in based in a small town came to me. And as most litigation lawyers at the bar, you sit with that stiff neck. Within 5 minutes, I realized he knew every legal provision that was to know related to his business transaction. And he was a business guy. He was not, an assistant manager of law. So I can imagine when business comes to people like Tushar or Pulin, they already know the law. They want him to give a solution, so he needs to know the law very well, but he needs to know the businesses as well. And at the same time, he needs to know the business and the law, because they want something more than that.
So I would also share on a lighter note that one instance in my life, in initial days of my career, when I was looking after the legal department of a big group I would not name, and the chairman had a lot of properties in the city. I used to look after his property tax cases. So he would assign me a file and ask me to go to a lawyer. And I'll come out of his office and go straight to the accounts department and ask for the details of the fee bills of the lawyer and whatever has been paid so far. Then I would be asked by the chairman of the company that why you are going to the accounts department to take the details. I said half of the time I'll be discussing about his spending bills and the payments. So the case would be discussed just 15 minutes, so I have to take this statement. So that is how we had started. But now things have changed. And as Naresh has said in the previous session, that budget is also given to the lawyer, that look, we have this much of budget, you have to work in that, within that budget, and we have to also deliver within that budget. Everything is budgeted at the beginning of the year, that what could be the legal cost and all. If it goes beyond that, then we had to, really bleed through nose to explain the management. So that is how. So I have seen those days where, 45 minutes in 1 hour I had to, settle about the previous pending bills of the lawyer, and 15 minutes case discussion. So that is how we have worked. Now it is given the, first thing in the discussion is giving this is the budget we have to deliver within that. So a lot of changes have happened, and I foresee a lot of changes will happen going forward.
All right, thank you very much. Any questions, any comments on that from the floor? I'm trying to find the organizers in terms of the timing, whether we have more time. I think we overran this morning a little bit. So I'm looking at my watch now, it's 4:15. So I would say we wrap this up for now. We have made up for quite a bit of time. You survived the after lunch session. Thank you for staying awake. Thanks to our panelists, of course, who made you stay awake for their very interesting and insightful presentations. And I'd like to ask you to give a round of applause to them. Thank you very much.
ये लो ना।
I request everyone to please take their seats. We're starting with session 4. Kindly take your seats. I request the esteemed panel to kindly approach the stage. So we're commencing with session 4, and the theme of the session is Bilateral Investment Treaties, Balancing Commercial with National Interest. And it's a matter of great honor to welcome Honorable Justice Vibhu Bhakru of the Delhi High Court, who will be chairing the session. Welcome, sir. The speakers are Mr. Gaurav Banerjee, Senior Advocate, former Additional Solicitor General of India, Ms. Rohini Roy, Chief of Legal Operations, Bharat Heavy Electricals Limited, Mr. George Pothin, Consultant, Ministry of External Affairs of India, Ms. Olga Boltenko, CMS Hong Kong. I now request the Chairman to kindly commence the session.
Good evening, ladies and gentlemen. Well, you know, the topic today is bilateral investment treaties, balancing commercial and national interest. Contrary to what this sounds, it's not as if the commercial interests are absolutely opposed to national interest. It's more like a subset that one would look at. Commercial interests are a part of the national interest. And of course, it is for each nation of what their commercial interests, so far as it's slightly different from national interests are concerned, would depend on what stage of economy and how badly do you need investment. If you look at it from India's perspective, where we are plagued with a large percentage of unemployment, then obviously the foreign direct investment which all bilateral treaties really seek to attract mean a lot more than perhaps what it would have meant in some of the other developed countries. With over 40% unemployment, a foreign direct investment actually means employment to people. And therefore, when you look at commercial interests from the perspective of what bilateral treaties bring and weigh that with the national interests, there isn't too much of difference between the two. It is a part of national interest to have our commercial interests brought up, and bilateral treaties are really essentially to be looked in that perspective. But perhaps today the subtle differences between where national interests and perhaps commercial interests might be in some conflict. I'm sure we have had, India is having a lot of bit arbitrations, and as you're all aware, we have been, India is probably the most in most actions the respondent in the year 2015 and 16. And we have Mr. Gaurav Banerjee, who's defending India in some of them. So I'll request him to start first.
Could I just stand there? It might just be easier. Lawyers think better on their feet, unlike judges. In fact, I wanted to start off on a sort of historical and personal note, because I see there are quite a few people of a different generation sitting in the rear portion of the hall. When I started doing arbitration, I really had no clue as to what this creature called BIT was. And even now, I think I meet a lot of people, and you mention bilateral investment treaties, you mention them to bureaucrats, you mention them to ministers, politicians, judges, lawyers, and I find it, and the reality is not many people know about this. And let me give you a parallel. If you think of domestic arbitration as a small pond with fish, and you think of international arbitration as a sea with sharks, I would think BIT is an ocean with killer whales. It's a completely different beast. The word arbitration here is very misleading, because to be a competent BIT specialist, you need to understand public international law, you need to understand treaty law, and you need to understand arbitration. And I think that's one aspect. If any of you want to go into it, that's one aspect you have to consider. The second thing is that it's not as prolific as international commercial arbitration, and yet for India it has become very important. And the topic, at least from the Indian perspective, is very important, because this balance between national and commercial interest has become absolutely stark when it comes to India. And I just want to tell you a little bit about the history of how India as a country has dealt with this. So our first BIT was in 94, and between 94 and 2003 we signed about 50 odd BITs. It was all done by, I believe, the Ministry of Commerce, Ministry of Industry. Lawyers were really not in the picture, the MEA was not in the picture. It was thought this was a good thing, it was a good photo opportunity, it would bring in FDI. The first time this issue came to the forefront was in the Dabhol matter. I was involved in some capacity in the Dabhol matter. But I don't know how many of you know about it, but essentially what happened was that the Dabhol power plant, there was a problem with the PPA. The price which was negotiated was said to be high, it became political, there were lots of litigation, the Mauritius Treaty was invoked, expropriation was invoked, and there was a huge claim. But it didn't come into the public eye because, surprise, surprise, the government settled the matter. In 2006, UPA won, government settled the matter. We all forgot about BITs. possibly a very good solution. Then comes white industries. How many of you have not heard of white industries? Or how many of you have heard of white industries? Can I ask the question? Anybody knows about white industries? No, right. This is what I call India's Penn Station moment. It was a very small dispute in commercial terms. It was a dispute of $4 or $5 million. It was a commercial dispute with Coal India and White Australia. There was an ICC award. The ICC award came sometime in, if I remember correctly, sometime in 2002. And obviously Coal India, being a public sector, challenged it in Calcutta. White Industries came to Delhi. Matter languished in the Supreme Court for about 5 years. White Industries then had the brilliant idea of engaging the Indo-Australian BIT. And I'm sure you know what the result was. And it was something which was a real shock in 2011 when India lost the matter. But, and there are many things which Mr. Salman Khurshid will be able to tell you about White Industries, but no? Okay, no. Right. But the reality is, and this is very important, the finding was effectively against the Supreme Court. And the finding was that our Supreme Court delayed the matter by 5 years. Interestingly, the reason it was delayed by 5 years by the Supreme Court was it was tagged to the Balco matter, which I'm sure you've heard of. And Balco was decided in 2012, just after the award. So perhaps had Balco been decided 2 years ago, we would have never had a White Industries. But I say excellent result in White Industries, small award, India's Penn Station moment when everybody came to understand or hear about BITs. And people woke up, investors woke up, and to some extent the Indian government woke up. Today we have 22 pending claims, subject to correction by Mr. Pothan. There are 22 pending claims against the government of India. On the topic, sometime in 2015, so what was the reaction of the government when White came? So the reaction of the government was in 2015 they came up with a draft model BIT, which actually was not a BIT. It was basically sign this document because this only protects the national interest, forget any other commercial interest. There was a Law Commission report, 260th Law Commission report. There was an expert committee. I was party to it. They rejigged the BIT and they now have a model BIT. The government of India today has terminated 56 BITs. That's the stand of the government of India. 56 BITs, and I've got the list beginning from the Indo-UK BIT, have been terminated. It seems that the present government and some people perceive, and I think Mr. Vishwanathan's written an article on it, that we shouldn't have BITs at all. It's a debatable proposition. Whether that helps in bringing in foreign investment or not, debatable proposition. But what you need to know is that despite this termination of these 56 BITs, they all have sunset clauses. Today, as an investor into India for a foreign party, you must look at the BIT implications. One international arbitration gives rise to one commercial arbitration and two BITs, inevitably. So that is so far as the investor is concerned. So far as the bureaucracy and indeed the judiciary is concerned, there is a massive need for education. People don't know of consequences of delaying some matters. People do not realize the consequences of, some of the 2G matters are now all gone to the BIT sphere. Some of the coal matters, coal cancellations have gone to the BIT sphere. Vodafone and other matters have also ended up in BITs. Each of these claims are in excess of 1 billion, 500 million, 6 billion. So I think you will see some massive awards in the not too distant future. I think the government, the bureaucracy, needs education, training, knowledge. This is not simply arbitration. And investors have already cottoned on to the fact, and we need to respond. Thank you.
Quite informative. But if you really look at the topic when we say a balance between commercial interests and national interests, it would be essential to find out what exactly are the national interests we're looking at. Mr. Banerjee, of course, gave us an overview of the number of what's the history of BIT as far as India is concerned, and the exposure that this country has in now 22 notices that have, I'm not sure whether all of them have commenced, but there are 22 notices, and few of them I think are already underway before arbitral forums. But what would be essential to look at it is how those came about. Ultimately, what is it that this country did, or what is it that the investors felt sort of betrayed the understanding that they had on which they came to India. Vodafone, I believe we all know, is for expropriation, because they allege that there is expropriation. But apart from expropriation, there would be other contexts in which these claims have been made, and I'm sure Mr. Pothan may be able to dilate on that a little in a while. And he would be in the best position to do so as far as what are the conflicting interests. But just throwing it open for another perspective. For example, in one cases where we think that it came directly in conflict would be perhaps the case of Uruguay, Philip Morris versus Uruguay, where Uruguay banned and bought tobacco legislations. And they had, you couldn't market, you couldn't smoke it in some places. And Philip Morris said that was really taking away from the basis on which they invested into that country. And of course, a tribunal ruled in 2016 in favor of Uruguay, because that was one case where you had public interest directly in conflict with the commercial interest of an entity. And in the face of such larger interests, it was ruled that when such large interests come, a state would always have the power to regulate and rule and make legislations in larger public interest. Now that's one place where it was in conflict, now that you look in hindsight, probably it's a no-brainer that a tribunal would have come to the decision that it did. But as far as the other contexts are concerned, other than expropriation, I just would request Mr. Pothan to dilate on this and let us have an insight on what really are the rival claims, or nature of rival claims. I'm sure they're confidential, some of them.
Good afternoon. Now, on a brief history, the first BIT which India signed was in 1994. But the first ever BIT signed was in 1959 between Pakistan and Germany. When you look at India, perhaps what we've got to understand, the first ever model BIT given to the Indian government was in 1976 by the UK government, when India responded to the UK government saying that investments from UK are protected according to our local legislations, and there is no need for a bilateral investment treaty. There's no need for additional protection under this. Perhaps, as we all know, India was in the fear that East India Company came in as traders and then the British Empire set in. But ironical as it may be, the first treaty was with UK. And today, at a time when there's a debate going on as to whether the UK has to pay reparations, whether can we really take the East India Company to an appropriate forum. And again, going back to UK, out of the 22 claims, 6 out of the 24, that's more than 1/4 of the claims are under the India-UK BIT. It was spoken of in the morning, and white industries is something that we've heard over and over again. But I've not heard many of them speak about another recent award which went against India, the Devas, in the Antrix Devas case. As we all know, that's one of the cases where you had, so I was just mentioning, you had a commercial arbitration and 2 parallel investment treaty arbitration. The company actually takes you to arbitration, and when that particular arbitration gets delayed, there are shareholders from two different countries, one from Germany and another set of shareholders from Mauritius, who bring in subsequent investment treaty arbitrations. And today we've actually, on the face of it, though these awards are still pending before the courts, the relevant courts, what we see is one commercial award where you have to pay the company a certain sum of amount, and on another side, you're actually another subsequent award under the BIT where the shareholders have been asked to, where the government has been asked to compensate the shareholders for unilateral termination of an agreement. It is important to take note of the context in which BITs were actually signed. If you look at it, India's early BITs, or the first ever BIT, was between Germany and Pakistan. The developed countries were actually looking at protection in the developing countries for their investments. That's why terms like expropriation, fair and equitable treatment, the first generation treaties, you look, that provisions are quite broad. You look at India's initial treaties, UK, Netherlands, Germany, Italy, it is more about the inbound capital. Are we still one of the major capital exporting countries? A while ago, I just had a look at the statistics, the data available in the RBI, on the RBI website. It says that inbound capital in India is 3,641 INR, whereas as per the data in RBI, the outbound capital has been just 584 billion INR. So, does investment treaty, or are investment treaties still relevant in the context of the 22 BIT claims? If you sum up the claims, in these 22, it's easily over 100 billion US dollars. Is it worth having investment treaties and bring these subsequent claims where the government or taxpayers' money out of the exchequer is paid so as to protect these investments? What we have seen in investment treaty, one of the core aspects is expropriation. The history behind it, the purpose of expropriation was in a different regime where you had autocratic leaders or dictatorships who used to expropriate investments, expropriate assets, were a direct taking over by the state, which over the past decade or past decade and a half, you really do not see it. What we actually see today is a broader interpretation by tribunal as to what constitutes expropriation, which is more in terms of indirect expropriation, which is a web of regulatory and administrative measures started over a period of time, and in a period of time you actually see either the share value, market value of the shares go down, or assets are not performing well, and then you actually bring about a claim dating back to a particular administrative or legislative decision of a particular government. Another bunch of cases that we have seen arises out of the 2G licenses. We heard about it this morning, that when governments enter into treaties, the arms of the government, the arms of the state, the agencies, under international law, like Sir just said, unlike commercial arbitration, BIT arbitration involves public international law, and under public international law, the state involves not just the state assets, but all arms of the state, including the judiciary, the local governments, until unless a specific carve-out is made out in the treaty. 2G license cancellations have resulted in another bunch of claims. The various claims that you've seen, then you've seen is the retrospective taxation, and we've also seen how innovative councils have been to bring about claims of expropriation arising out of criminal investigations by which individuals belonging to a particular company were restrained from traveling abroad or were spent time behind bars, which they attribute to an indirect means of expropriation. What really the investment treaties have done is the dispute resolution clause has allowed private investors, private individuals to bring about a claim against the government against a sovereign state for actions by a sovereign state or any arms of it. Is it really worth it? Australia, for example, in 2013, decided, for a brief time, decided to stop all investment treaty negotiations. And when you talk about investment treaties, it is of two types, either bilateral investment treaties or multilateral. And perhaps what we see today is also an investment chapter in many of the free trade agreements. And subsequently, when Australia decided to go ahead with negotiation certain free trades with a chapter on investment, what Australia had actually decided is subject to no dispute resolution clause under these treaties. Whether investment treaties really attract investments is also debatable. If you look at the US, one of the largest investors in India, India does not have an investment treaty with US. And Sir mentioned that we have terminated, out of the 83 treaties signed, we have terminated 56 of the treaties. And renegotiations have commenced in 20. Renegotiations have commenced in all 57, but in 20 we've had active renegotiations. What we actually see today is a shift in the investment treaty regime. You look, the 90s model, then you had the 2003 model, which was trying to be more explanatory in certain provisions. And then you had the later, the new generation BITs, which is more like the Indian model BIT. But if you look at the Indian model BIT, it is perhaps gone to the extent, it is perhaps a knee-jerk reaction after the White Industries case and the subsequent set of arbitration notices. In the investment treaty regime, what you actually see is that countries have decided to move on to actually balance the sovereign rights. Countries do not actually want to see decisions of their highest judiciary being challenged before an independent tribunal. And tribunal, for that matters, you've seen tribunals, different tribunals have interpreted the same provision in different ways. And there have also been tribunals who have interpreted, two tribunals who have interpreted a similar matter arising out of the same cause of action in two different ways. So how do you look at it? If you look at the Vodafone case itself, I can share with it because it's out and open. There are two investment treaty claims. One under the Netherlands BIT, one under the UK BIT. What do you do if you have two diverse awards in this? How do you go ahead with it? What if in one of the cases it's decided in favor of the government and in other in favor of the investor? Or say for that matter, what if both cases go in favor of one? Do you pay double compensation? Tribunals have not, individual tribunals have not stopped from deciding on cases where there have been parallel arbitrations. The Devas is one of the examples where you actually have two awards, one under the commercial arbitration, one under the investment treaty, and shortly we will have an award under the third arbitration under Germany, which is expected perhaps in the next year, however it goes. So prior to 2014, out of the as per data available, as per statistics available, there were around 2,900 investment treaties, bilateral investment treaties world over by the end of 2014, of which only 19 investment treaties were terminated. Until then, unilateral termination of investment treaties are only 19. In 2016, March 2016, India alone terminated 56 BITs. And over the past couple of years, what we have actually seen is unilateral termination of treaties by various countries. India is not alone in this. What you see is other countries, India, South Africa, Indonesia, Ecuador, Venezuela, Bolivia. The countries usually being affected are the countries where there's an inbound capital, the developing countries. The reason being that when investment treaties, what I earlier mentioned, when investment treaties were actually entered to, it was entered to between two countries or two states at two different levels. You had under most treaties, including India's, one of the states had an upper hand, like I mentioned the earlier Indian BITs. But today, perhaps if India and UK are to enter into a new BIT, it would be two equals sitting across the table and negotiating. Under these circumstances, is is it worth having BITs? Is it worth having claims over 100 billion against a sovereign state and having investment treaties without a balance, without a clear balance, drawing out a clear line between what the powers of a sovereign are and what the commercial interests which are protected here? What we actually need to go, and even in many treaties which have concluded, is to go back to the travel of the treaties, go back and see what parties meant while signing the treaty, what the understanding between parties are. In many treaties, the travel of the treaty is not available. For example, if I'm right, the first ever investment treaty arbitration involved our neighboring country, Pakistan. And it was one of the big arbitration law firms who actually sent the notice. It was a dispute under a contract for which, when they went to the law firm, law firm got back to the particular investor and said there is another method where you can take the state to arbitration under this treaty. And when the notice was actually served on this particular state, the state had to write back to the law firm asking them, could you please share a document under which the claim has been brought? They did not have a claim. Like sir just mentioned, investment treaties over a period of time are something what you call as an opportunity for photo, an opportunity to show something has been done, an opportunity to say we welcome investments, we are creating an environment. What actually needs to be done is look at our internal policies, internal regime, make them investor friendly. As long as investors have no issues or investors are happy with the internal legal regime, nothing's going to stop these investments from coming in. There is no point in compromising on sovereign rights by signing up to these treaties. Thank you.
Well, you've now heard the perspective of a litigant which is facing 22 notices. And and one of the questions which, of course, Mr. Posen put it very sharply, is there a need for a BIT at all? Considering that you would, if you have an internal regime which is investor friendly, then perhaps for a country like India, you may not require to have a SOP like a BIT to attract further infection. But let's hear the industry in perspective. Ms. Roy is from an industry and from PSU, and I'm sure she has the industry perspective to share.
Well, a very good evening. I think I'm taking the liberty to be seated and still run the risk of being called a lawyer. Just to start today's discussion, I think what is important is I do away with the written speech. It doesn't fit here anymore. We have a very distinguished panel, and I think a lot has essentially been said on theory, and I think it's time that we look and delve into what the practice of this potentially powerful dispute resolution mechanism has to offer. Of course, I will start by saying that in most panels, I usually have a minority status as the only woman in the panel. I lost that status to Olga this evening, so I'm claiming under a different minority status today. I perhaps will take the liberty of saying that I am one of the members of this panel who represents the three faces of this disaster, or benefit, as you would like to call it. One such face is the industry face, where I'm also part of the investor who has now started venturing into some of these investments abroad. I will also speak in the capacity of being the investment itself, which is not such a great feeling because you don't want to be looked at as a commodity. But the third and the most important perspective is, I think, the governmental perspective. And since I also represent a little arm of the government of India, it becomes necessary to know what the government thinks of behind these treaties. Of course, I lost that particular minority status to Mr. Butler, but I think that I still have some part of the governmental conscience, which I'm hoping I would be able to exuberate during the course of this discussion. So with that little introduction, I'm going to try and race myself through the various aspects which have troubled me and made me happy as an investor in this very litigious subject now. I think the BIT itself has become a subject of litigation and scrutiny. Before we delve into how the countries have taken it, I think it's important to know where we stand in India and what are the developments that we're looking forward to in this kind of an arena. I think that it suffices to say that one of the key concerns that we have in this heart-to-heart type discussion is whether India really is in a stage where it can conclusively say that it has gone and delved into the BIT sphere. This is something that it troubles me, and at the same time, I do see a lot of work which has happened. It's just that when I speak to my peers in the industry on this subject, I always say, the way I look at it is that if you think education is expensive, you should try ignorance. And I think that sums up where we stand today. While there is a lot of political consciousness, there has been a tremendous strata of development in the area. I think where we essentially lack is to develop the knowledge of the detailed planning of how to execute a BIT arbitration. I represent a sector where this is looked at with a lot of apprehension, is looked at like a luxury, and very often a draconian system which should not be tried. So very often I'm given the choice of trying to opine why a litigation system or the tried and tested methods of arbitration, institutionally especially, because we have ICC with us here, I think it's pertinent to mention that. I'm always confronted with this question, why a BIT as opposed to the normal mechanisms, and I'm saying normal because that's how we look at it. I think the problem today really, if I could sum it up in one phrase, is that innovation is really the need of the hour. I think we have really exhausted all our different machinery of dispute resolution systems. We have spent a large amount on litigation. We have tried and tested this method. We have been exposed to the evils and the advantages. But the industry perspective is important here because we feel that litigation has reached a saturation point, as has arbitration, institutional or ad hoc. One of the lesser tried varieties is actually the BIT, which has not been tried, and perhaps that's why it has not saturated as much. Unfortunately, being the investor in many transactions changes the perspective with which you look and review such policies. So long as you're on the receiving end, it seems important to balance national interest and perhaps tweak a little bit more towards national interest. When you are also the investor, you have that double-layered consciousness of trying to also protect the investment and protect yourself together with the national interest, which is, I think, somewhat a divergent approach, and it doesn't seem to be working as well as we would like it to work. So BIT here is looked at as a very highly innovative tool, but I think the journey has to be more of making it a strategic tool rather than just an innovative tool. Part of that bridging the gap between the two is education. I've always wondered that, you know, all of us, human beings, are always fools for at least 5 minutes in the day. I think wisdom is really not extending that limit of 5 minutes. And that's pretty much where we stand at the moment. I think that it is now time to view this strategic behavior as something which would benefit us as a community, not only of investors, but also the investment itself. We in India are still quite far, in my opinion, from understanding the full scope of bilateral investment treaty arbitrations or the treaty investments itself. We are still dealing with the formative elements of whether or not the protection is enough, or whether or not the cost of national interest is more important and desirable than protecting the outcome itself. And maybe that is the reason why some of the current policies seem very apprehensive in their nature and perhaps not as open door as we would like it to be. The white industries case is specifically significant to us because I think it has changed the way we look at investment treaty arbitrations, and it has changed the way we've modeled these drafts in the past. And now we stand at a very intricate precipice where we are actually trying to balance the national interest more, but despite the protections that the new model treaty gives us, I think one of the major issues where we end up in the dilemma is to actually see where policies, for example, which like the model treaty says that you have to balance and make sure that you exhaust all legal remedies before actually coming into the BIT ambit. I think that it has become a situation of debate for, especially when I talk in the investor capacity, because while that protects the national sentiment, while it protects public policy and perhaps reduces the cost to benefit ratio of entering into these kind of arbitration ambits, there is also an important question as to whether we are being looked at as being too rigid in our approach to really be able to attract. After all, the main aim of the BIT was to encourage FDIs, and I don't know if foreign direct investments, I think they're very related to the economic rationale that we use. But of course, as they say, there is no defined logic to how we derive each of these rationales, because I think logic is like a sword. The minute you submit to it or appeal to it, you've lost the game, you'll perish completely. And I think that's where we are, because at the precipice, we are not able to decide whether having a closed-door approach really protects national interest and whether there is a tricky balance in inviting fervor so that a foreign investor really feels secure. I think where we are worst affected is perhaps as an arm of the government, and in this regime where we are really trying to promote going out and representing ourselves as part of the globalization mechanism, we have also turned investors where we want to invest in foreign economies. Now there comes the altruistic sense of justice, because we do not expect to be treated the same way that we treat investors in our country. And there, the standards are hugely different. When I deal with bilateral investment treaty claims where I am an investor in a foreign government, very often I'm actually looking at rules and regulations which will protect me, which will not submit me to multiple litigation, multiple suits, multiple appeal systems, where very often I'm looking at a government-to-government mutual respect, where I'm treated at par with their economic objectives, where my trade ties is actually far more significant than how much business I owe or how many debts I owe. And unfortunately, we've had this problem when we try to practically operate the BIT as an investor and switch roles. We often get to hear that the foreign governments don't seem to have enough incentive to be able to offer that kind of protection, because they feel that they're not offered the same protection here. So here is one angle which continues to be the most litigious subject. Of course, there are, I think that as in a system in general, the BIT has a large amount of lacuna which is still being trying to bridge. We are still trying to bridge these together and align them with the main purpose why a BIT was really given. Part of that system of lacunas also deal with appeals. I think that the system could have done better with maybe a level of appellate redressal. Currently, this is still in the formation stage. You have a lot of independent member states who have come together and said that we would insist on having an appeal policy so that this is more rational and democratic, and all the beautiful words. But I think that eventually we need to look at a centralized system where even if there is an appellate authority, it has to be vested in one single corpus and not sort of disinvested in so many different bodies with different rules, rationales. So there is a time where India is still at a stage where we are trying to assess what kind of protective clauses the treaty should have to be able to make sure that the cost-benefit ratio and the net profits that we make through foreign direct investments are not disturbed. But at the same time, the world is really looking beyond the scope of the contents of the treaty, and they are looking at a larger perspective of how the treaty has to be enormous enough to be able to have appeals in them, to be able to provide a mechanism which is at the same time rational, logical, and also very fair. And there is, even despite having I think we have tipped the balance a little bit in the fair treatment clauses. Although I think the 2015 legislation has a lot of potential, it has had a number of clauses which I think have deeply benefited the interpretation of the Act itself. We've also had a very sizable expansion of definitions with more precision and clarity on what constitutes an investor, what kind of treatment is fair and equitable treatment. But I do think that maybe it is time finally to have the white industries case put a little behind us and move towards an environment where we would want to be treated the same way when we invest, because in this market of globalization, we're no longer just the recipient country. I think a lot of the BIT debate, when I look at the reasons why India would have followed this approach, I feel that a lot of developing nations seem to consider themselves the recipient of this policy. And when you are at the receiving end, you always would naturally want to protect the national interest more than a commercial interest, because you are more a recipient of investments than being an investor yourself. And when you step into the investor's shoes, there is a big conflict that arises, because then you realize that being a recipient is only one end of that spectrum, and that spectrum is actually very, very large. I think the scope of BITs is very huge to perhaps cover in a 10-minute panel discussion, but for whatever it's worth, eventually what we're looking at is an expansion of horizons, so that intelligence, this thing that we define as intelligence, is a wonderful tool. It's like a 4-stroke engine. You can just make it stop wherever the mole stops, and then you can start afresh. So perhaps it is time to really consider that whether BITs should be looked at not only as an effective tool for trade ties, but I think the approach and the reach of BITs has become colossal. It is no longer a trade-centric legislation. It is no longer an investment-centric protective legislation. I think BITs are being looked at now as a strategic tool, as I mentioned at the beginning of this discussion, to be able to see whether we actually have alternative remedies to arbitration and litigation. One of the major advantages being that in a foreign court, there is a very strong rationale which tells me that as a foreign investor, I wouldn't like to try the foreign court too hard. I don't know the laws. Most of them are not known to us. We operate in countries such as Syria, Yemen. Most of them do not have the kind of codified structure which we look forward to as investors. So I think the time has come to really broaden the definition of intelligence and strategy, and look at the BIT not just as a tool for trade relationships, but also as a very effective and empowering tool to get economic and political supremacy over our contracting. Thank you very much for being so patient.
Well, then now let's hear Ms. Olga on this.
Honorable Justice, co-panelists, dignitaries, friends, it is indeed a daunting task to speak after such dignified speakers. It is even more daunting because I have to speak in Delhi to a predominantly Indian audience, apart from Dr. Nicholas Wiegand, who is from Germany, on India's treaty policy as a foreigner without running the risk of losing credibility. So this is doubly difficult. But I'm encouraged by the fact that I'm not the only female speaker on the panel. So I'll take the liberty and stay seated and look at India's treaty policy from the point of view of our clients, foreign investors, who are looking to invest in India. But before I begin, I'd like to make a little concession. I had a very peculiar, interesting conversation with one of the fellow lawyers at the break who told me that there is no investment arbitration in India. So now two consequences follow from that. The first consequence is that sort of obviates the need for this panel. If there is no investment arbitration in India, then why would we talk about the balance between commercial and national interests in the context of India's investment treaties? But perhaps the most important consequence is that the question begs, is India in denial? Has white industries traumatized India so much by exposing its judicial delays and by sending a bill of 4 million Australian dollars, I believe, to Indian taxpayers, that India is indeed in denial and doesn't want to deal with this issue apart from producing a model BAT which is predominantly state-friendly rather than investor-friendly, and terminating its bilateral investment treaties? And the answer to that question, if I may, is that India is not in denial, but it is looking for the right balance between commercial interest and national interest. And this is where the question begs: what is the balance, and what exactly are we talking about? And perhaps the best way to demonstrate that important aspect of bilateral investment treaties, or any investment treaties in general, is to look at the criticism that is now being leveled at the investor-state dispute settlement mechanism. And one of perhaps the most important criticisms is that the investor-state dispute settlement mechanism that is ingrained in investment treaties causes a phenomenon also known as regulatory chill. And that means that the state, being afraid of this exposure to treaty claims, would refrain from regulating matters of environment, public health, safety, and other matters of national concern, because the state doesn't want to be exposed to having to deal with over 20 treaty claims. Now that's a very important criticism. In the face of it, we see that happen over and over again, in particular in Southeast Asia. For example, about half a year ago, the Philippines President Rodrigo Duterte made an announcement that he was terminating all foreign mining concessions because allegedly they were not in line with the Philippines environmental regulation. So he made this announcement, and on the face of it, it sounded like a noble fight of the state to protect the environment. And then on the other hand, obviously, there were a number of claims launched against the Philippines by foreign miners who were afraid of losing their investments to this particular attack, or green attack, as it is known. But so things are not as easy as they seem when you listen to statements such as Rodrigo Duterte's statements. It's very difficult for a treaty tribunal sitting somewhere in The Hague or in Paris or in London to trigger the liability of the state who's trying to protect its environment, who's, for example, issuing a new environmental regulation that closes down a factory that is sitting somewhere in the river, polluting it and causing gigantic environmental damage. But then at the same time, from the foreign investors' point of view, when you look at the post-expropriation events, you see that the factory was awarded to a domestic investor who just happened to be one of the relatives of regional government who would award licenses to the factory. So these environmental attacks are not a new phenomenon, and they're now known in investment and trade law as the green attacks. And they started a while ago. With me being a Russian lawyer, I should not be proud of that, but they started during the nationalization processes at the early stages of the Soviet Union, where private property was nationalized and then belonged to the state, which prompted a number of treaty claims against commercial claims against the Soviet Union. So there's an issue of resource nationalization, which has become quite an important issue in treaty arbitration. So the question of balancing commercial and national interests is not an easy question. But I'm happy to say that when I was preparing for this panel, I came across a speech by the former Prime Minister, Madame Indira Gandhi, that she delivered in 1972 in Stockholm. at the UN Conference on Human Environment. And that speech provoked tears and applause. She talked for about an hour about the dire environmental situation in India and gave a number of heartbreaking examples. So she concluded her speech by asking really, aren't poverty and need the greatest polluters? So for her, and she was the first person to set the standard for that fine balance between commercial and national interest when it comes to treaty making and investment treaty making in particular. She said that one can't go without another, and that is to echo Honorable Justice's comments. Increasing foreign direct investment is indeed the national interest, but it should be done with the caveat of responsible and sustainable development. And that is done through rebalancing treaty program that allows states their space to regulate matters of environment, public safety, and other matters of public concern within their own territory without running the risk of being exposed to treaty claims. And now, India has launched a search for that balance quite a while ago. And I'm going to give an example of a multilateral treaty to which India has never been a party, but you can see the traces of that treaty in draft multilateral agreements that India is now negotiating, such as the RCEP, the Regional Comprehensive Economic Partnership Agreement. And I now see that I do have slides, so perhaps I should go through India's treaty policy, the way it is seen by foreign investors and our clients who are looking to invest in India. So India has three distinct stages of treaty programs. The first stage started the independence of India in 1947 and lasted until about 1994 when the first treaty with the UK was concluded. So during that time, Indian government and legislature placed emphasis on protecting foreign investment through domestic legislation. So there were no investment treaties at that stage. And then in the 90s, the treaty boom started, and as my honorable speakers already mentioned, that was when, up until 2012, where over 50 or 60 bilateral investment treaties were concluded, starting with the United Kingdom. But those treaties were indeed investor-friendly. And they exposed India quite a bit to the risk of treaty claims, and that is the period for which India is paying now with its 22 notices of dispute. And the cracks in that enthusiasm about bilateral investment treaties started to appear in 2011 with the white industries. And this is when India, there's a seismic shift in Indian treaty policy, and that is when treaty making stopped. And that is when it happened very recently, I believe earlier this year, when India sent termination notices to put an end to 56 bilateral investment treaties. And I believe India also asked the remaining 20 states to issue joint interpretations of certain provisions of the treaties to limit India's exposure to treaty claims. But that doesn't mean, however, that India is rejecting the benefit of investment treaties. India, while terminating bilateral investment treaties, India at the same time is negotiating mega regional free trade agreements, which do contain investment chapters with investor-state dispute settlement mechanisms in it. And one of them is the RCEP agreement. If we could go to the next slide, and the next slide. And the next slide. Here, this is the emergence. If you look at India's position when it comes to RCEP, and I'm speaking under Mr. Porten's control there, we see a clear emergence of a new phenomenon in investment and trade law. And this phenomenon is called the green multilateralism. This is where states, when they're negotiating their multilateral investment treaties, they condition investment protections on sustainable and responsible investment that would protect the environment of the state and allow the state enough regulatory space to regulate matters of environment within their own territory. And if we can go to the next slide, we'll see this example of the Trans-Pacific Partnership Agreement. And I know everybody is going to say that India has never been a party to that, and the Trans-Pacific Partnership Agreement has been declared dead on the first day of Mr. Trump's presidency. And that is indeed true. But I'm referring to the TPP because it's one of the finest examples of green multilateralism, with substantive and substantial indeed environmental carve-outs that would protect the state and safeguard the state from treaty claims arising out of legislation that negatively affects the investment. So there are three very important provisions in the TPP that can be traced to India's current multilateral treaties. And that's the preamble that states that the purpose of the treaty is indeed to protect the environment in addition to promoting trade. The expropriation provision of the TPP states that if a state adopts measures designed to protect the environment, then those measures cannot constitute expropriation. So those measures are carved out from the expropriation provision of the treaty. And then a very interesting balancing provision that India amended in the RCEP draft that it submitted or discussed in Tokyo just a while ago. If we could go to the next slide, we'll see that this is, and I'm not going to bore you with reading out loud the provisions of India's draft of RCEP and the TPP, but you can see that this provision are almost identical. The only difference, and this might change when the RCEP goes into its final stages and when the text of the treaty is eventually released. But what is important is that when it comes to environmental carve-out from expropriation, India's position is even more robust than any of the other 16 member states of RCEP. Even Russia is not as specific about that environmental provision as India. And if we could go to the next slide, and the next slide. The slide before, that's where you have the provision. Basically, the TPP has a rather balanced provision saying that measures that protect the environment, unless they're otherwise consistent with this chapter, they do not constitute expropriation. Whereas India is saying that nothing in this chapter shall be interpreted to restrict the right of a party, a state party, to formulate, amend, modify its laws. So basically, under the RCEP, the way India sees it, India has carte blanche to adopt any environmental legislation that might affect negatively investment, but that would still not expose India to treaty claims. So that's India's current position. And another very important aspect of India that is also a result of white industries is the modal BAT, to which all of the speakers referred today. And if we go to the next slide, you'll see that the modal BAT has a number of very interesting provisions. It does have the very standard substantive protections, such as protection from expropriation, subrogation, and free movement of capital. What it doesn't have, and this is something that the majority of investment treaties have, and this is something that Rohini is looking for in investment treaties when she invests abroad. The model BAT doesn't have the most favored nations provision, which was the cornerstone of the white industries case. It doesn't have the fair and equitable treatment provision, doesn't have the full protection and security. But what it does have, it has an obligation for a foreign investor to first exhaust local remedies before a foreign investor can even commence investment arbitration against the state. And that goes straight to the heart of Rohini's statement, where she was saying that as a foreign investor, she does not want to be dealing with domestic courts. But this is what the Indian government is suggesting be adopted as India's model bilateral investment treaty. Now, the final point of my presentation is that this model bilateral investment treaty has come under severe criticism both in India and abroad for various reasons. First of all, from the from capital exporting states such as the United Kingdom or Germany, it would be very difficult for them to adopt this model bilateral investment treaty because it does not really accord the substantive protections that the foreign investor would be looking for. So it would be difficult for India to convince those states to adopt the model BAT. For capital importing states, such as Indonesia, for example, or the Philippines, they'd be happy to adopt this treaty. But what about Indian investors who invest in Indonesia, for example? If they do run into an issue with the host state under this model BAT, they would have to go to Indonesian courts, for example. And they would not have the benefit of substantive protections that right now they enjoy under the still existing treaties. And it's not a hypothetical situation, which is something that's in public domain. Reliance Power has invested in 3 coal mines in Indonesia, and you read about it in newspapers, invested quite a lot. And those 3 mining concessions were terminated by Indonesian courts. And Reliance has been involved with Indonesian courts for a long time now, trying to recall the termination notices, and they can't do that. Well, now they do have an option to sue Indonesia and try and recover the investment under the Indonesia BAT, which is now terminated. Not India this time. So Indonesia terminated, but not India. But still, there's a sunset provision, so Reliance can do that. But imagine there was no treaty like that. It would be very difficult for Reliance, an Indian investor, to recover that investment. So if we go to the last slide, there are a number of, there's this question of balance between commercial and national interest in treaty making is so multifaceted that it's very difficult to determine, even from investors' point of view, whether India has reached that balance. But it's really hard to say given the latest developments, including the model BAT and the termination of Indian treaties. So that's still an open question.
Thank you, Olga. I don't think we'll have much time for a discussion since we're already out of time. But just before concluding, I'm sure all of you would have realized this, that much of our debate has actually been colored by the exposure and the awards that can come against in a BIT claim. But a treaty, like any other instrument, is essentially a contract. And it may not be really fair to judge whether you should enter into a contract or you should not enter into a contract based solely on the risks of suffering an exposure for its breach. I think in the end, one has to dwell on what's the promise that you hold out in a bilateral treaty. The white industry case had brought this into a sharp focus. It was not really a treaty between Australia and India. I think they took the benefit of the most favored nation between India and Kuwait. And if anyone was to really look in India, then a delay in execution of an award is endemic. It's said that the travails of a litigant begin once a decree is passed. So it was nothing different. And if a promise that you would have you would have a recourse to recovery of a award expeditiously was made, then obviously it was something the system couldn't handle. So really, it must boil down to what is the honest representation that this country or any other country can make, and that would really determine whether it is worthwhile making that representation or not, and not the risk of exposure alone. That may be one of the benefits, as like Rohini said, it would be a cost and benefit analysis. And in that, of course, this would be a cost. The risk would always be a cost. And of course, I'm sure we're very grateful to Olga to have brought that out in some details. And that's food for thought for all of us. And I would just thank you all for this at this stage.
I request the gathering to please proceed for the coffee break. kindly take your seats. I request the Honorable Chairman and the speakers to kindly take their seats on the podium. The theme for the final session for the day is India's rise as a global hub for quick, cost-effective dispute resolution. The session is being chaired by Honorable Justice B.N. Sri Krishna, former Judge of the Supreme Court of India, Chairman of the High-Level Committee on Institutionalization of Arbitration Mechanism in India. Welcome, sir. The speakers are Mr. Sameer Jain, Managing Partner, Pamises Law Chambers, Mr. Vijendra Pratap Singh, Partner, AZB and Partners, Mr. Atul Sharma, Managing Partner, Link Legal Law Offices. I request the Honorable Chairman to kindly commence the session.
Thank you. Thank you, friends. The last session of the day is usually the time when everybody is tired and the numbers dwindle, enthusiasm also comes down. Anyway, let's carry on with this. The idea, the theme of the debates, discussion seems to be India as the hub of arbitration, right? Now, hub of arbitration in two senses. One is hub of arbitration for all international commercial arbitrations, where parties who have nothing to do with India should be enthused to say, let's go and do it in Delhi or Mumbai or Chennai or wherever in India. Just like today people would say, let's go to Singapore or Kuala Lumpur or Paris or London. And second, all domestic in arbitrations, how can we make sure that they are done in India to the best of interest of the litigating parties? Now, we have eminent panelists here. Now, what is the actual timeline? 5:30 to 9, right? So that gives me an hour and a half. So 30 minutes to each, or let's say 20 minutes to each, and give me a little bit of elbow room in that. Can we start from the left, Mr. Sharma?
Yeah, thank you, Justice Sri Krishna. Well, of course, it's a task because, as you said, that a whole lot of people have kind of tired out. And when we talk of arbitration in the context of, India being a hub, so obviously we are talking in the context of an international scenario. Because if we look at the genesis of why we are discussing arbitration at all, we are discussing it because we have always had a problem on the enforcement side when it comes to foreign judgments. And that's where, the New York Convention and the Geneva Convention provide you a remedy. And I think so, therefore, when we look at these remedies, they're obviously in the context of international parties, that is cross-border parties, and of course substantially in the realm of businesses, because we are not looking at anything which is in the realm of personal disputes. We are looking at disputes which arise out of a business relationship between a domestic and an international party. But having said that, I think what is very critical is to first look a little inward. And of course, the basic question which arises is, does India have the potential? Well, if you ask me from the perspective of raw talent, we certainly have the potential. We have outstanding arbitrators. We have outstanding retired judges who have acted as arbitrators, who have rendered fantastic awards. We have a fantastic pool of lawyers. We also have some basic pool of experts which are required for really making arbitration an effective tool. But in reality, the truth is that we do have the talent, but we really don't have the skills. And that is where we need to up the ante, as they say, and to really bring in an element of training. And therefore, when it comes to talent, we do have the talent, but we don't have the ability to really take it to a level at the moment where we can really say that it is as per international standards when it comes to comfort. Why I use the word comfort is because at the end of the day, the efficacy of any ADR system, particularly in a cross-border situation, is substantially dependent on the credibility of the system, the perception of the system in the minds of everybody who wants to use the system. If you look at the kind of understandings that we have had in the past 10 years or 15 years between the Indian businesses and the foreign businesses, we will realize that a certain element of certainty is attached to certain institutional arbitrations. And therefore, obviously, the obvious question is, do we really also have the infrastructure? I'll come to the infrastructure a little later. But I think what is really significant is that we need to understand that arbitration is a means of really giving the comfort to international business community to have the confidence to come and say that, look, this is a country which can really deliver in terms of not only an award, but a speedier award, but a very good enforcement system. We have in the last 1.5 years taken giant leaps, I would call them, because we had a status quo in terms of the 1996 law. And we have really brought in, and I can say as a practitioner very, very confidently that it is very clearly evident that there is will and willingness amongst the arbitration community, be it arbitrators, be it lawyers, to really push forward this because it has brought a very bad name to us. So, having said that, I think arbitration has become a necessity in the context of what I've said in terms of enforceability of an award, because you don't have the same comfort in an enforcement of a foreign judgment. So, but what is very significant is that what have we done towards really creating the infrastructure and then confidence? Of course, I mean, with due respects to, all the people involved in this process, we have not had a very serious look at this as of now, as until now. The amendment has really brought in a lot of excitement among the community. What is actually required is to really up the skills of the arbitrators, train the arbitrators, get arbitrators who are domain experts, get counsels to accept nominations. If you see the profile, and I must say that we have come across situations where I have personally gone and interviewed arbitrators in an international arbitration, interviewed arbitrators for their fitness for being appointed as an arbitrator. Are we willing to accept that in this country? That is something so critical to really bringing in domain experts and people who know the business, not only from a legal perspective, but also from the business side to really be, part of the tribunal. Well, we all know that in India, arbitration has become a post-4 o'clock activity for the last few years, and that is something which has really hampered the growth of arbitration in India. And therefore, until we really get out of that, we bring in that culture and we make arbitration as a habit. Because the fact remains that we have, now it really pains me sometimes when we fly across to Singapore or to some other jurisdiction, and then we have so much of money wasted. Talent which is available in India is not being utilized. We go and search for arbitrators, in different countries. All that can be very well done within India. Now, there have been a few steps in the last few months, particularly in respect of the Mumbai Center and the revival of ICDAR. But again, how do we need to approach it is a question. Would we continue to treat it like as an adjunct to our court system, or we want to really give it the freedom that it actually requires? Now we have this committee which has been constituted by the Supreme Court for the revival of the ICDR, that the institution which has been set up many, many years ago and never saw the light of the day in the real sense. My suggestion in this regard would be that we really need to look at these institutions in a more structured way. And structured not necessarily from the autonomy perspective, but also from the perspective of really what kind of people you want to train as arbitrators. Now, I give you a simple blueprint for that. If you look at the ICDR revival, I had the benefit of meeting the chairman a little while ago somewhere, and I put in a suggestion that, why don't we have divisions within the center? You can simply have, if you look at the kind of arbitrations that we have been having in this country, you can reasonably divide them into three parts. First is the commercial, which is in shareholder disputes, commodity disputes, and the like, which is very, very broad. The other area which is very significant is the construction disputes, the infrastructure, the construction disputes. And the third has been maybe IT infrastructure. So if we can really have some 3 or 4 or 5 divisions within those institutions, with of course, given that the infrastructure needs to be fully up to the international standards, and that I don't think we need to really debate about, because that's a given. If you can create these and then bring in domain experts. In fact, I have a suggestion like, you can really have construction, the best quantity surveyors to be trained as arbitrators. Royal Institute of Chartered Surveyors has a facility here wherein they're conducting courses in construction law. For example, I'm not kind of espousing anybody's cause, I'm only giving an illustration. Why can't we have 200 people trained as arbitrators in construction law? Similarly, why can't we have domain experts in IT, ITS being trained by somebody like NASSCOM or somebody or whosoever we think is relevant? Similarly, why can't we have some trade bodies train commercial arbitrators? Or maybe people who can really represent you in a commercial arbitration. The other part which I would like to impress upon is, I said that, if you look at the large number of disputes that we encounter in our country, and I'm saying so because it is very significant. Unless you create that culture, and before really thinking international, we should look first inward and see what is our regime today as it exists. Therefore, unless we put our house in order so far as domestic side of the arbitrations is concerned, we will not be able to build that confidence. The other aspect is the contracting regime in a public procurement domain. That is, I think, a very significant part of our ADR process today. If you look at all the government contracts, all procurement, whether it's PPP, non-PPP, EPC, or commercial contracts, it is kind of driven by a certain set of contracts which we have not been able to standardize. We all know that in construction space, we do have, FIDIC available, we have NECA available. We have never made a sincere effort to standardize. I don't want to say it because I've practiced that, or I don't want to go back in terms of time, but sir, you would be knowing that I started practice 40 years ago, and I used to appear in a construction arbitration. We all knew the ground rules. For example, on a claim relating to a restricted turnover or a variation, I would know for a fact that, look, the CPWD regime or the BWD standard contracts prescribe for a certain modality. How will you calculate the price? What is the percentage you will have profits, and what's the percentage of overheads? These guides were all available. We have really messed up all our contracts. Today we don't know whether we are following FIDIC. Today we don't know whether we are following NAC. We don't know what is the contracting regime. There is absolutely no standardization. And the parties are absolutely groping in dark, and they don't know what their rights are. So unless in the public procurement arena, we standardize our contracts, we send a common message across the country that, look, this is what is going to be the contract, the model contract. And that model contract should be followed to the hilt. So we precisely know what the contract is, what the obligations are, how they are to be enforced, what is the arbitration provisions, and we can really give that kind of confidence to the investors. At the end of the day, it's not only a foreign entity who's relevant for the business. When we are talking of making India a hub in the international context, we are also talking of a large number of foreign companies setting up subsidiaries in India. So technically speaking, they are domestic arbitrations. But for all practical purposes, the ownership rests somewhere outside. So that's another very significant message that we need to send to the international business community. We can continue to say ease of doing business and all that, but unless we change our mindset and unless we change the ground rules for these arbitrations at the domestic level, we will not be able to take it to the next level of the international, the comfort of an international business community coming to India and saying, like, this is what we need to be doing. So I think these were the broad points which I thought, sir, I'll make. And of course, subject to what you feel on any clarifications or questions or interjections that anybody might have. Thank you.
Thank you. At the end, we will take any questions if there are. Mindset. Mr. Sharma raised the issue of mindset. Mindset has to change across the board. The people who enter into contracts, the lawyers who advise them, disputes which arise, lawyers who handle the disputes, the arbitrators who decide them, and of course, our fraternity of judges who hear arbitration, challenges to arbitration awards. Across the board, there should be a change in the mindset. Mindset should be that let's put an end to this dispute immediately and not in the manner that we are doing in this country, which led to the white industries situation. Thank you. Now, Mr. Vijayendra Pratap Singh and his presentation.
Thank you, Judge. So we've had a realistic overview of what's happening here. And maybe that sums up this number of 178. That's what contractual enforcement ranking was in the ease of doing business guidelines or the rankings by the IMF, World Bank. It was easier to enforce a contract in Afghanistan than India. And that says something, which means that all of us can, as lawyers here, can take a pat on our backs and say that we know exactly how to break a contract and ensure that we can drag it on. But is that the impression that we want to leave the world with? And I think the topic for today looks at 4 parts: hub, quick, cost, and effective. And I'm not reading it as cost effective. So let us see what have we done to at least stand out amongst our peers, and how have we tried to move on this journey from incredible India to credible India. Because at the end of the day, that's what we want to be. You can invite money, but money will only stay where it is dealt with properly, it is dealt with honestly, and you have mechanisms to ensure that contracts are effectively enforced. We've had a journey of 18 months, and it's going to be 18 months tomorrow from when the amendment came in. It's going to be interesting to see what happens after 18 months, because that's the first milestone that you have on the new arbitrations that have commenced after the Act has been amended. And that's a time when all these tribunals that have been constituted there just thereafter will run out of time or juice in terms of jurisdiction. And I know for a fact that there are so many firms around in this country which do not want to be the first firm to file for an extension of time. But there is going to be a serious problem there because of the fact that some people may not have completed, for good reasons as well, the entire arbitral process in 18 months. How do we deal with it? I think Judge is taking a look at how to institutionalize arbitration right now. And one important aspect that we could possibly consider is institutional arbitration, where there is already a monitor who minds the process. May be given an exclusion because there is someone who is external to the arbitration process but involved with it and takes a look at how things are happening. That person or that arbitral institution or the registrar of the institution should be given the power to monitor that 18-month timeline and give extensions rather than send it to court. Because our idea of sending everything to court is primarily responsible for the problems that we face. There are 60 matters listed before a judge in the Delhi High Court on any given day. It's not humanly possible to do an effective hearing in all 60. So why not find a tangible, reasonable method by which you will get as much as is required to go there. So your ad hoc will anyway end up there, but at least keep your institutional matters, which are minded and monitored, out of that. And one easy way in which one can possibly look at doing that is possibly invoking the provisions of Section 83 of the Arbitration Act, which allows for the power to give removal of difficulty orders. That is one way in which you can have this come out and be effective from tomorrow, rather than wait for a legislative amendment. We know when the last one, how long the last one took, despite having 2 Law Commission reports, 1 initiative by the ministry. Mr. Khurshid was leading that roadshow as well. So it takes a while to get things to move through Parliament. But on the other hand, the removal of difficulty orders will just take care of it tomorrow, provided that there is consensus on how you're going to exclude people for the purposes of ensuring that the 18-month time limit, when it's breached in the case of institutional arbitration, will not lead to your arbitral tribunals sitting there de facto without jurisdiction. The other problem that I see, which we have a realistic solution to, is a reduced judicial intervention. Why is it important that you have minimal intervention and maximum support? It's one of the cornerstones on which an arbitral regime is built, and that's what makes seats of arbitration popular. If you want to be a hub, that is something that we need to do. Let's look at it from trends that we've seen in the last 18 odd months, and I must confess, maybe I'm an optimist and I see a large time ahead where I can see this translating into reality. I see a lot more permissive or arbitration supportive judgments coming about, and this could be on account of the fact that the Law Commission had indicated that the emergency arbitrator provision should be there. It was dropped from the amendment, but you had someone who was sitting here turn around and look at an emergency arbitrator award and give it the protection and the comfort of a Section 9 order. It doesn't mean that everything that comes from an emergency arbitrator is going to be extended, but courts are being less diffident towards what I would call a private dispute resolution process than they have been in the past. And I think that's a great mindset change. The Chief Justice of India, in his statements in the morning, was clear about that. He says that there is a regime and there is a mindset change, but that needs to translate to the last mile of delivery. Has that translation happened? So we've seen that with Section 9s being given even for emergency arbitrator awards or orders, We've seen that in the context of less permissive judicial intervention with awards. We've had the Cruise City Award that has come about, where they've turned around, and I'm so glad that Justice Bhakru, unfortunately is not here, said what he said in that judgment, which is enforcing contracts is equally a fundamental policy of India. And finally, the bogey of FEMA coming in the way of everyone, and the famous and the go-to defense of all recalcitrant contracting parties in Indian law, has hopefully been buried. Of course, it's seen a resurgence every now and then, but at least for the present round of litigation may have seen an end. The other thing that you see which has come about is how are foreign awards dealt with, or how are awards being dealt with today generally. An interesting trend, at least in respect to foreign awards, and I see this in Justice Dhanuka's judgments in Bombay, and I see it in Justice Muralidhar and Justice Bhakru's judgments here, is if you have lost there are certain consequences. It doesn't mean that you're immediately executing the award, but at least you need to protect the award amount in dispute. Why is that important? With the passage of time in the Indian legal system and the whole churn that takes place, money finds its way out of the award debtors' pockets, and surprisingly in every other pocket other than that of the award holder. So this trend that you see, which is in the form of bank guarantees or deposits. So for instance, the Docomo award was actually secured by 8,400 crores of FDRs. The reason I know that is we went and handed over those FDRs ourselves. We've seen that in Bombay, where we've had the entire amount being secured by way of an FD or a bank guarantee. This ensures that people realize that if they have taken arbitration, they'll have to pay for the consequences in case they lose. And that encourages a culture of trying to figure out, do you really want to fight tooth and nail down to the last man standing? And I think that's a great idea or way forward. The other thing that we've seen is to try and make ourselves a hub. We've made a distinction or a distinct characterization between our awards that come out in India. And I'm glad that Atul mentioned it. Indian subsidiaries of foreign companies are going to be treated as domestic arbitrations. But their foreign parent being involved in the same contract would turn it into an international commercial arbitration. Now, the involvement of a foreign parent as a signatory or a confirming party changes things. Why? Because the Indian law says that we have Make in India awards and Made in India awards. So if you're born here, you're stuck with whatever is here. However, if you're not born here and you've come and arbitrated here, and you've got an award, you will get a fast track. A, you will go to the High Court. B, you will get the matter disposed of within a year. Now that gives you an incentive if you are looking at holding yourself out as a hub, which is going to be a tangible benefit. And that may lead to its own structuring. Whether this distinction should exist is a different question, but it is definitely a step towards making us a hub. That brings me to the next point, which is with respect to being a hub, are we respecting the agreement to arbitrate? And there are two ways in which you respect it. A, you respect the fact that there is a decision to arbitrate, and B, you respect the fact that you've given the decision with respect to the nuts and bolts of arbitration in the hands of an institution, and therefore the decision of the institution will be seen with a certain degree of deference. I think Judge was there in the Shinichi matter, where the standard that he laid down, fortunately has been followed still, and in fact has been followed even more recently, a lot more clearly, because there was a split at that point of time, so it was a 2-1. But that has, the view that you took is now the majority, is not only the majority view, but is the accepted view with respect to how arbitration agreements, especially in the case of a foreign award or foreign arbitration, will be seen. Namely, is there an agreement? Does it contain an arbitration clause? And if it does, then there is no reason not to allow parties to go to arbitration other than 3 limited grounds. One, it is an agreement which is unenforceable, incapable of being performed, is null, void. Other than that, there's nothing else. The good part is courts and the last mile of connectivity, including the NCLT as recently as yesterday, has in fact referred parties in a matter of mind to arbitration, because they said within 2 months, there is an agreement, there is an arbitration agreement, it's contained in an agreement which is not denied. Parties in fact want to go and have set out that they will get all disputes resolved. The NCLT, which has otherwise an exclusive jurisdiction under section 430 of the Act, of the Companies Act, say that I'm keeping my hands off and sending parties to arbitration. The second thing which was interesting in that matter and has been seen as a trend even from the Supreme Court is the deference towards institutional decisions. You see that in the context of the IMAX judgment and even in this one. IMAX was an ICC decision with respect to seat because the seat was not clear. But the decision once made, the Supreme Court said, and Justice Bobde's judgment there, clearly says that if you have decided upon a seat, either in terms of the contract or through an agency that has been empowered in terms of the contract, a court has no business to interfere and give a second look to it. As a result of which, it actually did away with a challenge that was filed in Bombay. And I think that makes us have a realistic chances at becoming a hub. In my matter, which has gone to arbitration, it's an SIAC clause. The NCLT turns around and says that with respect to all the shareholder disputes that have been enumerated, all of these can actually be answered under the shareholders agreement and in arbitration. So that famous bogey of trying to keep people in India and fighting in your own backyard has now more or less started to go and get buried. However, it does take a time, it does take its time, and the issue then comes about as to what are you going to ensure that people put their money where their mouth is? How do you ensure that? I think the amendments try and bring about a realistic cost regime, and that allows for people to really figure out whether they want to put their mouth and voice off grounds which they know are going to lose. And I see that because today we are seeing awards with cost awards coming in, where people are getting compensated for the first time on a real-time basis. In fact, you've given me a cost award where I had about 80% of my costs. I think that's what makes the difference between being just a nation that has the best parentage on your arbitration law, which is what India did. India had the New York Convention as a part of its law. It had the UNCITRAL model law. But an intention and an understanding which was quite different from what either of the two said. Today you actually have the mindset, you have the intention. However, it's up to us to ensure that we carry it, and it's only then that we'll become a hub and not before. And as I said, it's only then that India moves from incredible India to credible India. Thank you.
Thank you, Mr. Singh. Yes, you are right. Ultimately, the bottom line is mindset. Mr. Jain, your presentation, please.
And being the last speaker in the last session makes me feel like a conclusion to a brilliant, lengthy legal opinion, which is short, concise, and covers as to what has already been spoken. So that's what I will do. Thank you, Justice Sri Krishna, Ranish Shekha, Mr. Salman Khurshid, who's my senior and a mentor, Mr. Moses, who has become an advisor over the past few months, my seniors at the bar and the profession, ladies and gentlemen. The undertone of this conference has been very India-centric since the beginning. Though it's an engaging Asia arbitration summit, but the undertone has been India. And I think this session assimilates and concludes as to what most of the speakers have already spoken. In my experience of arbitrating or participating in arbitrations over a period of time, there has been a sea change in the attitude of both the legislature and the government and the courts in terms of a pro-arbitration approach. There used to be a joke on us earlier when there were some interpretations by the courts which were not pro-arbitration or pro-foreign seated arbitrations, that we are having to litigate the arbitration clause that was meant to avoid arbitration. But I think post-Balco, a lot of situations have changed, which I will deal in the later part of this presentation. But before that, why is India important is a very important question. And I will put forth some crude statistics here. Now, the economy of Asia comprises of more than 4 billion people, and which is 60% of the world population. China and India are currently the first and the third largest economies in the world, respectively. And India today is the world's largest exporter of software and IT-related services, amongst others. And the current financial centers of the world is shifting to China and India. that has led to a lot of business being transacted with India, in India, and by Indians. So therefore, there are a lot of commercial disputes which are coming up, where Indians and Indian companies are involved. In fact, the 2015 SIC report very interestingly states that out of all the disputes which have been referred to as SIC, the majority have been Indian companies or the Indian parties. The counter to that, and interestingly, which is I think the core of this session, is the ICC report. In the last 10 years, I think there have been 534 cases where an Indian party is involved. And out of 534, surprisingly only 53 cases had India as a seat. And out of those 53, 31 have been in the last 5 years. Now, this is something to ponder about. With so many Indian parties going to arbitration, why India is not a seat of arbitration? I was attending the Niti Aayog conference last year, and after Make in India and India being the hub for business and FDI investment, a new slogan came up. After Make in India, it came up, Resolve in India. So I think keeping up with that slogan of Resolve in India, I will just conclude and point out, which already has been pointed out, the key changes in the Arbitration Act in the 2015, which talks about majorly about the limitation of time from 12 to 12 months at max 18 months. It also talks about and clarifies the basis on which the award can be really challenged. As Mr. Singh stated, there's a cost optimization in the new amendment, and so on and so forth. So the Act really looks at improving the process of arbitration, which is a welcome change. Though there's a huge debate on the timeline which has been set in the new Act, whether and a lot of people are saying that in a complex arbitration it's really not possible to finish an arbitration in 12 months, especially when the time for that 12 months is starting from the date of reference and not from the date of constitution of the tribunal. So essentially, between the reference and the constitution, you may just spend 3-4 months if there's a dispute in relation to what arbitrator needs to appoint it on the tribunal. So the host that fact, of course, at least there's an intent by the government to expedite the process of arbitration. Now, even before that, the attitude of the judiciary came about with a sea change, and I will just mention 3-4 important judgments. Of course, everyone here is aware of Balco, which brought about the very important change that a foreign-seated arbitration cannot really be, the Part 1 of the Arbitration Act will not be applicable on a foreign-seated arbitration, which has also now been incorporated in the amendment itself, with the exception of few provisions, especially in relation to the interim relief. So you can essentially have an interim relief in a foreign-seated arbitration as per the new amendment, except that Part 1 will not be applicable. Now, in Centro Trade Minerals and Metals, very recently, the court accepted a 2-tier arbitration system. Now, it's very interesting to see that a contract can in itself provide for an appeal to an arbitral award by another arbitral institution, which the Honorable Supreme Court said is not against Indian public policy if the parties have agreed to it, which is such a welcome acceptance to the international practices of arbitration. In chloro control, very interesting to see, while interpreting Section 45 of the Arbitration Act, the court said that non-parties to an arbitration can also be brought in. The concept of parties claiming through and under, they were interpreting the term through and under Section 45. So non-parties to an arbitration can also be made parties to an arbitration. It's also interesting to see that those terms have now also been brought in into Section 8. So I think the difficulty which a lot of litigants and claimants or respondents were facing after Sukanya has now been taken over by the Section 8 amendment. Also, Precall Limited, the Supreme Court went ahead and said that even if the clause in the contract is badly worded, or if you claim that the arbitration agreement is not exactly proper, the intention of parties to arbitrate is clear, and hence even if there's a pathological arbitration clause, it will still be upheld and a reasonable intent of the parties will have to be construed. So these judgments really show that there's an increasing intent to not interfere with the awards of the arbitrators, and there's a great acceptance to the international commercial arbitration awards in the country. Now, why in India can be considered as a hub for arbitration is, to my mind, and we used to debate this quite often in office and with colleagues, that and I think Honorable Chief Justice also stated that India is a land of diversity where people, lots of different kinds of people come here. It's centrally located, to which I think I say that most importantly why India can be a hub for arbitration is that there's a brilliant system of a brilliant quality of lawyers and arbitrators available. Senior at the podium said we have the talent but we don't have the skill. But I think the skill is developing, and it's developed to a large extent. And more than that, there are certainly some lacunas which we have to fulfill, and just point out those lacunas and conclude. We need to have an arbitration bar, most certainly. There have to be lawyers who are exclusively practicing in arbitration. Currently, I think anyone who litigates also arbitrates. It's something which is quite rampant, is acceptable. Why shouldn't it be? But there are jurisdictions where there's an exclusive arbitration bar, so there has to be an accepted arbitration bar. The institutions which are in India have to really come up with the international best practices. Though I think that there's a misconception when I discuss it with people, there's a misconception that an international institution really cannot have an India-seated arbitration. Of course, I think everyone knows here there can be an ICC arbitration in India, or there can be a SIC arbitration in India, or an LCI arbitration in India. Nevertheless, there have to be Indian institutions which needs to come up. The MCI, the latest institution, has very robust rules. The ICADR is being revamped. The Supreme Court of India, the Committee of Judges is really looking into it. So all of that needs to be done. There has to be an ease of access to arbitration practitioners and arbitration arbitrators to India. We think that have been cases wherein foreign arbitrators have been made uncomfortable by unnecessary interferences of the court. So there should be a concept of civil immunity to foreign arbitrators and foreign arbitration practitioners when they come to India. The concept of emergency arbitration has to be embedded under the law is something which I believe will make India as a very favorable jurisdiction for arbitration. And I think someone has stated during the day that in Singapore there's a tax exemption to the fees of the arbitrators and arbitration practitioners, which is a very interesting point. So you need to promote people and the practitioners and the arbitrators to come to India and arbitrate. So with these points taken care of, I think the day is not far when India will become a preferred seat and venue for arbitration, though it is already on the way of becoming that. So I think I'll conclude with that. Thank you.
Thank you, Mr. Jain. I may just say that all the three learned speakers had Delhi High Court in view, Bombay High Court in view, and perhaps some of the other premier high courts like Calcutta or Chennai in view. But don't forget that arbitral awards are challenged before some district judge in some remote area. Yes, if the Commercial Courts Act applies, yes, but Commercial Courts Acts are not applicable everywhere, nor have they been set up everywhere. Now I'll give you a simple illustration. I came across this, and I'm saying this from personal experience. There was an arbitration award, 2-1 award by majority, that the law takes care of it. The matter was argued before in some remote district area in Maharashtra, and the learned judge who heard it, probably I don't blame him because he didn't know the arbitration, the front end of the arbitration from the back end of the act. He came to the conclusion and said, I've looked at both the majority award and the minority award. The minority one really appeals to me. I think that should be the role of the court. I said, okay, now that's it. Then there is no way if you're going to go and argue before such a judge. Now this is what I meant by mind fact. Now if you really want arbitration to succeed and you want India to be an arbitration hub, every person who deals with arbitration, be he an arbitrator, be he a lawyer, be he even a litigant, should understand what is it that's involved in this whole process. The process is, people forget that it is a supplant to the litigative process. It is not merely a supplement that when I retired in 2006 and for the first time I came to Delhi, somebody appointed me as an arbitrator. And I was told by the lawyers, can we not have it every day from 5 to 7 or 5 to 9? I said, are you kidding me? I won't be able to work the whole day and then come here and do it. Or can we have it only on Sundays? I said, no way. The last working hours that I knew as a judge of the Supreme Court was from 10:30 to 4. Not 1 minute less, not 1 minute more. Only from Monday to Friday. Take it or leave it. And then it worked. People got, of course, they grumbled initially and then said, what kind of a arbitrator are you stuck with? And then they had to suffer it. Now this is where it is necessary. Now, it is possible for the arbitrator or arbitral tribunal to put his or its foot down and say, sorry, this is exactly what you should do. I would love to do it. People don't file. My experience is first 8 months are wasted in pleadings. Nobody files the pleadings on time. 3 times adjournments are asked for, reluctantly given. Now, let's say I am a very strict arbitrator and then at the very first day I say, I gave you 8 weeks time, you didn't file it, so I'm shutting you out. Immediately an application will be made, a petition will be presented to the High Court and the judge will say, heavens would not have fallen if some time was given. Now this liberal jurisdiction or jurisdiction of the heart should stop if you want to really go on with arbitration. And finally, this concept of public policy. I don't know where public policy, they said in England, was a wild horse which needs to be kept under control. Who is to keep it under control? Because everything is public policy here. Public policy in the matter of what happened before, what happens during, and what happens post the contract. Now, and I can tell you from my experience, the government of India, which advocates all these highfalutin principles, is itself guilty of not adhering to timelines. I mean, that I used to see even as a judge, that they never file affidavits on time. They keep on asking for a time. They say that so-and-so, the law officer is not present today. He is there somewhere. Now, come on, change your mind. You want to do it seriously, do it seriously. And lawyers are scared that somehow if you accept mediation or arbitration as an ADR, so their earnings will go down. I don't see any reason. If you are charging 50 lakhs for appearing in the court, by all means you are charged 50 lakhs for appearing in the arbitration also. What makes you, whether you do your argument here or there, your fees is standard. Why can't it be done? Why can't it be done even for mediation for that matter? Probably it's less botheration and more money. Now this mindset has to change at all levels. And if mindset changes, then there is a hope. Otherwise, we are always long on statutory enactments, but short on implementation. Take any enactment, 30 days, I have seen the limit of 30 days in several statutes. Not one of them ever fulfilled. Now here, of course, Vijendra is right, 18 months. But I must say one thing, one fallout of this was, it gave me an escape clause. So I, with a clear conscience, say I will not accept any domestic arbitration because I am not able to fulfill your timeline, and I am not going to be answerable to some judge saying, why did you not finish? I am going to charge, what, minus 5% of your fees for every month. Sorry, I don't want this. I would rather keep away. One good thing for me, because it gives me more time to spend with my family. But that may be, see, the point is, ultimately, have we resolved that yes, this needs to be sorted by arbitration? How would I put my heart and soul into arbitration, ensure that this dispute is resolved? Not much of technicalities, not relying on the usual dodges that go around in the courts. If that is done, sure, India will be a hub. India can be a hub for various other things. Why not for arbitration? Thank you, ladies and gentlemen. If you I still have another 15 minutes. Otherwise, I'll have to announce like the airlines and say, हमें प्रसन्नता होती है कि हम 15 minutes पहले खत्म कर दिए. I'm not intending to that. Please, if you have any questions which really touch the issue, we will request the panelists to enlighten us on that. Otherwise, हम 15 minutes पहले खत्म कर देंगे. Yeah. No question. Oh, there is a question. No question means everybody understood or nobody understood. Yes. Who is that? Abhinav, who is that? Mr. Bhushan, are you asking a question? Yes, please. Yes, please, go ahead.
So this big debate about nationalization of arbitration, this debate about an indigenous institution. Now, I come from the ICC, which is headquartered in Paris. I'm also supporting, we're also the knowledge partners for this conference. And I'm an Indian, above everything else. Is the concept of where we will only be able to make India a hub for arbitration if we have Indian institutions, is that, in your view, the correct view? Would we benefit from having the support of foreign arbitral institutions, whether that's the ICC or SIAC or LCIA or MCIA, MCIA being an Indian institution, but the same logic would apply to MCIA when they would be administering foreign seated arbitrations, which they can. So is the theory that we need to have one Indian institution to make India a hub for arbitration correct in your view?
Mr. Bhushan, I will not answer this question. I plead Article 20, Clause 3. No? Because I am currently heading a committee which has to investigate it. And like all judges on pending matters, we don't express opinion. I'd rather have my panelists say something about it.
With your permission, Justice Sri Krishna.
Yes, please.
Well, that's a point which I was actually itching to make. Why do we need to reinvent the wheel? The first thing which I said was upping the skills. Well, we are always, very, very fussy and sticky about, saying that you have sold the conscience of the country because you have chosen to hand over the process to somebody else. Well, there can always be a hybrid, and the hybrid is going to be very, very simple. At the end of the day, when we want to create an institution of international standards, we need certain standards to be understood, certain practices to be implemented, certain processes to be put in place. Why can't we just have 3 institutions in this country? We already have 2 in the pipeline, maybe a third one, maybe a fourth one, where we can really ask all these institutions like the LCIA, the SIAC, who have done it and over and over and over a number of years, to become technical partners. You don't need to sacrifice your autonomy or independence. You can make them technical partners and say that, look, we will enter. You can have a roadshow as a country, as the institutions can have a roadshow that we want you, all of you to come and present to us, that how can really make this institutional arbitration center as of world class. And why can't you give in technical inputs, whether it's in the form of training, whether it's form of formulation of rules, which need to be tweaked, of course, to Indian requirements. Why can't you give us support in terms of, how to improve our infrastructure, what is it that we need? So basically what I'm suggesting is only a technical partner.
I just have a follow-up comment to that. That's a brilliant suggestion, but to my mind, I can't think of any other country in the world, which is today considered as a hub for arbitration, be that London, Paris, Singapore, Hong Kong, etc., who advocates such frivolously that you must use their indigenous arbitration, because in my view, that is the very antithesis of promoting yourself as a hub for arbitration. The moment you become, I think in my view, nationalized about it, the concept of international goes away from there, and the example that I'm talking about are from the leading seats of arbitrations in the world. So we need to address this question. I'm sure Justice Sri Krishna would in his report quite
I will not answer the question, I'll only give a counter example. I'm told, because I am heading a committee appointed by the government, that I must travel only by Air India. You know what it means.
So coming to your question, Abhinav, India is a country obsessed with cost effectiveness. In fact, there's an ad, kitna deti hai, with respect to mileage. The fact is that the day the ICC decides to denominate its fees in rupees, you will see a 3 times jump in the number of arbitrations that come to you. And that's got to do with the fact that the rupee becomes a bit of a challenge on the conversion. On the issue of whether you need a domestic champion, we've tried the domestic champion model. In fact, after Balco, we had this concept of legal tourism where come to India and get interim relief was actually set out as the model. Obviously, that model has been done away with. So the idea here is not to have a domestic champion at the expense of anyone else, but to have a domestic champion for the purposes of at least having that culture of arbitration, because invariably all the seats that you mentioned are also synonymous with one arbitral institution. So the idea of developing such a culture would help in developing an institution which we believe is going to be a quid pro quo. That's the only point.
If you remember in the good old days, Mr. Bhushan, if you remember in the good old days, we used to get only a Fiat car and an ambassador car, right? You are compelled to use the Fiat car and the ambassador car. Well, that kind of, it's difficult to get out. As I said earlier, the bottom line is mindset. Well, friends, any other questions?
Hi. My learned friends, I am a layman, not an advocate. The first question is, if you want to create a arbitration hub, the first point is, as per the matter of experience, the integrity of the arbitrators. In India, it has been seen, people do not want to go for arbitration, they prefer to go to the court. Simply, there is a doubt on the integrity, that is one point. That has to be taken care of first. Second is, the arbitrators, their fees differ from man to man. A former Chief Justice is retired, if he is the arbitrator, his fees was different than the ordinary judge. And thirdly, it has been, I have seen myself, one arbitrator was so strong in his arbitration, he says, next time I will meet in India International Center, I will not meet, I will meet in 5-star hotel, and next hearing will be in Shimla. You have to come to Shimla. So, when you are going or having a dreams which come to reality, you should give weight to these basic facts. Thank you.
All these problems are with ad hoc arbitrations. We are talking of institutional arbitration. The institution doesn't have this courtesy. I can assure you there are still some persons with integrity in this country. Don't be under the impression that everybody in the country is a dishonest person. Maybe the percentage varies depending on the time and the place. But we are now, that is why the government of India has now constituted a high-level committee with me as the chairman, assuming that my integrity is good, to take forward institutional arbitration. The debate which Mr. Bhushan raised and it was answered is pertaining to institutional arbitration. If there is institutional arbitration, it is the institution that monitors it. The institution will make sure that things are done on time, and then they make sure that the timeline is followed. Finally, a word is rendered, and it's enforced by its own method. Maybe you had bad experience. I also have bad experience. Let us share our thinking. That's it. Is there any other question? No. And since I am not required to sing Janagana Mana, we'll stop here.
Kindly join us for dinner at 7:30.